A few technical difficulties this morning, I think.
Good morning, everyone. We just got out of the Democratic caucus, so I'm going to just make sure we have a quorum and let other members join us. I'm going to have 1, 2, 3, 4, 5, 6, 7. We do have a quorum, but I'm going to wait just a couple of minutes to see if others join our meeting.
Yeah, Representative Harnett, there was a problem with getting the invitations in the email this morning. So people might still be sorting through their inboxes for them.
Thank you. I know I got mine and then I got another one at 9:57. So.
Well, that was the only one I got. So.
Right. We don't get enough emails, so I appreciate the. See, I know that Senator Carney is in front of another committee, will not be joining us until later this afternoon.
Representative Harnett, I just wanted to let you know that I'll be here only for about 10 minutes right now, and then I'll be back and forth this morning between meetings. So you'll see me appear and not appear from time to time.
Like a magician. Thank you,
Right.
Senator Sanborn.
Yeah, and Tom, also for me, I'm going to be called out to a work session in state and local sometime later this morning.
Thank you, Representative. Given that we have a very full day, we have 6 public hearings, 2 this morning. So why don't we get underway? Good morning. Welcome to the Joint Standing Committee on Judiciary. The committee is assembled today electronically for the purpose of inviting public comment on proposed legislation. I'm not going to go into too much detail about our new electronic world, but just remember we are on an electronic platform and everything that is being done here is being broadcast over our YouTube channel as well. So everything that you say and everything that you do on camera is available to the universe. It's preferable if you mute your microphones when you're not speaking so we don't hear any background noise. And so we get to remind people 30 times today that they're still on mute. So I also, with respect to people that are here as attendees and members of the committee, please make sure that the name that is in your square identifies who you are. So we don't see Dad's laptop or iPhone 8 or something along those lines. And with that, I would like to introduce the committee, and I'm just going to go on the list as you appear on the participant page. And I will begin with Representative Libby.
Chair, I'm Laura Libby. I am from Auburn. I hail to you from Augusta today, and I represent District 64, which is part of Auburn and all of Minot.
Thank you very much, Representative Libby. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. I am Rena Newell, the Passamaquoddy Tribal Representative.
Thank you, Representative. Representative Warrior.
You didn't come through, Tom.
Representative Poirier, we can't hear you.
Thank you, Mr. Chair. Jennifer Poirier. I represent District 107, which is all of Skowhegan and part of Madison.
Thank you, Representative Angelos. You're on mute.
Good morning.
Representative Evangelos.
You are correct, sir. Good morning, everyone. Representative Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you, Representative. Representative Moriarty.
Good morning, all. Happy sunny Wednesday. I'm Steve Moriarty from Cumberland, representing all of Cumberland and part of Gray.
Thank you, Representative. Senator Sanborn.
Good morning. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And I'll be in and out today with some other meetings that I have to attend as well.
Thank you, Senator. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is Northern Oxford County, in 2 communities in Androscoggin.
Thank you, Senator. Representative Sheehan.
Thanks, Mr. Chair, and good morning, everyone. My name is Erin Sheehan, and I represent House District 12, downtown Biddeford.
Thank you, Representative. Representative Babbage.
Thank you, Mr. Chair. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you, Representative. And Representative Reckitt.
Hi, I'm having wild troubles this morning, but can you hear me?
I can hear you, but you appear to be a cinder block, but that.
Well, that's because I'm because my phone is what's doing the video and it's like crazy.
We can see you, then hear you.
All right.
So if you
I'm
just.
sorry, I'm from District 31, the ocean end of South Portland.
Thank you, Representative. As we've demonstrated very ably, there will be glitches along the way with a new electronic format. So we all need to be patient and keep in the spirit of good humor as much as we can. I just want to talk about the chat function for a while. The chat is probably disabled for attendees. And I want to remind all committee members that the chat is not the way to communicate because it is not part of the legislative record, not record. And when members of the committee want to be recognized in order to ask questions of people that are testifying today, please use your electronic raise hand feature. And if for some reason that is not working, you can raise your real hand. Representative Evangelos, you have a question?
Yes, sir, I do. I wanted to build on the comment you just made. It hasn't become a problem yet, although I've witnessed it happen a couple times. One of the reasons I opposed remote participation in the previous years of my service on the Judiciary Committee was because of the concerns I had around other people that would be in the room with the person who might be testifying or whatever, and it leads to coaching, and we're not sure we're actually hearing from the person. And, you know, I've seen it happen a couple times already this year. So it remains a concern of mine around remote participation. And then when we talked about it with municipalities and things like that, when they go into executive session, it even becomes more of a concern, because how can you execute an executive session when there are people joining in a call that shouldn't be involved? So anyways, I just want to make the chairs cognizant of the fact that although it hasn't been a problem yet, I have witnessed it several times when people were testifying. There was somebody else in the room talking to them and, you know, helping them answer questions and stuff. And I don't think it's appropriate. So I'm glad. I'm also uncomfortable with some of the chat that was going on a couple of weeks ago. So not by any committee members, by the way, but by some of the other people. But anyways, just a concern. Thank you.
Thank you, Representative Evangelos. I appreciate you airing those concerns. We are all trying to navigate this world that none of us expected, and we are all doing the best that we can. We're going to hear 2 bills this morning, and we will deal with those as we would at a regular public hearing. I will first ask for the sponsor to introduce the bill. Then I will ask if there are any co-sponsors who wish to be heard and any other legislators that wish to be heard. We will then hear from people in support of the bill, those against the bill, and those neither for nor against. And the clerk will be promoting you from attendee status to panelist status when it is your turn to testify. On our first bill today, which I have not yet discussed, The sponsor will have an unlimited amount of time to present the bill, but we have, I think, over 15 speakers that wish to testify. I am going to be limiting that testimony to 3 minutes. And at 3 minutes, I will have to ask you to wrap it up as quickly as possible. Please know that the committee members have access to and have had access to your written testimony. And the fact that we limit the amount of time that you can speak does not mean that we will not review and take into account everything that you have submitted. So with that, I will now open the public hearing on LD 320, an act to provide the right to counsel for juveniles and improve due process for juveniles. And I would call on the sponsor, Representative Victoria Morales.
Thank you very much, Representative Harnett. Honorable members of the Judiciary Committee, my name is Victoria Morales. I represent House District 33 in South Portland. And it is really an honor to be with you today to present LD 320, which was LD 1684 last session. It's an act to provide the right to counsel for juveniles and improve due process for juveniles. Juvenile justice reform is the main reason I ran for office in 2018. I started my career as a youth worker in 1997 and am now an attorney who has dedicated much of the last 15 years working to keep kids in school, out of court, and out of prison, and more connected to their communities. I bring this bill to you today because there are holes in our juvenile justice system that this bill would fix. Since our juvenile code was written in the 1970s, there has been a tremendous amount of scientific research about adolescent brain development that shows us that there are better ways than incarceration to teach our kids accountability and responsibility. The more we are able to keep kids out of prison, the more chances they and their communities have of having healthy outcomes. This legislation, as many of you know, is the culmination of several years of work and is a reprise of a bill I sponsored last session, LD 1684. It arose from the collective expertise and wisdom of providers and advocates. It is based on a solid foundation of conclusive research on child development, best practices, and legal principles of fairness and access to justice. Included with my testimony, you will see, is a sign-on letter from more than 20 organizations in support of this legislation, many of which have just this kind of expertise. I believe that legislation is best when it's debated and negotiated by people with varying viewpoints. And so from early 2019 through February of last year, I met with stakeholders to do that. I met with the Department of Health and Human Services, the Department of Corrections, prosecutors, defense attorneys, judges, young people, child development specialists, the judicial branch, the governor's office, and many others. We had robust talks, and I amended the bill to reflect the feedback that I got. With all parties in agreement last year, this committee voted 12-1 in favor of the amended bill. This is the same bill I bring to you today. Unfortunately, the legislature adjourned before the bill could get out of committee, so we are starting over again this year. LD 320 is nearly verbatim the bill that the committee supported last year. I thank those of you who were on this committee and stuck with us, showing great patience while we worked out details with stakeholders. For those new to the committee, I'll briefly describe some of the holes I see in the juvenile justice system and how this bill will fix them. The first is that Maine currently has no minimum age for prosecution of children. LD 320 sets that age at 12. As we all know, the goal of the juvenile code is rehabilitation. Studies show that introducing a child 11 years or younger into the juvenile legal system causes harm and derails that child's path for successful development. 11-year-olds are usually in the 5th or 6th grade. I have a 10-year-old myself. If they are reading at grade level, they are reading books like Matilda or Charlotte's Web. They are moody, they are impulsive, and they are pushing boundaries all the time. The point is that when 11-year-olds act out, they are displaying normal adolescent behavior. And when they act out in ways that are beyond what is normal, we know that something is really going on that's wrong in their home or in their community. And in order to fix the underlying issues, they need help and guidance, not incarceration. The second piece of the bill is that once children are sentenced to Long Creek today for an indeterminate duration, it must be for at least 1 year, and they lose access to attorneys during that year and beyond of incarceration. LD 320 removes the mandatory 1-year minimum sentence from the law and ensures that children have access to an attorney at each step of the process. It also ensures that judges have the discretion to make individualized dispositions for every child. Currently, judicial oversight of a sentence to Long Creek occurs only once a year until a youth reaches age 18, and children are not allowed to have an attorney to represent them in this review. LD 320 would ensure all young people incarcerated in a juvenile facility have an annual review of their plan and placement. It also allows a young person's attorney, if they wish, to petition the court for review of a sentence every 6 months to determine if the commitment is in the child's best interest, and to reevaluate a very important piece of the juvenile code, which is always to make sure that the child is in the least restrictive alternative available. So the questions presented in this bill are really very simple. As policymakers, should we draw a line in the sand to protect our youngest, most vulnerable children from prosecution and incarceration? Should we provide our children with legal counsel and judicial oversight of their commitments to Long Creek, to do everything we can to make sure we are not harming them? I ask you all to join me in answering that yes, we should do that. That is our role as policymakers. Studies show us that we can engage in more appropriate interventions with our children than putting them in prison. These alternatives that keep kids in the community and give them the supports they need will lead to healthier outcomes for the youth, their families, and all of us who live in their communities. Thank you very much, and I'd be happy to answer questions that you all have.
Thank you very much, Representative Morales, and thank you for bringing this bill back to the 130th. I recall all the great discussion that we had in the 129th, and I appreciate you sticking with this very important issue. Before opening it up for questions from the committee, we were joined by Representative Hagan. If you could just introduce yourself to the committee.
Thank you very much, Mr. Chair. Can you hear me?
I can.
Okay, I apologize. I've had been on the phone with IT for 2.5 hours trying to get the Zoom address for this meeting. I am David Hagan. I represent House District 101, Hamden and Newburgh. Thank you.
Thank you very much, Representative Hagan. And I now want to trying to pull up the bill. I apologize. I know that we have a co-sponsor on the committee, and I would like to call on Senator Keim as a co-sponsor. I'm sorry. I want to open it up for questions for Representative Morales first. And Senator Keim, you were the first one with the hand up. Was your hand up to ask a question, or it was? You may proceed, Senator Keim.
Thank you, Mr. Chair. Good morning, Representative Morales. Thank you for bringing this bill. And we've had some discussion on this, and I've had lots of discussion already on this bill with various people, and I look forward to the committee's work today on this and hearing more about everything. But just for clarification, because it's one of the issues that I've heard brought up, you mentioned that this bill is almost verbatim what we had last session, what was our committee amendment that had the 12-to-1 vote. Could you just point out what the difference there is?
The only difference that I'm aware of has to do with a language review, and it happened after the committee vote around, and I believe it's in making sure that, because as you remember, and this committee remembers, we wanted to make sure that judicial review was provided to all the children who are in the custody and care of the Department of Corrections in Long Creek. And since we extend that beyond the 18th birthday to 21, if they have committed an offense prior to their 18th birthday, we wanted to make sure that they had access. And so with the judicial branch and your analyst, that was the only change that I am aware of around the definition to make sure that all those young people have access to the judicial review piece.
Thank you. That's important to note, and I'm sure we'll be working through all of these things. But again, thank you for bringing this. And Mr. Chair, I won't be testifying on this bill. I will just be an active committee participant.
Thank you, Senator. And do you need to continue to be active right now, or are you done with Representative Morales?
I'm done for the moment. Thank you.
Thank you very much, Senator Keim. The next committee member that I see is Representative Laurel Libby. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Representative Morales. The question I have is simply to gain a better understanding of the bill, since I wasn't here last time around. So my question is giving a practical example to understand how the law would impact an actual example. So I come from Auburn, and there was a recent case of an 11-year-old Auburn girl who was charged with attempted murder in the stabbing of her father. So I just wonder if you could lay out for us the potential consequences in a case like that under current law and under proposed law in this bill.
Yeah, thank you very much, Representative Libby. While it is rare that we ever have scenarios like that, we do. And as you recall, well, you didn't recall because you weren't on the committee last session, but we had a discussion around a number of years back. We also had a 10-year-old child who smothered a baby. And so we talked about how does the system handle that, right? And in that situation, that child did end up in the DHHS system. And all reports say that that child is doing well, needed lots of services, because we all recognize that at that young age, right, 11 and under, defense attorneys will tell you and judges will tell you they're not competent to stand trial. So the judicial system and the criminal justice system really just isn't the appropriate place for them. And also when we think about, their needs, and that's largely a huge piece of this bill and what we've learned about adolescent development and brain development and sort of the conditions that young people need to thrive, is that when a child is either experiencing abuse or neglect or exhibiting that behavior themselves, they really are children that need very similar services. And the way the system is set up now, one of those children gets services through treatment and therapy and sort of wraparound services to the family or potential outplacement with DHHS and community services, and the other child goes to prison. And so that's what this bill is trying to fix. And in particular, around the 11-year-old child. And I was very involved in it. Long Creek is in my district. I do care very deeply about it. So I was on the phone almost immediately with DA Robinson in Androscoggin County, with Colin O'Neill at Long Creek, talking at length about that. What was really challenging with that child is we're in COVID. And so she had to quarantine in isolation alone in Long Creek. And she, no one will tell you. And if they do, I'd be shocked in our system that that's the place for that child. Because, we don't know the facts of that case. The fact that that affidavit got out of the father is not something that should happen pre-adjudication of all of the facts. So I think it's a travesty for her. But we do know now, and I can't reveal everything and I don't know everything, but just I've confirmed with defense attorneys and prosecutors and Long Creek that she's not in the system. We got her out as soon as possible. Lots of us made phone calls to try to make sure that would happen. She's with a family member with wraparound supports and a safety plan, which is what should happen. So my pitch with this bill really, and using that example because it's tragic, but it's a good one, is that we don't have to have the period of incarceration as a stopping ground always, because that's how it is now. That's the way the system works, and everybody tries very hard to get them out. And if you don't try hard to get them out, the system in terms of competency hearings takes 60 days to happen. So there's a very long period of time that a young person could potentially languish, particularly at that young age when we know it's harmful. So thank you for that question.
Thank you very much, Representative.
Did you have a follow-up, Representative Libby, or are you all set?
I do not. Thank you very much.
Thank you, Representative Libby. Representative Evangelos.
Thank you, Mr. Chair. We had a couple of questions, and Good morning, Representative Morales, and thank you for bringing the bill forward, and same to you, Senator Kine. How are you today?
Very good. Thank you, Representative.
Were you aware that approximately 20 years ago, a 14-year-old boy was sentenced to 30 years in prison?
No.
Would you be open to a friendly amendment on this bill to increasing the 14 years old to maybe 15?
Well, the way the current bill is that, and so actually this is a great segue, and I will answer that question, but I would like to explain sort of where this bill came from the beginning and where it is today after the work this committee did with stakeholders last session. So we did have a provision in the bill that would, 11 and unders would never be handled by the Department of Corrections, and then B, 12 and 13-year-olds would never go to Long Creek or never be in youth prison. And that was significantly debated, discussed with all stakeholders. The Maine Prosecutors Association supported this bill last session, and we worked this out. There was concern for them around removing Long Creek altogether for 12 and 13-year-olds. So we came to a compromise with this committee, and we, instead of removing the option of incarceration for 12 and 13-year-olds, we included in the bill factors against incarceration, and those factors include age. And so if the young person is of that young age of 12 and 13, that would be a factor for that judge to make that individualized determination for each child. And if the offense committed would have been a misdemeanor offense for an adult, that those really would have been the two pieces that are significantly analyzed at that juncture.
Well, thank you.
I'd be happy to talk more about your friendly amendment. I am of the belief that I think we really need to make some significant change here. I see that there would be a lot of discussion and concern about that, but I'd be happy to talk more about that.
Sure, we can do that at the work session. I just wanted, with the chair's permission, I just wanted to share something with you. May I, Mr. Chair?
Briefly, will it result in a question to the representative?
It's relevant to the bill, just, and it's backs up why I'm supporting the initiative. But last month, I received a phone call from the prison from a boy. He's a man now. It's this 14-year-old boy who's now in his 30s, and then his mom called me. But and you mentioned about the brain development issue. This boy did commit a serious offense, but he's earned a bachelor's degree, perfect 4.0 average, has been a model prisoner, and he's now 7 months to go at the Bullitt unit. And because he committed a violent offense, he's been made ineligible for home confinement. So the mom called me. I did reach out to the commissioner, and so that is why I have these concerns around 14-year-olds. So you would be open to discussing those kind of situations and possibly tweaking the bill a little in work session?
Yes, I would be. I do really value that this bill, we worked together with many stakeholders. And so I would be willing to talk about it for sure, Representative Angelos. But I just say that I do value the process that we went through.
Well, you mentioned the tragic circumstances that it creates in an adolescent's life. And this was pretty tragic to listen to the boy, I'll tell you. Thank you.
Thank you for that.
Thank you, Representative Angelos. Are there other questions for Representative Morales? I see Representative Moriarty.
Thank you, Mr. Chair. Good morning, Representative Morales. I think it might be useful for the members of the committee if you could briefly track for us the chronology and duration of legal representation for a juvenile.
In the bill?
In the bill.
Okay. So I did explain that currently post commitment, there has previously not been access to counsel. And so what the bill does is it provides that once a young person, well, it certainly provides, you're talking about specifically the post-conviction reviews?
Well, no, actually, the onset of the right to counsel and the duration of representation.
Right. So once a young person has a petition for review, which includes consideration of incarceration, which, as we know, is a constitutional issue for adults, they would be provided with access to counsel, and then that counsel would be available to advocate for them. That counsel would continue with them once they have the adjudication to commitment in Long Creek. And so how that would work is currently there are yearly reviews that are built in to the code, and this bill would allow for a petition for a 6 month, only once every 6 months, if the attorney determines that that's necessary, to review the reports of the department, to again go back to the, sort of the mission and the directive of this code, to ensure that we're providing the appropriate services to the young person, to make sure that Long Creek continues to be the least restrictive alternative, and that perhaps there might be a family member available, or there might be, because we know that 50% of the young people who are incarcerated are there because they need care. They're not there because they're a public safety risk. And I learned this after the Children's Law and Policy Task Force that I served on this summer with a number of other senators and representatives. We did a full assessment of Long Creek. And so those numbers are shocking to most people. But that would be a part of that review, is that if there was determined to be a least restrictive alternative for that young person, that could be petitioned upon that judicial review.
All right, thank you then.
Thank you.
Any further questions, Representative?
Not for me at this time, thank you.
Thank you, Representative Moriarty. Are there other questions for Representative Morales from members of the committee? Seeing none, I want to thank you very much, Representative Morales, for bringing this bill forward, and I appreciate your willingness to work with us at the upcoming work session.
Thank you so much.
Thank you very much. Senator Keim, who's the only co-sponsor of the bill, has already indicated she is not testifying today. I do not see anybody on the list, but I do want to make sure, are there any other legislators that are on this call that want to be heard on the bill? Seeing no hands going up, and I did not see any legislators in the attendee room, I will now turn to people testifying in support of the bill, and I will use a list that was provided to me by the committee clerk. And I will remind all folks testifying now moving forward that you will have 3 minutes, and at the end of 3 minutes, I will ask you to wrap up as quickly as possible. And the first person I have is Atlee Riley from Disability Rights Maine.
Good morning. Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is Atlee Riley. I'm a managing attorney at Disability Rights Maine, which is Maine's protection and advocacy agency for people with disabilities. I also served on the Maine Juvenile Justice Assessment and Reinvestment Task Force that Representative Morales mentioned, and that I'm sure you'll be hearing about some today. I'm testifying in support of LD 320 because the vast majority of youth who end up at the deepest end of Maine's juvenile justice system are youth with disabilities. While we recognize that this is a national problem, Maine must confront and address it in multiple ways, and we believe that LD 320 is a good start. As the Protection and Advocacy Agency for people with disabilities in Maine, we have the authority to monitor facilities where people with disabilities live and receive treatment. That includes Long Creek. We conduct monthly monitoring visits to Long Creek, and those have continued virtually during the pandemic. Due to those visits where we communicate directly with youth and our other experiences with youth at Long Creek, we know what these reports have shown, that the majority of youth have, for example, individualized education programs due to disability-related educational needs. Most have received behavioral health services prior to their commitment. A quarter of them came directly from residential programming, indicating a high need for adequate treatment and services. And so the significant overrepresentation of children with disabilities at Long Creek raises serious questions and concerns for us about the failures to provide appropriate services to those youth, to proactively address their needs before they end up in the most costly and potentially for many of the students, the least effective manner in which they can have their needs met. In addition, as reports have known, I checked all the links on this letter last night. They should work. So if you're interested in additional information, feel free to click through. Hopefully they came through in a fashion where you can do that. But we know that incarcerating children is costly. It's counterproductive. We know that juvenile correctional facilities are often unsafe places for youth. And abuse and concerning conditions have been documented nationally and as well as here in Maine. Children with disabilities often become involved in the system when other systems fail to meet their needs. And there's been some well-publicized difficulties and gaps within our children's behavioral health system. And again, there's the information below there. I think some of those things are really being addressed now, but we're just starting to do that. And I think LD 320 is really aligned with those efforts. And so I'm sure that I'm getting closer to out of time than I would like to be. So I'm just going to skip down and hope that you'll take some time to read the rest of the letter. But I do want to highlight.
If you could wrap up, sir, you're just a bit over 3 minutes. Thank you.
Okay, well then I will wrap up. I'm happy to take your questions either now or if you'd like me at the work session, I'm happy to be there. But I would just like to thank Representative Morales for bringing this forward again. And thank you for your consideration. I think it's a very important bill.
Thank you very much. Any questions for Atlee Riley from committee members? Seeing none, thank you very much for your testimony. We look forward to seeing you at a work session.
Thank you.
And just so people can plan their morning, I will call on people one at a time, but I will provide just advance notice of the next 3 people that I'm going to call on, and I will update that as often as I can. And the next person testifying in support of the bill is Jill Ward. Ms. Ward?
Video cued me. Thank you, Representative Harnett, and thank you for having me, committee members. My name is Jill Ward, and I am a resident of South Portland, Maine. I've worked on juvenile justice policy and reform for more than 20 years and currently manage the Maine Center for Juvenile Policy and Law at Maine Law. I also serve as one of the 3 co-chairs of the illustrious Maine Juvenile Justice System Assessment and Reinvestment Task Force that you have heard about and will continue to hear about this morning. And I would note that my testimony represents my personal views only and not the position of Maine Law or the University of Maine system. I submitted, as you heard from Atlee Riley, a more extensive written testimony with links to resources about the harms of incarceration and other details around the policy support for this proposal. But I would like to just lift up for a minute where we are now and why LD 320 deserves your support. For several years, Maine has been moving away from a reliance on incarceration. Numbers of youth involved in the system have been declining, and the number of youth incarcerated at Long Creek is at an all-time low. These efforts have been supported by the task force and the system assessment that you heard about that was conducted by the Center for Children's Law and Policy that was released almost to the date 1 year ago today. This comprehensive report has findings with short, medium, and long-term recommendations to improve policy and practice in Maine's juvenile justice system. Now, since the report was released a year ago, the Department of Corrections, OCFS, the judicial branch, and other system stakeholders have embraced many of the recommendations and worked to implement them, even as we have been dealing with the pandemic. So for example, over the past year, there's been greater cross-agency collaboration to keep youth out of Long Creek. There's been a partnership with the judicial branch, the DOC, MCILS, and the defense bar to provide counsel to committed youth. There's also been increased investment in community-based programs. But there are also recommendations in the report that require legislative action. A key finding of the report was that Maine law, quote, lacks a strong presumption of keeping youth in community and also lacks the limits on use of confinement as a disposition that are common in other state codes. The report calls on Maine to create a process for regular judicial review of commitments and out-of-home placements and to eliminate the mandatory required year of commitment to DOC. It is worth noting that other New England states have no such minimum in their codes. And all of the other New England states have more robust review processes in Maine, more frequency, more players involved to check on how the young person is doing in that placement. The judicial review and representation provisions in this bill will help bring Maine more in line with best practice about how long a child may be incarcerated, who makes that determination, and how often that determination is reviewed. Finally, it includes an important provision to exclude young children from prosecution in juvenile court. These children are better supported by their families, schools, and systems who are more capable of providing a response that is trauma-informed and age-appropriate. LD 320 creates appropriate boundaries around the justice system and justice system involvement and incarceration for very young children and incentivizes the state to provide responses proven to be more effective, less costly, and less harmful. Similar bill, as you all heard, many of you here had approved last session. And
I apologize for interrupting, but I'm going to need you to wrap up if you can.
Yes, I was just on my last sentence. You approved the bill last session, and it had broad support across many stakeholders. And I encourage you to take the opportunity to finish the job that was started on behalf of Maine's children. And I'm happy to take any questions.
Thank you very much for your testimony today. We appreciate your input on this important issue. Are there questions from the committee for Ms. Ward? Seeing none, I will thank you again, and we may want you back for the work session. I hope that will be possible with your schedule.
Absolutely. Thank you very much.
I just want to give a heads up on the next three people that I'm going to call on. The next will be Julia Finn, then Liz Blackwell Moore, and then Mary Bonato. I will now call on Julia Finn. Ms. Finn.
Good morning. Representative Harnett, members of the Joint Standing Committee on Judiciary. I'm Julie Finn, and I represent the judicial branch. And I'm here to testify in favor of LD 320. As you may recall, and as Representative Morales just mentioned, this bill began as LD 1684 in the 129th legislature. The judicial branch at that time presented testimony in favor of the bill, but had some suggested changes. After the public hearing, proponents of the bill worked very hard with stakeholders, which did include representatives of the judicial branch, as has been mentioned this morning, and worked to improve the bill with agreed upon amendments. The amended version of the bill was ultimately nearing completion when things shut down in March of 2020. Ultimately, it was one of the many bills that died upon the adjournment of the 129th. LD 320 is the final or nearly final version of the same piece of legislation. The judicial branch supports this draft and will work to implement the new law should it pass in the 130th. I will refrain from commenting on the specifics of the bill. There are others, some of whom you've already heard from, who will speak eloquently and passionately about the details and the public policy behind the bill. So with that, I will conclude, and thank you for your time.
Thank you very much, Ms. Finn, and you have an extra minute the next time you testify.
I'm going to remember that.
In the bank. I'm now open it up to questions from the committee members, and the first hand that I see up is Representative Reckett. Representative.
Yeah, there's going to be some feed. Let me see if that goes away. No.
You're on two different screens.
Yeah, and I'm on two different devices. It's not crucial. Forget about it.
Okay, once we figure it out, maybe we can get back to you, Representative. But if you could mute both of your devices, that would eliminate the feedback. Thank you. Senator Keim.
Thank you. Ms. Finn, I was just wondering, and maybe someone's going to come behind you with this information, but could you get some information, just how many children end up in the judicial system that, you know, I guess broken down by under 12, and then the 12 to 13 and 14-year-olds as well?
Some of that information we've already provided to Representative Morales and others. The under 12 data, I do have reports on. I can send those to Peggy to distribute to all of you. That was recently updated at the request of the proponents of the bill because we had provided it a year ago. And so it was updated to provide the 2020 numbers. They're very low, of course, like about 8 per year. With the older numbers, there's less of that. It is a small number. We do have data on our website about annual filings, and I could check this quickly, but I believe it's about 100 cases per year total statewide, which is, you know, it is a small number, fortunately, in all parts of the state.
So just to clarify, you said it's about 100 that would be in the age category of 13, 14, and 15, or 12, no, 13, and 14?
That would be total. I actually
okay, include a total of what? What's the age group that's 100?
It's juvenile cases.
Okay.
Juvenile cases. Actually, it's more like 1,000. I'm sorry, I misspoke, but I did open the document that I needed to look at that has data for the past 5 years. It was 1,100 in FY20. That's statewide, and that's under 18, which is the juvenile category. It isn't broken out with respect to age beyond that.
Okay, and then how many end up at Long Creek?
That I don't have. As others have stated, I know that number has been decreasing steadily, especially recently, but I don't have that information right now.
Thank you.
You're welcome.
Ms. Finn, is that information you could make available prior to the work session?
The Long Creek information might be, that would probably come from corrections.
Okay.
I'm not sure whatever other information you might like. I don't know if you want me to try to get juvenile data broken down more by different age groups.
I think that was one of the areas that Senator Keim was inquiring about. So yes, I think that would be helpful.
I believe we can get that. I can provide the 11 and under, and also break it down between 12 and 18.
Thank you very much. Are there other questions from committee members for Ms. Finn? Seeing none, I thank you very much for the committee for testifying today. We appreciate your input on this important piece of legislation. Thank you. The next person to testify will be Liz Blackwell-Moore, followed by Mary Bonato and Megan Sway. Ms. Blackwell-Moore.
Hello, good morning, Chairpersons Carney and Harnett and members of the Judiciary Committee. Thank you for having me today. My name is Liz Blackwell-Moore and I live in Portland, and I'm here in full support of LD 320. For the past 15 years, I've been a public health professional working with communities across Maine to increase the use of best practices and policies to improve behavioral health for young people. The research on brain development overwhelmingly shows that the actual structure and functioning of the brain is shaped by young people's experiences, relationships, and the environments in which they live. This early structure and functioning then provides the foundation for future learning, behavior, and health. This is why in public health, we understand that it is the responsibility of adults in the community to ensure the environments in which young people live and the experiences that they have within systems, including the juvenile justice system, are not harming them, but are instead providing assistance towards thriving. Currently, the juvenile justice system is like a complex maze with many entrances into the maze, but very few out. And LD 320 takes a real common sense approach to reforming the juvenile justice system by reducing entry points in, making the system work better for those in it, and increasing pathways out. First, the bill reduces entry points into the system. We know that over half of young people in juvenile justice systems have experienced incredible amounts of trauma and have been the victims of child abuse and neglect. In Maine alone, 45% of youth who were committed were a part of at least one indicated or substantiated child welfare investigation. While many young people who enter the juvenile justice system may have developed maladaptive behavior because of untreated trauma and behavioral health problems, but a sound response is support with accountability and fixing the gaps in the youth behavioral health, foster care, and child protective systems. The science of brain development and resilience would tell us to go higher, but setting the age at possible incarceration of 12 is a good start. Second, LD 320 goes some distance in creating possible pathways out of the juvenile justice maze through the appointment of counsel and the opportunity for judicial review. Additionally, eliminating the mandatory minimum commitment to confinement for 1 year is critical. Long periods of incarceration for all young people who are committed is not in line with best practices for supporting improvements in young people's behavioral health, or well-being. Regular monitoring and review of individual circumstances and individualized solutions is essential. And it's essential because adolescence is a time of really rapid brain development. All young people, but particularly young people who've experienced a lot of trauma, need opportunities to build resilience in order to become competent, contributing community members, which is really what we all want. And resilience is essential for thriving, but it's created through supportive and safe environments where all young people are free to develop relationships with peers, adults, community members who care about them. And it's built by receiving trauma-informed care, having opportunities to build coping skills, and finding sources of faith, hope, and cultural traditions within community. So brains change and grow.
Ms. Blackwell-Moore, I'm going to have to ask you to wrap it up if you could.
Yes, certainly. So people change and grow, but incarceration cannot provide them with all the opportunities that they need. So having those brief, regular reports and judicial reviews is essential. And we must really, the system, as the state, it's our job really to make sure that we are taking our funds and putting them into the best possible places for enabling youth to thrive. And that's through intensive outpatient and intensive family supports, and not through incarceration. Thank you very much. I'm happy to answer any questions of the committee
Thank
member.
you very much, and thank you for your testimony today on LD 320. Are there members of the committee with questions for Ms. Blackwell-Moore? Representative Moriarty.
Thank you, Mr. Chair. Quickly, Ms. Blackwell-Moore, are you affiliated with a particular organization?
I am a public health consultant working with various communities and organizations and municipalities across Maine on working on public health.
All right, good. Thanks very much.
Thank you, Representative Moriarty. Are there other questions from committee members? Seeing none, thank you very much for your time today. Greatly appreciate your testimony and the written testimony that you submitted as well. Thank you.
Thank you.
We will next hear from Mary Bonato, followed by Maggie Sway, and then Pedro Vasquez. Ms. Bonato, welcome.
Thank you. I'm hoping my video will reconnect at some point. Representative Harnett, distinguished members of the Joint Standing Committee on the Judiciary, good morning. I am very happy to be here in support of LD 320 and very grateful to Representative Morales and the many people who have worked to improve this bill. Just very briefly, GLAD, where I work, is deeply connected to supporting children and families so they can live their lives and make the contributions that they can make in the world. And I want to say that I got a call on a weekend in November 2016 I never expected, which is that a young transgender person at Long Creek had taken their life while in detention there. And I was stunned, and even more so because I had just recently received at GLAD 2 letters from different young gay men who were incarcerated there. So I asked a volunteer at the facility to please connect me with people there so I could understand what was going on. And with what I saw, honestly, there was no option to look away. Most of the young people who I met at Long Creek were members or allies in the, of the LGBTQ community. And I came to know and appreciate these young people as they were trying to manage their confinements. I certainly employed my legal skills on their behalf. But what I saw in them is what I have seen with over 30 years of work with young people, which is their enormous promise and potential, especially when they have genuine opportunities for growth and they have the supports they need and they're not injured and held back by discrimination. And as Ms. Blackwell-Moore was just stating, so many experts see this time in life, adolescence, as a precious opportunity when you can repair and remediate and redirect your brain to even deal with past traumas. And to me, that says we have to be extraordinarily careful when we think about ordering secure confinement. So while GLAD supports all of LD 320, I want to just highlight a few items. One is the 1-year minimum for confinement at a juvenile corrections facility, and the other is the counsel and judicial review provisions that will give young people a voice, not only in how they're treated, but in their life's direction. The young people I worked with each lingered too long. One had no programming at all when I met him and aged out at 21. Another had earned college credits at Long Creek, worked in the laundry, had completed every program, which will be footnoted in my written testimony, but his progress was on hold. And to DOC's credit, when I, as a lawyer, was able to go to DOC with information about his charges and an initial psychiatric assessment of him, they were willing to allow a forensic risk assessment. And eventually he was able to do what he wanted, which was to be able to go to school and to begin to work. And because he was so overdue for community integration. And every young person, we think, deserves that kind of opportunity and that kind of closer look. I also want to note that the Reinvestment Task Force report that Ms. Ward referenced highlights length of stay as an ongoing issue at Long Creek and cites the data about how confinement beyond 3 to 6 months is counterproductive for these young people and therefore counterproductive for our future and our communities. I will not forget the young people I met, and one young person in particular was not so lucky as the other one that I just mentioned, if you can call it luck. This individual I met at age 16 from Aroostook County, and he had an extremely difficult time for his nearly 2 years at Long Creek. He was discharged at 18, and he succeeded in taking his life just a few months later. His is not the only failed placement to come out of Long Creek. And it is why I think young people deserve a voice, deserve fundamental due process and fairness when they are held in confinement, and they deserve a chance to have somebody advocate for them and to advocate for themselves. They are our treasure. They are our future. I urge you to vote ought to pass. Thank you.
Thank you very much, Ms. Bonato. It's nice to see you again. Are there questions from members of the committee for Ms. Bonato? Seeing none, again, thank you very much for being here today. We look forward to working with you in the future on this and other bills of interest to you. Always appreciate your input. The next person to testify is Megan Sway, followed by Pedro Vasquez, Tina Neto, and our last testimony in support by Justin Andros. So, Ms. Sway.
Thank you, Representative Harnett, members of the committee. Good morning. My name is Megan Sway, and I am Policy Director at the ACLU of Maine. On behalf of our members, I'm here to support this legislation this morning. I think others have talked and covered the harms that incarcerating young people can cause, so I won't belabor that. I'll just say that the stakes couldn't be higher. And while the ACLU supports all parts of this bill, I want to focus on some constitutional issues. The first is that, as you've heard, brain development is something that the Supreme Court has actually looked at, and over a few decades has come to the point where they have declared that children are constitutionally different from adults because their brains are literally different from adults, and this makes them less blameworthy and more able to change and grow. This constitutional difference, we believe, allows this committee to draw a line in the sand and say that some kids are so young and their brains are so underdeveloped that our state will not charge them criminally. On the issues of right to counsel and due process, right now under Maine law, there's an annual review of a young person's incarceration until they reach age 18, and the state presents a report to a judge. But the young person is not allowed to have a lawyer at that review. In another section of the code, the law allows the state to ask for a child's length of incarceration to be extended past the original date. And again, under current law, the young person does not have a right to counsel if this happens. This is an issue of basic fairness and one that courts have weighed in on at length over the years. The Supreme Court has held that even though juvenile court is different from adult court in some respects, it's still a basic right for kids to have an attorney if their liberty is at stake, and kids are still entitled to due process. And LD 320 would go a long way towards addressing these issues. Thank you.
Thank you very much, Ms. Sway. Are there questions from members of the committee?
Thank you so much. Have a good day.
Seeing none, thank you again for your testimony. And I will now turn, the next three will be Pedro Vasquez, Tina Neto, and Justin Andros. Mr. Vasquez.
Good
welcome.
morning. Thank you. Good morning, Representative Hartnett, Representative Morales, and the members of the committee. I'm Pedro A. Vasquez. I'm the current chair of the South Portland Human Rights Commission. Professionally, among other things, I represent people with disabilities in administrative law proceedings at the federal level. Many of my clients are children. For centuries, American and English common law has held that children were not legally capable of forming criminal intent. Without the convergence of actus reus and mens rea, a crime has not occurred. Legislators and legislatures across America have largely changed this common law idea that children are unable to formulate criminal intent, and as a result, on any given day, over 60,000 youth are incarcerated in our country. So it is beyond debate, as you've heard, that the human brain does not reach anything resembling full maturity until the early to mid-20s. Therefore, it stands to reason that a child cannot understand the nature and consequences of their actions. The fact remains that children are children. They're not adults. Their brains do not work the same way as an adult's. So if you're looking for evidence of that, ask any parent. Children cannot enlist in the military. Children, indeed adults under 21, cannot legally order a beer. Children cannot enter into contracts, and children cannot make legal decisions for themselves, but they can be charged with crimes. So there's little, if any, evidence to suggest that the current treatment of juveniles in this criminal justice system decreases crime or has any deterrent effect. In fact, what evidence does exist suggests the opposite. Studies show that incarcerating children more often than not results in higher rates of recidivism, and essentially it turns children into hardened criminals. Let's turn to the so-called Long Creek Youth Development Center, a problematic facility here in our city of South Portland. Surely you've heard about the case of the 11-year-old boy who was navigating mental illness and who was brutally beaten by guards there. Despite the absence of any physical threat, the guards entered his cell, bashed his face against a metal bed frame, and knocked out his front teeth. After that attack, they didn't take him to the dentist for 6 days, at which point it was too late to save his teeth. And earlier, someone mentioned the unfortunate passing of the transgender boy who ended his life at Long Creek while on suicide watch. It's been reported that he was upset that he was being housed with girls instead of boys. And so I challenge anyone to demonstrate how Long Creek served to develop either one of those youths. A required court review of determination as LD 320 creates and provides a mechanism that could serve to prevent these types of tragic occurrences. The roles of race and the school to prison pipeline and youth incarceration rates are not the subject of debate among serious individuals. The data is pretty clear. These are factors that persist and cannot be ignored. LD 320 provides a mechanism for us as compassionate members of communities and citizens of the state of Maine to protect our most vulnerable from the trauma and harm inflicted by the lack of protections that exist within the current legal framework. I encourage you to support LD 320. Thank you.
Thank you very much, Mr. Vasquez. The committee certainly appreciates your testimony and your dedication to youth, which is clear in the material you have submitted. Are there questions from the committee for Mr. Vasquez? Again, thank you, sir, and appreciate working with you on this as we move this forward. The next, the final two folks that I have listed in support of the bill are Tina Netto and then Justin Andros, and then we will turn to those folks that are neither for nor against. Ms. Netto, nice to see you again. How are you?
Yes, it's been so long. Thank you, Chair Harnett, and thank you, members of the Judiciary Committee, for hearing me today. My name is Tina Netto. I am a criminal defense attorney who practices in Portland. I've also had the honor of representing juvenile clients on their appeals to the law court and petitions for post-conviction relief. I also worked extensively on this bill in its original and previous iterations, LD 1684. I serve as the executive director of the Maine Association of Criminal Defense Lawyers, and it is in that capacity today that I speak in full enthusiastic support of LD 320. MACDL, of course, supports any legislation and any policy that keep people from coming into contact with the criminal legal system, that divert people away from the criminal legal system, that minimize the harm created by interaction with the criminal legal system, and that reduce the amount of time any person is incarcerated or supervised by our criminal legal system. That goes double for kids. When we prosecute and incarcerate children, we are ensuring a new generation of people who will become our clients. I don't think I'm speaking out of turn for my colleagues when I say that for most of us who practice criminal defense and juvenile law, we sincerely wish that our jobs would become obsolete. We are nowhere near that place now, but this bill is an important step forward in reducing harm to children and reducing recidivism by those who are currently in the system. This bill, I'm going to focus on one part of it, would enshrine in legislation that no child in this juvenile legal system is without counsel at any time, even and especially following the young person's commitment to Long Creek. In September 2019, when the former iteration of this bill was carried over into the short session, I asked the Maine Commission of Indigent Legal Services to adopt a policy that would ensure that a roster of highly qualified and specialized juvenile attorneys would be called together and be appointed to represent each one of the young people who were incarcerated at Long Creek. These attorneys could assist their new clients in pursuing early release, which we soon saw was desperately important in the months of COVID, advocate for appropriate programming, and once implemented, represent the child at judicial reviews of commitment. Having a competent, dedicated attorney is an indispensable tool to ensure that children are afforded the justice to which they are entitled. Although the Commission unanimously voted to implement this policy in September of 2019, the experience of watching this program languish for several months with no action demonstrates to me even more clearly why legislation is necessary here. Mickles, the Commission on Indigent Legal Services, as you all are very well aware, has not always been great at abiding by its own rules and policies. Legislation would mandate that they cannot stray away from this vital obligation to provide counsel for imprisoned children without exception and without delay. As others have indicated, prison harms, it does not and cannot heal. We should also remember that the vast majority of children who become wrapped up in this system are survivors. Maine must continue in its trend of steering juveniles away from the system altogether, away from court, away from incarceration, and toward community-based programs that offer treatment, support, and this bill is an important step along that process. Thank you very much.
Thank you very much, Ms. Neto. Are there questions from members of the committee? And I see a question from Representative Evangelos.
Thank you, Mr. Chair, and hello again, Tina. Thank you for your testimony. In your experience with the empathy and compassion you were showing this client base, can you share with us what you encounter from the prosecution side, whether they're willing to work with you or whether it's a difficult path?
I'm going to try to respond to that question. I think it's a bit, maybe I can respond to a narrow version of it. I know that prosecutors, particularly one prosecutor in particular, has been very, very involved in the evolution of this bill to its current form. I will say there are parts of this bill that are, in my opinion, watered down from the original, but that comes from, bringing everyone in. I think there are very few prosecutors in the state of Maine who are juvenile specific prosecutors. There's a mere handful of them. Most juvenile cases are disposed of by regular assistant district attorney. So, each district attorney sets the policies for their own district, but legislation is important in that it binds the hands of district attorneys so that children are not getting less just because they're in one district or another. So I'm hopeful that prosecutors will join us. I do think they are starting to see very clearly the harm that's caused by overly carceral responses to misbehavior.
And just a quick follow-up, have you had any experiences with manslaughter or homicide cases with the Attorney General's office, and how they, do you have any experience there to share with us?
Very broad question. Yes, I represented people accused of manslaughter and murder before.
I'm talking about youngsters specifically.
Oh, youngsters specifically. I can't really comment on that right now.
Okay, thank you.
Yeah.
Representative Reckett.
Miraculously, I think my system is working again. I was trying to reach you about a problem that has now been rectified.
Oh, okay. And I've just been informed that my list is inaccurate. So I am next seeing no further questions from Ms. Neto. Thank you very much for being here today. I have 3 people still who want to testify in support. The first being Justin Andrus, and then Elizabeth Saxel, Sarah Branch, and let me check the chat, and D.A. Sarbeck as well. So that's 4 more testifying in support, starting with Mr. Andrus. Mr. Andrus, welcome.
Thank you, Chair, Senators, Representatives. I am Justin Andrus. I am the Interim Executive Director at the Maine Commission on Indigent Legal Services. I think the committee members all know me. The Maine Commission on Indigent Legal Services supports this bill in its entirety. We see our mission as to ensure due process to the populations that we serve. And that population includes these minors. I won't revisit all the testimony that you've heard, except to say that I'm aware of many of the things you've heard this morning as well, and fully support the need to address them. This bill is a good start. It's not the end of the road, but it's a good start in that direction. I have been asked whether we can provide data for a fiscal note at this point, and I just want to note that we don't yet have good numbers on how the caseloads are likely to change if the bill is implemented. As you all know as well, I've expressed my concern about meeting additional needs. We don't condition our support for the bill in any way on funding to allow us to engage in this representation. We're going to do that. We're going to provide counsel for these kids. But I would note that to the extent that it results in an increased caseload, we're going to need support there as well. Thank you. If there are questions, I'll address them. And otherwise, that's the briefest I've ever been.
Thank you very much, Mr. Andros, and brevity is appreciated. Are there any questions for Mr. Andros from members of the committee? Seeing none, thank you very much for your testimony and look forward to working with you on this and other matters in the future. The next person that I have testifying in favor and support of the bill, and I have received information in the chat that there's yet another person who wants to testify in favor. But right now we're going to go to Elizabeth Saxel, followed by Sarah Branch, and then D.A. Sarbeck, and then Jan Collins. Ms. Saxel, welcome. Thank you.
Good morning, Senator Carney, Representative Harnett, members of the committee. My name is Elizabeth Ward Saxel. I'm here today on behalf of MICASA, Maine's Sexual Assault Support Centers, and Maine's Children's Advocacy Centers in support of LD 320. There's a fair amount of research related to juveniles who've engaged in sexually harmful behaviors, but what we know about those under 14 or under 12 is more limited. However, we believe there are key findings from the research that will be useful as you consider the bill in front of you today. The research is clear that once detected, most juveniles who have engaged in sexually problematic behaviors do not continue to engage in these behaviors. One key meta-analysis of 63 data sets estimated the recidivism rate at approximately 7% at the 5-year mark. And the research consistently demonstrates the effectiveness of developmentally appropriate assessment and treatment for this population. As part of assessment and treatment, it is critical to understand that this population differs from those committing other kinds of offenses. Although the research demonstrates that many of the underlying risk and protective factors related to juveniles, their peers, their community are parallel, this population differs from those committing other juvenile offenses. Their own sexual victimization, as well as sometimes atypical interests, are a factor that stand out. As a result, it's critical that specialized evidence-based programming continue to be developed for these children in particular. We also know that some policies can result in further harm to these kids, and you've certainly heard a lot about that today, but I'm bringing the sexual assault perspective. ATSA, the preeminent association of professionals engaged in the treatment of those who have committed sexual offenses, writes of sex offender registration and notification for juveniles that such practices are inconsistent with community safety and promotion of pro-social development, and in fact, may elevate a youth's risk by increasing known risk factors for sexual and non-sexual offending, such as social isolation. Though focused on registration and notification, I would suggest that we could continue to consider these impacts with regard to prosecution and incarceration of at least our very youngest and most malleable. I also want to share that, as with all bills, we form this position in collaboration with Maine Sexual Assault Support Centers. And it is also informed by a survey we did in December 2019, which sought to understand the views that victims of sexual violence hold about the juvenile justice system. Of the participants, 50% of survivors interviewed strongly agreed that teaching youth who commit an offense to take responsibility for his or her actions does not require incarceration. One survivor shared that, "I don't like that Long Creek Development Center has been the only option for this population. There has to be ways to find more alternative resources and support for these youths." Another survivor shared, "I think there should be programs in place to help youth in crisis who have hurt others. Incarceration is extreme and sometimes only functions to increase recidivism instead of reforming offenders and making communities safer." These are not researchers, these are survivors of sexual violence. As a result, we support this bill and also look forward to working with the Office of Child and Family Services to learn more about the current and programming planned for therapeutic interventions. Thank you for your consideration.
Thank you very much for your testimony, Ms. Ward Saxel. Are there members of the committee that have questions at this time? Representative Babbage.
Thank you, Mr. Chairman. Ms. Saxel, thank you. I just want to make sure I'm clear on what you were trying to share with us. Can you be precise about, you said recidivism after 5 years is 7% for what specific population?
For the population specifically who have engaged in sexual behaviors that are inappropriate. So
that then become part of the system? Is that what you're saying?
Yes, that have been identified, right? So we know that sexual violence is the most underreported of all the violent crimes. So we can't speak to the whole population. What we can speak to are those juveniles who have been identified as having engaged in some of these behaviors.
Thank you very much.
Yep.
That's good. Thank you, Mr. Chairman.
Thank you. Are there any other questions from committee members? Seeing none, thank you again, Ms. Ward-Saxel. Very nice to see you again, and we appreciate your time.
Thank you for
and
the opportunity.
testimony. The next three speakers in support will be Sarah Branch, followed by D.A. Sarbeck and Jan Collins. Ms. Branch, welcome.
Thank you so very much. Good morning, honorable members of the Judiciary Committee. Thank you so much for the opportunity to speak to you about this very important bill. My name is Sarah Branch. I'm a solo practitioner and I focus my practice on criminal and juvenile defense. Prior to my work in Maine, I was an assistant attorney general in the District of Columbia, and a variety of my tasks there also included prosecuting juveniles. And today I'm a part of that pilot project that was referenced by Attorney Nadeau, where I am actually currently representing committed juveniles at Long Creek. And that's what I'm going to focus my testimony on today, the importance of representation. I'm going to cut right to the chase. We've got 3 minutes and ticking it down, and many people trying to talk. Currently, just so you have context, a child is given a disposition that includes commitment. They go to Long Creek. They no longer have an attorney. If that same child works their programs, he does well, he wins early release and into the community, he gets out into the community and he's following all the rules that are set out for him by his team. If he messes up, small, large, the team could drag him back into Long Creek. There is no judge and there is no defense attorney involved in that decision. This is what is concerning. I'll give you an example. A number of years ago, I got a call at my office, and it was one of my former clients. And I say former because that's important. He was calling from Long Creek. He had, in fact, worked his program. He had, in fact, gotten out into the community. And he was calling incredibly upset because from his perspective, he was brought back into Long Creek for something he didn't do, and it was small. From his perspective, he wanted people to hear him, and he didn't felt heard. His reaction was visceral. He was frustrated. He didn't know what to do, and I felt trapped. There was no rule that provided for my representation at that point. This bill addresses that fact pattern. He was a child. It didn't seem fair. Most children have a compass for what is right. They know when situations aren't fair, and providing them an attorney who counsels them, listens, advocates, and can litigate on their behalf is an empowering relationship for someone who may feel completely powerless in their cell, and gives them investment into their rehabilitation. To be clear, I have no doubt that everyone who does this work is trying to do right by children. The district attorney, the Department of Corrections, the Department of Health and Human Services, everyone. You don't do juvenile work if you don't care about children. But we all have roles to play, and the system requires balance. I'm a practical attorney, and all people accept consequences better when they feel that they were treated fairly. Children, more than any of my other clients, must feel that our system is listening to them. Providing children an advocate is a step towards realizing the principles that the juvenile justice system was founded upon. So I urge you to vote for this bill. Thank you. I'm happy to accept questions.
Thank you very much, Ms. Branch. Are there any questions for Ms. Branch from members of the committee? Seeing none, again, the committee thanks you very much for your testimony and for all the work that you do on behalf of youth. Very much appreciated. Thank you. The next person to testify is Jonathan Sarbeck. Welcome, District Attorney Sarbeck.
Thank you for having me, Representative Harnett, members of the Judiciary Committee. I'm Jonathan Sarbeck. I'm the District Attorney in Cumberland County and a resident of Cape Elizabeth. I am here on behalf of myself as DA and also as numerous members of the Maine Prosecutors Association in support of LD 320. I think for prosecutors, we recognize the value that this legislation would bring to increasing due process for juveniles who are in the system. As Attorney Branch just alluded to, we agree that representation is always key to increasing due process for any juvenile that's in the system, and we're in support of that. The key factors that I think take that balance between the juvenile being involved in the system and public safety are those factors that are in place with regards to the considerations of the level of crime for 12 to 13-year-olds on whether or not commitment would be authorized, and then that's limitation on 14-year-olds and higher. We support the removal of the 1-year mandatory minimum. From the information I've received, that 1-year mandatory minimum existed because that was required to get programs in place. And I think that my friends at the Department of Corrections would agree that rehabilitation treatment starts day one, and there shouldn't be a mandatory minimum that's going to get them those programs. That the members of Long Creek want to make sure that those kids are getting those programs from day one until the time that they are fit to be released. So we find that that's very important. The big one that I think was probably going to be questioned is the eliminating jurisdiction from or for criminal offenses for those under 12. Quite frankly, as law enforcement, police, and prosecutors have been doing in the community for numerous years, is picking up those pieces when other things fail. And we're in support of this limitation on criminal jurisdiction on criminal offenses for those under 12, because quite frankly, it's time to get some other programs in place for DHHS to start putting in place programs that are going to be helpful. Because as you heard people testify already, we recognize the trauma that can be put down on a child when they get brought into the system. And we know that that trauma can have lasting effects, that this goes to adverse childhood experiences that would be considered one for this incarceration. And we know that later on down the road, what effects those adverse childhood experiences can have with bringing somebody into the adult criminal system. 70% of a jail population has a score of 4 or higher on an ACEs scale of 1 to 10 for some of those traumas, and youth incarceration could be considered one of those adverse childhood experiences. So we support the idea of taking this out of law enforcement's hands and getting the attention to another entity, being DHHS. And I will say this, it is something that for a lot of prosecutors, it's difficult. There are apprehensions on giving this over because we have committed prosecutors like Christine Thibault who have done this work for so long in the interest of children. But we recognize that there is going to be a need to take that out of our hands and for other state agencies to step up to protect these kids. And
thank you very.
I heard the buzzer go off for the 3 minutes.
That's right. It's not too subtle. Thank you very much, Mr. Sarbeck, District Attorney Sarbeck. Are there questions for District Attorney Sarbeck from members of the committee? Senator Keim.
Thank you, Mr. Chair. Thank you for being here, Mr. Sarbeck. I'm wondering, so public safety is your job. And so can you speak to concerns around public safety that you've seen with youth, just to help us understand the types of cases we're talking about here and what could potentially happen if this bill passes and there isn't someone there at 3 a.m. to pick up a child?
Yeah, that's a valid concern, Senator Keim, and it's something that with supporting this bill, we really are taking that leap of faith to hope that those programs are going to be in place. I know that if there is a situation where this terrible crime happens with somebody with a child under the age of 12, that they're going to get the attention. It's a matter of who gives them that attention. Is it law enforcement or is it DHHS that can address the needs? I don't think that this is going to eliminate any sort of supports from public safety perspective that would be there. the EMA in Cumberland County and York County, we run a fire setters program. And the idea of the fire setters program is to address those very issues when a child is starting fires, because there's probably something else going on and we need to be aware of that. So I think that that program isn't going to be eliminated because there isn't going to be jurisdiction. As opposed, we're hoping to supplement any sort of DHHS programs that are going to be able to get involved to protect those children and to address those issues and those needs that that child most likely has. And with regards to people or children over the age of 12, I think that this legislation addresses the idea of if you had a 12-year-old that committed a homicide or a gross sexual assault, that because there are safeguards in there that takes into account the class of crime being a class A or B or C felony, that can be consideration on whether or not that child should be committed to Long Creek, but has the ability to make that decision, that determination for that commitment. There isn't a strict, you can never be committed to Long Creek at age 12, but there are those considerations that basically make the presumption that incarceration is not the first choice. But if there are factors that make it appropriate, then the court and the prosecution can recommend that, and then the court can order it.
Thank you. So, I mean, obviously, you know, I'm a co-sponsor of this bill, and so I am in favor of this process. What I'm concerned that I hear you say is that you hope, and it's a leap of faith. And I was hoping that we would have somebody from OCFS here today to talk to us about this, because the hope and the leap of faith part. Have you had any conversations with OCFS, and are you aware of what program or what supports they will be able to offer again at 3 a.m. when the 911 call comes in?
I myself have not had any of those conversations. I know those conversations have been had, and from what I've been told is that those programs are being funded, and the start date is going to be this fall. So I hope that will be, and that's all I can do, Senator Kime, is hope and take that leap of faith, which it is one, I'll tell you that much, especially for a person in my position and the position of other prosecutors and police out there that do this work every day to protect the community. That we're basically handing it off to another agency to take care of. But the reason that we're doing that is because we're recognizing that there are collateral consequences that come along with the involvement in the criminal justice system. And we're hoping that this bill being passed will eliminate that type of trauma that, like I said, can have everlasting effects into the adult system.
So just help me understand, like, a really from practical perspective, because this is just not being super familiar with the system, but if the court doesn't have jurisdiction over a child that's under 12, right? So 11-year-olds and under, can law enforcement even take that child into custody? They cannot, right? So it absolutely has to be someone from DHHS.
I believe you're correct on that.
So then just like, I'm thinking through scenarios in my mind, because this is how law works, right? It's actually practical. So it is 3 a.m. and a child has stabbed their father, and making no judgment on what went on in that situation with that statement. But then at that moment, there's a 911 call, law enforcement shows up. If in fact someone from OCFS does not show up at the same time, what happens in that moment? Like, the law enforcement can't take that child out of the home. The child is left there, or what?
I think what would have to happen is that as you said, DHHS would need to be getting involved in that type of situation. It would become a care and protection matter with regards to the law enforcement. But the law enforcement wouldn't have the jurisdiction to place that person into custody. Not commenting on that situation that you talked about, but that is, like I said, that leap of faith that we have to take with support of this bill, and we're willing to take in support of this bill. But we need to make sure as a state that we are going to have those support systems in place. And I do not work for DHHS, and I know that they have a task that they work hard every day, but it is going to be DHHS who's going to have to be stepping up to take the reins of protecting some of our most vulnerable people in our community.
Right, understand. So that's obviously our responsibility here, is to kind of oversee like all the moving parts all work together. And then just one other, just to help me understand process, if I could, Mr. Chair, one more question.
Yes, Senator.
So then say there was still an emergency situation though, and law enforcement shows up, but it isn't, it's considered that the child is at risk to be left in that situation. Does law enforcement then take that child out of the situation, or do they still not allowed to unless someone from DHS is there to take them?
I would have to, they can't take them under the purview of you've committed a criminal offense, you are under arrest, because they no longer have the jurisdiction to place that kid or that child under arrest. They might be able to take them under the guise of into protective custody, but this would take out the jurisdiction for a police officer to use that tool in their tool belt to say, we're going to take you into custody under the criminal or the juvenile code. They would no longer have that jurisdiction.
But they could take them into protective custody.
I believe so, yes.
Senator Keim, we will be hearing from the Governor's Council. That might be a question better directed to them. So you'll have the opportunity to talk about their views about child and family services as well. So not suggesting you drop the issue. It just seems as if the district attorney has provided the amount of information that he's able to at this point.
Thank you.
Thank you for your questions.
Are there other questions from the committee for District Attorney Sarbeck? Seeing none, I want to thank you on behalf of the committee for your testimony today and look forward to working with
and
you on this.
Representative Harnett, I forgot to say we would be available for the work session if the chair is inclined.
Be careful what you wish for. We will see you at
Thank you.
The work session. The next person that I have testifying in support is Jan Collins. Welcome, Ms. Collins.
Thank you, Representative Harnett and honorable members of the Judiciary Committee. My name is Jan Collins. I'm Assistant Director of Maine Prisoner Advocacy Coalition, and I am here to support LD 320, an act to provide the right to counsel for juveniles and improve due process for juveniles. I come to this testimony as a parent of 3 children who were adopted from the Maine foster care system. What does it take to share another person's wound? To acknowledge some children are born to parents that never wanted them, were molested by someone who was supposed to love them, are confused, in pain, and in need of deep nurturing, not more separation, pain, and loss. First, we must acknowledge that it exists, that there are wounds that cannot be seen. Then we must imagine that it is our own, feel its depth, and absorb the pain that surrounds it. I have a 12-year-old granddaughter. She loves to read, laugh, sing, hike. She loves hugs even when she's too timid to ask for one. When I consider incarceration at Long Creek, I picture what it would be like for her to be there. The fear, the confusion, the hurt, and my own powerlessness at being unable to help. I try to imagine a positive outcome from spending time there, but I come up empty. Maybe that's because I know the statistics. The longer a child is at Long Creek, the more negative her future life will be. A higher chance of returning to prison, an increased chance of suicide, more likely to suffer from substance use disorder, a future of poor health, broken relationships, and poverty. Although I would prefer to see children remain in and receive services in their communities, Any steps that we can take to decrease the number of incarcerated children, their length of stay, and their belief that no one cares are positive steps in the right direction. LD 320 keeps some children out of the system, establishes an age below which they cannot be incarcerated, ensures that they have a lawyer at every step in the process, and seeks to minimize their time at Long Creek by requiring regular judicial review. It is a small but necessary step in the right direction. Children who enter the criminal justice system are likely to have survived losses, trauma, and wounds. We must not add to those wounds. Compassion is the greatest medicine. I urge your unanimous support of LD 320, an act to provide the right to counsel for juveniles and improve due process for juveniles. Thank you for your consideration, and thank you to the sponsors, Representative Morales and Senator Kine.
Thank you very much, Ms. Collins, for your testimony today. And it's always important to hear from you. Thank you for being here. Are there members of the committee with questions for Ms. Collins? Seeing none, again, thank you very much. Look forward to working with you in the future. At this point, I have no one else on my list who indicated they wanted to testify in support of LD 320. But it can be a clunky process to indicate for some whether you're in support or not. Are there any members in the attendees room that want to testify in support of the bill? If so, if you could make that known to the committee clerk, that would be appreciated. Seeing none, I will ask, are there any persons here today, and I have none on my list, that are here to testify in opposition to LD 320? Seeing none, I will now move to those persons testifying neither for nor against, and I am going to list those that I have on my list so that you have some idea when you will be called. We will begin with Erica King, followed by Gerald Reed, then John Pelletier, and then Sky Goslin. So at this point, I would welcome Erica King to the Judiciary Committee. Thank you for being here, and please feel free to proceed.
Thank you. Thank you for having me, Chair Representative Harnett, and distinguished members of the Joint Standing Committee on the Judiciary. My name is Erica King, and I'm a Senior Policy Associate at the Muskie School at the University of Southern Maine. And given our long-standing research focus in the area of juvenile and criminal justice issues in Maine and nationally, including a partnership with a number of stakeholders like the Maine Department of Corrections, I'm here to provide informational testimony summarizing our findings on the impact of confinement on Maine youth and communities. As a baseline, and as you've heard overwhelmingly this morning and in work session and in last session in your committee, national research, local data, and a growing number of correctional leaders across the country are overwhelmingly aligned in the finding that the use of confinement for young people increases the likelihood of adult incarceration. It increases long and short-term costs to taxpayers, and it leads to many long-lasting negative outcomes for the young people that are in the system. And one of the reasons for this is that Maine, like any other places in the country, programming happens in youth facilities within the context of a behavior management system. However, responsive treatment to mitigate the traumas, both gender, economic, and racial, that lead to young people to the justice system remain largely unaddressed in the community. And so this approach leads to what we call a length of stay problem. And this is where a young person's release in time in a facility is tied to treatment and behavior, but the facility and programs may not be equipped to provide responsive, individualized family treatment to help young people develop and heal all the things that led to their incarceration and that they will have to face as they come home. So as a result, under the current policies, a young person is likely to face an extended confinement upon release, to be further disadvantaged by work experience, managing their social conflict, and building social capital. The most recent juvenile recidivism study that we did notes that on average, youth spend 13.6 months in a facility before being released to the community, with approximately 42% of them returning to Long Creek or the adult criminal justice system within 2 years of release. The risks of long lengths of stay within this indeterminate context has also been pointed to by the Maine Juvenile Justice Task Force that you heard about earlier this morning, showing that the longest lengths of stay tended to be among low and moderate risk youth, staying an average of 508 days in the facility. Meanwhile, high-risk youth stayed for an average of 321 days under the auspices of the current system. So in sum, even though it may be counterintuitive, longer lengths of stay do not achieve better public safety outcomes. They actually result in diminishing returns. And just as important as the public safety and taxpayer impacts are the unquantifiable social and economic costs to our young people and communities. And that includes damaged social networks, decreased educational opportunities, severe functional limitations, worsened health and mental health outcomes, and a heightened risk for incarceration as adults, especially for youth of color. Likewise, their labor force participation is severely depressed for formerly incarcerated people, which is a huge issue for our transition age youth and for them and for our state. So important reforms in this bill concerning who is eligible for confinement, eliminating the 1-year mandatory minimum for secure confinement, and access to legal counsel and judicial review could have implications for reducing lengths of stay. And these reforms have the potential to reduce social and economic costs of youth incarceration and the burden on taxpayers, as well as improve youth and public safety outcomes. Thank you, and I'm happy to answer any questions.
Thank you very much, Ms. King. The committee appreciates your testimony and participation today. Are there questions for Ms. King from members of the committee? Seeing none, I thank you again for your time and participation today.
You're welcome. And Chair, may I offer, if it's helpful for the work session, I do have some access to some data that disaggregates young people in the facility by age. I noticed someone asked for that earlier, and I'm happy to make it available for the work session.
That would be very helpful to have. Thank you very much. The next person presenting testimony is Jerry Reed, Counsel for the Governor. Mr. Reed, welcome.
Thank you. Good morning, Representative Harnett and members of the Judiciary Committee. I'm Jerry Reed, Counsel to Governor Mills, and I'm here this morning to offer some thoughts from the Governor's Office on LD 320. My colleague, Deputy Counsel Tim Feely, and I did submit a fairly long and detailed letter to the committee this morning, setting forth some of our ideas and concerns about the legislation as proposed. And I think the best use of my time this morning is not to read that letter back into the record, but to try to quickly hit some of the high points and themes that we'd like to emphasize. So that's my plan. And I want to start by commending the co-sponsors of this bill for bringing forward some ambitious legislation to address what is clearly a very important problem that needs to be addressed. They deserve great credit for taking the issue on. The administration supports that effort, and everything else I say this morning should be understood against that background. So let me turn now to a few provisions within the bill, touch on some of its strengths and where we think it needs some improvement in its current form. One of the problems with the current system is that it doesn't do a good job of ensuring counsel for a juvenile who's charged with a criminal offense early in the process and throughout the process. And we think this bill does do a good job in sections 3, 4, and 5 collectively of addressing that problem. We think it's an important fix and will make a substantial improvement to the current system as it exists. One of our significant concerns with the bill as drafted is that issue that was the subject of discussion between Senator Kime and District Attorney Sarbeck just a few minutes ago. And that is that if the bill were enacted in its current form, it would make jurisdictional changes to the juvenile court that would create a gap for certain children who are in dire need of services. And these are children, for example, who are less than 12 years of age with violent tendencies, who are not themselves in jeopardy within their home from anyone else, but instead are a source of jeopardy to others. The state would have no mechanism available to compel that a child under those circumstances receives the services that would be required to ensure that there's no threat to other family members or even the general public if these changes were made currently. So we understand that that's a relatively rare set of circumstances, but it's far from unheard of. And we don't believe it's appropriate to make this jurisdictional change unless and until we have a way to fill that gap. So in the leap of faith on that issue that was discussed earlier, we are uncomfortable with making that leap of faith until we have more assurance that there is some mechanism available to fill that gap. To the extent that the Families First Prevention Program at DHHS is being held up as a solution to meet the needs of these children, that would present some concerns for us because, as I think you've heard, that program does not yet exist. It's still a budget item. And even assuming it can be put into place sometime soon, it's not clear that the type of services that would be provided through that program would be the services required to address the needs of these children under these challenging circumstances. DHHS is also working hard to establish a psychiatric residential treatment facility in Maine, but right now that doesn't exist either. And currently we'd be forced to rely on waiting lists for placements in other facilities out of state for these children. We believe these issues ought to be addressed and fully resolved first before the jurisdictional changes are made and take effect. So those are the primary concerns I wanted to touch on. There are other points, technical points and resource-based concerns that are set forth in the letter we've provided to the committee, but I'm mindful of the time. And I think what I'd like to do is just to close by acknowledging that I am not personally an expert in this complex area of law and policy. Tim Feely and I have been doing a lot of studying in the recent days to try to develop some familiarity with the issues in preparation for this hearing. And when I'm not an expert in an area like this, I do know enough to consult with those people who are experts. And so that's what Tim and I have been doing. And the concerns and testimony that's set forth in our letter reflect those concerns that we are hearing from those experts within the administration who know more about these issues from having devoted their careers to them. And what I want to do is pledge that the administration will work with the co-sponsors between now and the work session to try to resolve the issues we've raised, and we will make available the experts in the administration, especially those within DOC and DHHS, to answer questions that the committee members may have at the work session and try to work through the issues and bring them to resolution. So with that, I'd be happy to try to answer any questions that the committee members may have. And I thank you for your consideration of our testimony.
Thank you very much, Mr. Reed. The committee appreciates you taking the time out to provide testimony today. Are there members of the committee that have questions for the Governor's Council? Seeing none, we look forward to continuing to work. I'm sorry. For some reason, you're covered up on my screen. Senator Keim, now I see your hand, both real and virtual.
Yes, it was. We couldn't let Mr. Reed get away that fast. So thank you for being here, Mr. Reed. So am I to understand then that you are here in lieu of OCFS or DOC being here to answer more particular questions on the basics of this bill?
Colin O'Neill from DOC is on this call, and I think he would be available to answer questions that would be within his purview at DOC, if that would be helpful to the committee. But generally speaking, you're right. The idea was that I would be here to present kind of the broad view of the administration at the hearing while committing to make available these experts from the agencies at the work session and between now and the work session.
Okay. Well, I do have a few questions. And first, I am a little surprised at what I think was Mr. Landry being very supportive of this and suggesting that the Family First initiatives or programs would in fact be able to cover this gap. Can you help me understand how we might be hearing something from one part of the executive branch and then something else from now here today?
Sure, I hope that's not the case. And Mr. Landry should speak for himself, and he will be doing that at the work session. I don't think that I overstated the position of DHHS on this issue. The primary point is the program doesn't exist yet. And so there is a leap of faith in enacting this legislation on the assumption that it will be stood up and take effect and be able to fill the gap. The secondary point is the other issue about whether this program is really ideally suited to meet the unique needs of these children who are maybe small in number, but presenting a very challenging set of circumstances that need to be addressed on an immediate basis. So that's the one where I think Mr. Landry would be better suited to address the particulars of than me. But I think that he and I are on the same page about that.
So the other issue about who gets jurisdiction of the child is whether or not that child is competent to stand trial. And I think more often than not, they're found that they are not competent. But I don't really understand how that determination is made, and maybe you're not the right person to ask this to, but if they're not competent, then at that point, DHHS has to take custody of that child anyway, I assume. And so they must have some type of programming that works for this. I guess I'm asking the question because I need to understand better how all these systems are working together and you know, the very practical thing of where does this child go from moment to moment in the process as different entities are trying to sift through who has jurisdiction and how those determinations are being made, and you know, where in the moment is that child during the process.
Right, and I think that's exactly what our concern is also. So we're all concerned about resolving the same issue, it sounds like to me. And as DA Sarbeck was explaining, I think I understood this correctly, if this legislation were enacted in its current form, the criminal justice system wouldn't have jurisdiction over the 11-year-old child in the circumstances we're talking about. And the problem that we've identified is that if there's no jeopardy to the child themselves in their home setting, DHHS likewise would not have the ability through the child protective process to file a preliminary protection order and to take custody of the child. And so DHHS custody is only triggered, and jurisdiction is only triggered when there is an ability for the agency to demonstrate in court that that child is in jeopardy through some other, by means of some other external threat. And what we're concerned about is when there is no such other external source of jeopardy to the child, but the child themselves is presenting jeopardy to others. Under those circumstances, DHHS would not have the ability to satisfy its evidentiary burden in court to take custody of the child. And the criminal justice system would likewise not have jurisdiction to detain the child. And that's where the gap exists that we've identified. And it's not a gap that I think is impossible to fill, but I don't think that there is a mechanism that's been identified currently that assures us that it will be filled. And that's what we want to focus on.
A follow-up, if I may.
Yes, Senator.
So then, but if that same child that maybe that is in a home that isn't unsafe for them, but they are the safety risk, but then they're not found competent to stand trial, then at that time they have to be given into the care of DHHS anyway, and right? So we must have some mechanisms in place.
My understanding is that DHHS would have no ability to assume custody of the child under those circumstances. There are parental rights at stake that the state cannot interfere with unless certain showings are made in court. And so that's where the problem lies. So I'm not sure about the mechanics of some of these things as they happen on the spot, but as a jurisdictional matter, the problem is that DHHS is not going to be able to make the showing it needs to assume custody of that child, even on a temporary basis.
Okay, thank you.
Mr. Reed, you mentioned that Colin O'Neill was here. I realize he's with the Department of Corrections, not DHHS. Would he be in a position to answer Senator Kimes' question, or is that too far afield?
I think it's a good idea. We should give him the opportunity because his experience probably would allow him to shed some light on at least what practically happens under these circumstances.
So I would open that back up to you, Senator Kime, if you want to pose that question to Mr. O'Neill.
Yes, thank you. That would be helpful. I believe for all of us to just understand, practically speaking, how, you know, what the mechanics are when a child is found that they're not competent, and just speak to where they go at that point, and who's taking jurisdiction over them.
Welcome, Mr. O'Neill, and thank you.
Thank you, Representative Hartnett and Senator Kime. And I'm Colin O'Neill. I'm the Associate Commissioner for the Department of Corrections, and I oversee the Juvenile Division for the department. And I can try to practically answer that question, Senator Kime. Competency, only a judge can determine competency. And so usually competency is determined through a judicial process. And so once a child is determined to be not competent by the judge, then the juvenile justice system no longer has any authority over that juvenile or the court. And so that would end it. But I believe your question speaks to a little bit about in the heat of the night, you know, if something happens, what would be the jurisdiction? If that child has been determined incompetent, that would be on a prior offense. So in the middle of the night, if something happens and it's a young child, if the court system had no authority and law enforcement had no authority, there wouldn't be any response you know, to that child in that sense. And so what happens now is law enforcement with the Department of Corrections and the DA's office determine if that child meets criteria to be detained. And so that's what happens now. And if that authority is taken away, then that no longer would be the process to determine if the use of detention.
So from the moment of an incident, it's assumed that that there is the jurisdiction is with the courts at that point, and so the child is detained for about how long before a judge will determine whether or not that child is competent? How long does that take? A week or 2 days or?
No, it takes usually a lot longer than that, because there's a competency evaluation that is set up by the court and by state forensic services, and that can take upwards to 60 days plus. So it's quite a lengthy process to determine competency.
Okay, that is a long time. And then if they're not competent, then the jurisdiction immediately goes to DHHS, and I maybe you can or cannot speak to what would how that transfer happens and where does the child end up at that point?
Well, the child would be, there would be an ongoing process to continue to meet that child's needs through OCFS and through other state agencies, just making sure that that happens. But there isn't they wouldn't be compelled to do that.
Right, and we spoke about that earlier, which I don't know if the committee's all aware of that whole compel piece, and we also talked about children then being sent, possibly to other states to get the services they need. So, but unless someone else has questions around that, I won't bring that up. But thank you so much. I'm sure we'll have lots more questions at the work session, and I think Mr. Reed said you would be available.
Yes, and we'd be happy to provide any data as well, as far as to help with the committee.
Thank you.
And Senator Keim, rest assured, we will request representatives of the appropriate departments in DHHS at the work session to address these questions, which seem to remain unanswered. Thank you. Representative Reckitt, and thank you, Mr. O'Neill.
I'm sitting here puzzled, and I'm not sure. I think this question is to the governor's representative, but it might be to Colin. Basically, there are times when things happen out of the nice, neat route we think everything ought to follow. I mean, I myself have been at the door of a judge at 10 p.m. at night to get a protective order signed back in the day when it wasn't so easy to do in court. And I've listened to friends who are retired judges get called in the middle of the night for search warrants. There must be some intermediate step that can happen between the incident and the rest of this long devolved 60 to 90 day competency process. There has to be another way. So I'm asking the governor's representative whether or not there is a thought process going on about things that are sort of outside the box in terms of what the normalcy is. We're not talking about a lot of kids or a lot of instances. There has to be a way. Any ideas?
Yeah, I think I agree with the thrust of your question, which is we're not talking about the laws of physics here. We're talking about laws that we have the ability to change and policies that we have the ability to change. And so the gap that we think we've identified that we feel is a problem is one that can be filled. And I think the other states who have tried to do something similar to what's proposed in this legislation have found ways to do that. And so I do think there are ways that we can try to bridge this gap and ensure that services can be mandated in this interim period for this somewhat limited set of circumstances that we're talking about. And so I think it's something that we can try to work through, but it is something that we should work through and not gloss over.
Thank you.
And I'd just like to add that not every competency case do all youth wind up waiting for that determination at Long Creek. And so there are many cases where young kids come into the system that maybe have been detained, but through a determination and through a court process, they can do and wait out the competency process with supports either at home or in a some type of mental health program and all that. I think the big piece to that is that those programs and supports are voluntary, and so if at a rare case, a family and a young person doesn't want to engage in that, then there are concerns for public safety. And so I think that's kind of the challenge of it. So there are many cases where where some significant events have happened, and a competency hearing and evaluation has been ordered, and that young person is is weighting that and engaging in that while they're being in somewhere else other than Long Creek. Just to muddy the waters a little bit.
Well, it is near a creek.
Senator Kime.
Thank you, Mr. Chair. I had another question, which I think might be for Mr. Reed, but I'm not really sure who is appropriate to ask this to. And it's something the sponsor and I did have a discussion about. I heard some concerns around the definition that was added of juvenile, and that might be a problem. That changing that definition might have confused might be confusing in the way this works out, because trying to get this, remember this right, because if they're still under jurisdiction under the juvenile code, but then they commit a crime while they're actually an adult, then they would have to still be treated as a juvenile. Like they would still be in a juvenile court for that. Was that a discussion that was had in the governor's office, Mr. Reed? And was that a concern or no?
I have heard that issue raised, and I'm going to have to defer to, I think, probably prosecutors who have more experience in this area than I do to provide a more meaningful answer. It's not an issue that we raised in the letter that we submitted to the committee, so it's not one of our leading concerns, but it may be something that the committee wants to ensure that it gets a full answer to during the work session, because I have heard that raised by others.
And then I'm sorry, I have too many papers in front of me, but my other question for you is around section 13 about having, moving that they can have a reevaluation every 6 months instead of a year. Was that in your letter as well? Because I'm not finding it in front of me. Oh, yes, it is in front. Yeah, so can you speak to that piece?
Yes, it is in our letter, and you know, I can easily understand why that additional process would be helpful and desirable in ensuring that more attention is brought to bear on these individuals and their needs. I think the primary issue we raised with respect to that is that it could be a substantial or at least a significant additional burden on the agencies and offices that are involved. It would implicate, I think, staff at DHHS, at DOC, at the Office of the Attorney General that provides legal services to those agencies, and certainly within the DA's offices. So I can see why that's proposed as a matter of policy, but I do think that some consideration should be given to whether the system can sustain the burden that would be associated with that.
So a follow-up to that would just be, as I think through this as a policy matter and thinking about youth, a year is a long time to wait to have consideration be given of good behavior or changes in that young person themselves. And so when we set small goals, sometimes they're close enough that they're front and center for a child, and that's sometimes helpful as something to attain. And so was that, okay, so I hear the resource concern about this being time consuming and resource intense to basically double this, because, you know, the bill does say that it's, you know, if the lawyer thought it was appropriate, but I think that the more often than not that the youth and the lawyer would definitely decide to take advantage of this. I mean, I can't imagine that they would not. So I think it would become probably protocol. But so the question is, how many young people would this really, how many young people are in that this would be happening, right? So resources, if it's only 5, is much different if it's 100. And how much thought was given to the benefit to the youth by having this shorter time frame, sort of ending thing to look forward to, and to, you know, sort of reach out for as a goal for themselves.
Yeah, I think those are exactly the right considerations. And it's, as you're pointing out, it's a balancing. It's balancing the benefits to the youth involved against the ability of the system to provide that level of focused attention. And I think I would just urge the committee to make sure it gets the information it needs, probably primarily from the Prosecutors Association and the district attorney's offices, but also from the agencies about what this will mean in practice for them.
Might I suggest, partly with concern for time, that we request that precise information from the parties that have it, so we can have that in front of us in a work session. If that's makes sense to you, Senator Keim.
Absolutely, thank you.
Thank you. I see no other questions for the Governor's Council. I want to thank Mr. Reed and Mr. O'Neill. And I'm sure we will be seeing you again.
Thank you.
I will now turn to John Pelletier on behalf of the Criminal Law Advisory Commission, and then Sky Goslin, and then, unless there are others, we will close this public hearing. Mr. Pelletier.
Representative Harnett, members of the committee, thank you. My name is John Pelletier. I'm the chair of the Criminal Law Advisory Commission. And we've reviewed the original bill, and we discussed this bill recently. And the commission as a whole is in favor of most of the provisions. We did divide on the provision that was just being discussed, juveniles under 12. And we had one group of folks on our commission who felt that that there was an indication from the sponsor who participated in our meeting that there was a new program that DHHS had some grant money for and was looking to put in place. I had mislabeled that program in my testimony, but it's the Family First program that's been discussed. And so a number of people in our group thought we do have public safety concerns with some children under 12. We don't know what this program is going to be. It's not in place. We can't see exactly what it is. We think this should be deferred. So that was one group. There was another group that was in favor of this provision. And they were in favor of the provision based partly on the information that we had heard about the Family First program and more services being available. But both discussion of the original bill and discussion of this bill, there was some sentiment on our group that at some point we've got to force the hand of DHHS and the other powers that be to provide the necessary care for these children. And that if we keep defaulting to the juvenile justice system, we will continue to cause harms to very young children. And because that default system is in place, the necessary work will not get done to provide the services that are truly needed to best serve these kids. So those are the two, you've heard both sides of that today. That is where we came down as well. As I mentioned, I did provide written testimony. I think I'd like to address the issue of the definition, because the concern that was raised by Representative Khan, Senator Khan, did come up at our meeting, and we did not explore it extensively, whether or not that problem would actually exist, because we fairly quickly came to the consensus that Section 1 of the bill, the alteration of the juvenile definition, is not necessary. Now, one of the things the bill does is it allows, under current law, these reviews. May I finish my sentence, Mr.
Yes,
Chairman?
I'm sorry. I'm just trying to keep track. If you could wrap it up, that'd be greatly appreciated, Mr. Pelletier.
Under current law, these reviews apply only to people who are up to 18. But of course, commitments can extend up to age 21. So the bill extends the eligibility for review up to age 21. And I suspect that this provision was drafted just to make it clear that those folks between 18 and 21 remain under the jurisdiction of the juvenile court. The criminal code takes care of that. There's a section in the criminal code that says any court proceeding relating to an offense that was committed before someone's 18th birthday is in the jurisdiction of the juvenile court. So we felt that provision was unnecessary. So I'll stop now. I'm over my time. I would be able, I believe, to shed some light on the competency issue as well.
Thank you, Mr. Pelletier. Questions for Mr. Pelletier, Senator Kime?
Thank you. I am trying to be cognizant of the time, Mr. Chair. So I would be interested in what you just said, Mr. Pelletier, about the competency piece, and then I have one further question.
Okay. Under the juvenile code, competence in the way it's being discussed requires jurisdiction of the juvenile code. The person is charged. They may be detained at Longcreek. They may not be. There's a process that includes at least one psychological evaluation, and then there's a hearing in court. And there may be multiple hearings because the person may be found not competent, but if we wait a little while or provide some treatment, maybe they'll be competent in the future. So they can extend over a significant period of time. Once the court finds that a juvenile is not competent, they can commit the juvenile to the custody of the Department of Health and Human Services, but they're not required to. The judge can also order that there be treatment, that DHHS do an evaluation and recommend some treatment that the person may voluntarily take, or the judge can put them in DHHS custody, or the judge can simply dismiss the case and the person goes on their way. Those are the possible outcomes after a determination of not competent.
Thank you. And then the only other question I have for you, because I'm sure you'll probably be available for the work session, and I would like some consideration given to Section 6, where there's a discussion that there would be, there's language there that consideration would be given on whether or not a juvenile will be incarcerated based on if they have made or agreed to make restitution to the victim. So to me, it seems like if someone is incarcerated, it should be on a public safety, but not on whether or not they have money to pay a victim. Is that a discussion?
That is, yes, and that's addressed in my written testimony.
Okay, thank you.
Because there's a court. Our group divided on that question. The majority were what you said, that there's a fairness issue. Why should a family that's able to make the restitution render the child less likely to get a commitment to Longcreek than a poor family? There were some people on our group who felt that the language in Section 6 addressed that problem because it says that the person gets credit so long as they make restitution up to their ability to pay. So that person may not be able to pay all the restitution, but as long as they make up to their ability to pay, they would still get the credit. But that divided our committee. And I'll point out, as I do in my testimony, that language is existing law. It's last legislature, there were 2 bills that addressed this provision. One passed the language that's in Section 6. The other passed more abbreviated language that didn't have the language about ability to pay. So there exists right now in statute a conflict that the legislature is going to have to resolve one way or the other, could repeal both or choose one over the other. But as I say, on the policy matter, our group was divided. Our majority felt that there was unfairness in making someone less likely to get committed if they or their family had means and could pay the restitution.
That's illuminating. Thank you.
Thank you, Mr. Pelletier. Thank you, Senator Keim. Representative Moriarty.
Thank you, Mr. Chair. As you know, I had to leave our meeting electronically to go elsewhere, and maybe this came up in the meantime, but I'm confused about one point. So, Mr. Pelletier, suppose you have a juvenile who committed an offense while under the age of 18. That person, as I understand it, still remains within the authority of the juvenile justice system until age 21 with respect to that offense. Am I right so far?
Well, they may or they may not. It is an appropriate disposition in the juvenile court. All juvenile crimes are committed by someone under 18. There is an authorized disposition where a commitment to Long Creek can extend beyond the 18th birthday up to the 21st birthday. And I believe probation can extend beyond the 18th birthday as well. So if the person receives a disposition that extends beyond their 18th birthday, then they remain in the custody of the juvenile court for any proceeding related to that disposition.
Okay, I got you. So suppose then that someone is under such an order of disposition that carries forward from the 18th birthday. And suppose they then commit an entirely new offense, and perhaps a entirely different type of offense after having attained 18 years. Are they now within the jurisdiction of the main criminal code?
Yeah, yes, they are. And it happens frequently. Unfortunately, the most frequent scenario I'm familiar with is someone who is serving an extended commitment at Long Creek commits an assault. So they're 18 and a half years old, they commit an assault. And there are in fact juveniles who have been transferred from Long Creek to the Cumberland County Jail because of criminal conduct committed at Long Creek. But that conduct, if they're over 18, that conduct subjects them to criminal penalties and the jurisdiction of the criminal court.
Okay, that helps. Thank you.
Thank you, Representative Moriarty, and thank you very much, Mr. Pelletier. Seeing no other questions from committee members, thank you very much for your testimony on behalf of CLAC. And I would turn to our final person to testify, and Skye Goslin. Welcome.
Hello, Representative Harnett and members of the Judiciary Committee. My name is Skye Goslin, and I'm a community organizer with Maine Youth Justice. And I'm here today coming with a youth perspective. Maine Youth Justice is a nonpartisan campaign fighting to end youth incarceration in Maine and invest in a range of community-based supports that respond to young people's needs, support families, and build community. We are a campaign led by young people who have been incarcerated in Long Creek. We are calling for the closure of Long Creek, the end of youth incarceration, and the reinvestment of $18.6 million currently being spent to lock up Maine's youth. We thank this committee for taking the time to consider legislation that keeps children out of detention and protects the youth who are sent to Long Creek. Maine Youth Justice believes that no young person should be incarcerated or prosecuted in the criminal legal system. Similar legislation passed this committee last session. This summer, thousands of Mainers protested in solidarity with Black Lives, demanding the closure of Long Creek. This legislation takes a step in responding to the demands of formerly incarcerated youth, but fails to address the violence currently taking place in Maine's juvenile justice system. Maine Youth Justice is testifying neither for nor against this bill. There is no justification for sending young people to prison, traumatizing them for the rest of their lives and tearing apart communities. We urge this committee to move as quickly as possible to end the criminalization of young people and end the end of youth incarceration. This solution is a Band-Aid to a failing system that is causing constant violence and trauma to youth and their families across the state. Personally, I was 12 years old when I became involved in the juvenile system. I was getting bullied, and the school resource officer did nothing to support me, except the cop who arrested me at school was laughing at me. I was being treated as if I were some crazed criminal instead of what I was, a little girl. And then my first time being sent to Long Creek, I was 14. Before I was locked up, my friends were all sent to Long Creek. I was lonely on the outside and lonely on the inside. I should never have been incarcerated so young. My relationship with education was harmed when I was arrested at school. Being ripped from my school and my community to get sent to Long Creek left trauma around education. 7 years later, I'm healing my relationship with education, but not because of Long Creek supporting my growth, but because of my commitment to make sure no young person has to go through the experience I did. What I needed instead of Long Creek was someone to have helped me that first day, someone who believed my side of the story before jumping to conclusions. Most kids just need to be cared for, not just another case with numbers at the top of it. Many people do not understand the kind of trauma young people experience while incarcerated. When young people are incarcerated, we begin to see ourselves as society treats us, as outcasts, driving us further into a life of troublemaking. The trauma does not stop once you leave the detention center either. Your family and friends have all moved on. Young people leave incarcerated settings so traumatized they lost an understanding of human interaction, including how you handle conflict or connect with people. So we urge this committee to end the 1-year mandatory minimum sentence for youth in Maine and recognize this is only the beginning of the transformation that is needed in Maine's juvenile justice system. This legislation takes steps in supporting youth who are incarcerated by providing legal representation during commitment and probation period. For as long as Maine continues to incarcerate youth, have a right to state-appointed counsel during the entire time we are involved in the system. Maine Youth Justice encourages this committee to listen to the communities most impacted by the harms of youth incarceration. We have the answers, and it begins with a plan to end the criminalization of youth and investment into care, support, and resources for young people and their families. Thank you.
Thank you, Ms. Goslin. Are there any questions for Sky? Representative Evangelos.
Thank you, Mr. Chair. Sky, I just wanted to thank you for your testimony. Your very strong remarks. You've been through a lot, and it took a lot of courage. You spoke very well today. I want to assure you your issues will be taken into consideration when we meet in the work session. So thanks a lot.
Thank you. I just also want to say that we also put other testimonies, written testimonies of other young people's voices as well. So I just encourage you guys to read the stories just to bring some young voices in here, because at the end of the day, we are discussing about young people's lives.
Thank you. Thank you very much for the reminder. Are there any other questions for our final witness on this bill? Representative Newell.
Yes, thank you, Mr. Chair. I went into our Google Drive and I was just wondering if we have a copy of Ms. Goslin's testimony.
I have not found one. If we don't have one, we will have one.
Thank you.
I don't know how quickly the Google Drive is populated.
Thank you.
Okay. I will give one more opportunity. Is there anybody in this electronic meeting who would like to testify in any way on the LD that is in front of us right now, LD 320? Seeing none, I will close the public hearing. I very much thank the committee and all of those who participated in today's proceeding. At this point, I need to confer with the committee clerk and analyst. We have one bill that is scheduled for this morning that only has 4 witnesses or 4 people testifying. Are they available now? At some point, I need to give the committee a break. And I posed the question in the chat to you. Are we able to, if everyone's here, I would go forward with it and then take the break and delay the afternoon session. But if they are not here, I would take the break now and move them to shortly after 1:15. Is that a question you can answer?
I'm not sure where Senator Stewart is. Yeah, he's signed on.
I just sent him an email.
Okay.
And he's in the attendee list.
Okay, is the committee comfortable with moving forward with this bill and then taking the break after that and delaying our afternoon session? Senator Keim?
I just wanted to let you know, I texted the sponsor and he said his bill will be quick. So that might help us make our decision.
That I think we just made the decision. Thank you. So with that, I will open the public hearing. Just want to make sure I have this up. Open the public hearing on LD 291, which is an act regarding continuances for protection from abuse hearings. And as we did in the first hearing, the sponsor will have as much time as he needs to present the bill. We will then hear from those testifying in support, those testifying in opposition, or do you have any co-sponsors with you today, Senator Stewart?
Negative.
Okay. Then we will hear from those in support, those in opposition, those neither for nor against. Again, there will be no time limit on the person introducing the bill, but there will be a 3-minute time limit on all others who testify. Welcome to the Judiciary Committee, Senator Stewart. It's nice to see you, and the floor is yours.
Thank you very much, Mr. Chair. I appreciate it. And good afternoon to members of the committee. I'm Senator Trey Stewart, and I proudly serve the people of District 2 in the Senate, which includes Southern Aroostook and parts of Northern Penobscot counties. And I'm here today to present LD 291, an act regarding continuances for protection from abuse hearings. This bill came to me by way of a couple of attorneys in Aroostook County who have been struggling with ensuring that their clients are able to access justice when they are going through the hearing process for a protection from abuse order that has been filed against them. Under the current process, a hearing is required to be held on the matter within 21 days of filing, which remains in effect throughout that time. As you know, the pressures on attorneys and the court system in Maine are incredibly high, and cases are presently on a multi-year waiting list in some instances. Fortunately, this is one area that moves the quickest as the risk to the defendant to lose their rights during that time is a legitimate constitutional issue that must be dealt with expeditiously. At the same time, ensuring a quick resolution to the matter is a benefit to both parties, given the implications that the temporary order has on defendants and given the stresses placed on both parties as they seek a resolution. That does not mean, though, that the other constitutional protections afforded to defendants should be cast by the wayside in hopes of ensuring speed over justice. While there is case law that stipulates that judges have the ability to determine if a continuance should be granted in a particular case in front of them, if the continuance isn't granted in these cases, the defendant is certainly disadvantaged, and the plaintiff may even be as well. For the defendant, the risk lies in not being able to conduct a thorough discovery process to understand the evidence being presented in the case against them that would otherwise be commonplace in other civil actions. There is a potential risk for the plaintiff as well, who will have a shorter amount of time to build a case against an individual who is a potential danger to them, and should they fail to prove the legal burden at the hearing, the temporary order won't be extended to protect them. Again, expediency is not always the best option and may lead to a greater harm. This bill seeks to remedy this problem by ensuring that when a continuance is requested by the defendant, that request will be granted. In short, it changes the case law standard of may be granted to a more definitive option. By making this shift, we'll be ensuring that in those instances where there's a legitimate discovery process is warranted and necessary and hasn't had time to yet be conducted, the defendant's rights won't be compromised in the name of expediency. Of course, throughout any extension, the protection orders and other requirements will remain in place against the defendant, meaning their incentive to move quickly still exists. I don't suspect that this extension would be requested in most cases for that reason, as the defendants will want to deal with the orders that are against them as quickly as possible and move on with their lives, except in instances where a legitimate extension of time is required to ensure justice is achieved. I have been contacted by other stakeholders, some of whom will be testifying behind me today, who have some technical concerns with the language of the bill regarding the reason for continuances, and we welcome that feedback to amend the bill to ensure the process is not abused by defendants with ulterior motives. That said, it is clear that there needs to be a change in statute made that will legitimately protect defendants when justice requires, which currently does not exist. No doubt these are serious actions and should be viewed holistically by the legislature, whose job it is to not only protect the plaintiffs in these instances, but also to ensure that our system and procedures are allowing the truth to come out and that the outcome is fair and just to both sides. I appreciate your time and attention to this important matter. I'm happy to answer any questions the committee may have at this time.
Thank you very much, Senator Stewart. The committee appreciates hearing from you and welcoming you to the committee for the first time as a senator. Are there members of the committee with questions for the bill sponsor, Senator Stewart? Seeing none, I thank you for your testimony, and I will now turn. I don't have on my list anybody testifying in support of the bill, but I do want to check if there are in fact people in the room, in the electronic room, that do want to testify in support of the LD 291.
Mr. Chair, I do have a constituent who is here today with us. I'm not sure if there may have been an issue with the electronic.
Is that Richard Rhoda by any chance?
Yep, Attorney Rhoda, correct.
Attorney Rhoda was listed as neither for nor against, but if Attorney Rhoda is here and is testifying in support of the bill, he will be heard from first. But
that was the case. That was the goal. I don't know if maybe the wrong box was selected.
Well, we have found that this has happened on numerous occasions. So if Attorney Rhoda could be moved into move to a panelist, we will hear from him to testify in support of LD 291. Mr. Rhoda. I do see a box with Mr. Rhoda, but his microphone is muted. Now it's unmuted. Mr. Rhoda, are you testifying in support of LD 291?
Yes, I am.
Okay, you can welcome to the Judiciary Committee and you can proceed, sir.
Thank you very much, Mr. Chairman and members of the committee. I'm Dick Rhoda from Orient, Maine, and I've practiced law in Holton since 1972. You've received my written comments, which I set forth the nuts and bolts of the main rules of civil procedure that affect this LD. My present comments are to elaborate upon issues brought up by this LD as I see them. Getting much closer to the end of my practice of law, there's one aspect of the law that I have observed and that I strongly believe needs to be clarified beyond any doubt. I speak of the need to ensure that a defendant in a protection from abuse case is assured that his or her attorney is allowed to be fully prepared to protect his or her rights. Senator Stewart stated the problem very well. It is simple. If judges are free to determine if a continuance shall be granted, if requested by the defendant and it is denied, then the defendant is at a distinct disadvantage going into a hearing. Excuse me. Those opposing this bill take the position, I believe, that their cited case of Shaw v. Packard protects the defendant by Title 19A, Section 4006, which assures the defendant that he or she can have a hearing within 21 days to protect their personal liberties. But a hearing can only be held beyond 21 days if the defendant presents substantial reasons to support the granting of a continuance. We have to look at lawyers do discovery for a reason. They're there to try to dig out facts which more clearly explain the content of the allegations made in the complaint. Protection from abuse complaints usually are not made out by one knowledgeable of the law. General misstatements of the law and hearsay statements, which would not be admissible in a hearing, may help sustain the ex parte order by a judge. And remember, many times this initial order is based only upon the written complaint and without the judge seeing or otherwise questioning the plaintiff. I like to say, trust me, I'm a lawyer. And what I've just told you is the truth of the judge not seeing the plaintiff. I say, trust me, because my word is the most important thing that I have when I come before you here today. Without discovery, you cannot tell where the testimony at a hearing is going, if it's going to zig or it's going to zag, or perhaps something new will be brought up that the judge will listen to. The main rules of civil procedure assures the defendant the right to conduct the discovery. If the defendant is willing to be denied certain personal liberties beyond the 21 days, the defendant says, I'll go beyond 21 days, subject to what the court has ordered. So my lawyer can be better prepared to defend him or her. Please, you must recommend this bill for passage by the legislature as a whole, I ask you. And one last thing, please. The case of Shaw versus Packard clearly states that, quote, the granting of a continuance, the statute allows the court to maintain the status quo by extending the effectiveness of any protection orders. And there may be one that's brought that the defendant can have no contact with the plaintiff going forward till the court orders otherwise. That order stays in effect if there's a continuance.
I need you to wrap up, sir.
I'm right there. You now hold the welfare of your constituents in your hands. Please don't deny them the assurance that they will be able to be fully prepared to defend their personal rights. I thank you for your attention and consideration of these concerns. I would say to you, be safe as you carry on your work on our behalf. It is appreciated by us out here. If there are any questions I might be able to answer for you.
Thank you very much, Mr. Rota. We appreciate you taking the time to both submit your testimony and providing oral testimony today. Are there members of the committee with questions for Attorney Rota? Seeing none, I again thank you very much for your participation in bringing this matter to the attention of the committee. Thank you, sir. I see on my list, I have nobody else testifying in support of the bill. Is there anyone in this electronic format that wants to testify in support of LD 291? Seeing none, I will go to those in opposition, and I have two people who have signed up, and I will take them in the following order. It will be Andrea Mancuso, followed by Julia Finn. And if there's anyone else who wants to testify in opposition or neither for nor against, please let the committee clerk know. Ms. Mancuso, welcome. It's good to see you again.
You as well. Good afternoon, Representative Harnett, distinguished members of the committee. My name is Andrea Mancuso. I'm here today on behalf of the Maine Coalition to End Domestic Violence and the various domestic violence resource centers across the state in opposition of LD 291. We urge you to reject the proposed language put forward by the original proposal and would be in favor of the amendment that I understand the Family Law Advisory Commission submitted in its written report back to you all. Overwhelmingly, most protection from abuse cases are in fact held within 21 days of the plaintiff having filed the complaint pursuant to the statute. But the law court has long held that the district court judges retain the discretion to evaluate requests for continuances by either party for a variety of good reasons and to continue the case where appropriate. In our experience, when the defendant has a legitimate reason brought forward to need more time, the district court judges are best positioned to be able to evaluate these requests in the moment given the individual circumstances of each case and liberally grant the requests of defendants in these circumstances. Setting out this single reason why a continuance beyond the 21 days can be granted would disallow other reasons. Both plaintiff and defendant often come forward with legitimate and compelling reasons on why a continuance is appropriate. The unavailability of a material witness on either side, the unavailability of an attorney on either side, life circumstances of either party. We would assert that the district court judges are best positioned to evaluate these circumstances in the moment with the litigants in front of them, and that restricting the judicial discretion in this one party, one manner way is really inappropriate. It would put in place a structure that is really ripe for abuse by defendants. I've provided a couple of circumstances that we see abuse by defendants already in obtaining continuances for this. Of great concern is the fact that temporary orders do not address financial needs of litigants, and defendants use this to their advantage in requesting continuances. You can't have a child support order, you can't have a spousal support order, you can't address restitution or the need to make a rent payment. It's also not unheard of for a defendant, through counsel or not through counsel, to try and obtain a continuance to promulgate harassing and inappropriate discovery in these cases. The district courts entertain those requests. They're able to evaluate the merit of the individual request in the moment. They're able to assess, is this a case in which it is appropriate for the defendant to be able to haul a plaintiff into their attorney's office and subject her to a deposition for 8 hours in the context of this summary proceeding. It's essential the courts retain the discretion to screen for these potential abuses and maintain the ability to respond effectively to the requests of either party in these cases. I'm happy to take any questions and would certainly be available for the work session.
Thank you very much, Ms. Mancuso. Are there questions for Ms. Mancuso from members of the committee? Senator Keim.
Thank you, Mr. Chair. Maybe for the work session, but just have you considered an amendment to this that would narrow it, and would that be something that you could support?
The amendment, we support the amendment that was put forward by the Family Law Advisory Commission. I'm not sure if you've seen it, but it essentially takes the holding of Shaw v. Packard and puts it in the statute to provide clarity to judges and to litigants and to members of the bar that the court retains the discretion to entertain requests for continuances. To the issue of discovery, which Attorney Rhoda referenced in his testimony, I can tell you that that is on the agenda for the Family Law Advisory Committee and the Family Rules Advisory Committee, I believe, to try and put some structure around that, because PFAs are not technically a family matter. The family matter has very good rules understanding the opportunity for harassment and abuse, that you can't seek discovery outside the scope of financial issues without establishing good cause to the judge. So in a family matter, you can't ask for things that could be embarrassing to a victim without asserting to the court, like, here's my reasons, here's what I want, here's why I want it. That same protection doesn't exist around PFAs. It hasn't been an issue. A PFA is a summary proceeding. And so to extend the final hearings for months, it really is outside the scope and purpose of the proceeding.
Thank you.
Does that speak to your question?
It does, yes, thank you.
Thank you very much. Are there additional questions for Ms. Mancuso? trying to close out some things here. Seeing none, thank you very much. We appreciate your testimony and your willingness to participate in the work session.
Thank you.
I will next call upon Julia Finn from the Judicial Department. Good afternoon, Ms. Finn.
Thank you. And I recognize that I am the only thing between you and lunch, so I will try not to take too much of your time. Representative Harnett, members of the committee, again, my name is Julie Finn, and I am here to testify in opposition to LD 291. As Ms. Mancuso just mentioned, district court judges who hear protection from abuse cases routinely receive motions for continuances in all matters. They receive these motions from both plaintiffs and defendants, and for a variety of reasons. District court judges also routinely grant these motions and deny these motions. The court's authority to dispose of motions for continuances in protection from abuse cases has been affirmed by the law court. And the case of Shaw versus Packard has been mentioned today. That was decided in 2005, and this very issue was argued in that case. And in that case, the law court ruled that the statute, which talks about the 21-day limitation, does not deprive courts of their discretion to grant a continuance of a final hearing, even over the objection of a party. The 21-day requirement ensures that defendants who may be subjected to substantial restraints on their personal liberty pending the final hearing, which and had been put in place by a temporary ex parte protection order, they will have the opportunity for a final hearing on an expedited basis. This case has been cited by the law court since 2005 on multiple occasions. In addition, a possible unintended consequence of this bill would be to create confusion over legitimate bases for requesting a continuance. The express mention in the statute of only one basis to be used by one party could be interpreted to exclude other good reasons for a continuance and other parties from making similar requests. Thank you for your time. I'd be happy to answer any questions if I am able to.
Thank you very much, Ms. Finn. You now have 2 minutes in the bank moving forward on future bills. There was mention of a proposed amendment put in by the Family Law Advisory Committee. Does the Judicial Department have a view on that proposed amendment?
Yeah, that amendment, I believe, assuming it's the amendment that I have seen, would be something that would be acceptable. In fact, there are times when the court rules on issues and it expands upon or it differs from a statute, and when the statute doesn't get changed, that can be confusing for the public reading that statute. In fact, a couple of years ago, it may have been last session, there was a bill about grandparents' rights, and that was actually, you passed that bill because the statute no longer reflected the current status of the law. And that does happen at times, and this may be one of those instances.
Thank you very much. Are there questions from members of the committee for Ms. Finn? Seeing none, thank you very much for your testimony. We look forward to seeing you again when you have all that time to squander with your bonus minutes. Are there any other persons on the electronic meeting who want to be heard either in support, against, or neither for nor against LD 291? Seeing none, before I close the hearing, I just want to ask Senator Stewart a question. Senator Stewart, have you seen the amendment proposed by the Family Law Advisory Commission?
Thank you, Mr. Chair. We have, and in reviewing it, we understand the goal of what they're hoping to accomplish with that amendment. By we acknowledge that there is an issue with the current language of the draft, sort of narrowing the scope of why continuances may be granted. That said, we are concerned that if the language is not more definitive in terms of of actually saying that it's not a may, it's a must, then we're right back where we are right now. And in some instances, some judges are simply never going to grant them. And so that is the issue. That is how we got here. And our concern is that unless there is stronger language, nothing's really going to change.
Thank you for that. And I obviously would not tell you what to do with your bill. I would encourage you before the work session, if you could communicate with FLAC to see if there is some language that you could agree on. It might make things easier for the committee moving forward. And again, seeing no additional individuals who want to speak on this bill and seeing no hands from committee members, I'm going to close the public hearing on LD 291. And the committee will begin its 1 o'clock series of public hearings at 1:40. I do want to give the committee a chance to take a break, and we will see you all back here at 20 to 2. And I would remind folks to shut off your microphone and shut off your video until we gather again. Thanks for all your work this morning. Good afternoon. Still waiting for a few more faces in our boxes. We're supposed to start at 1:40, but time is ephemeral in this building. So I'm going to wait for a few more, but thank you for those who did get back on time. Good afternoon to those who are tuning in on the YouTube channel. We're just waiting for members to get back from their break. We don't have enough faces to have a quorum yet, but we're getting there. Six. Okay, good afternoon. My name is Tom Harnett. I serve as the House Chair of the Judiciary Committee, and I welcome everyone to this afternoon's public hearings. We appear to have enough members to form a quorum. You will see members coming and going due to competing obligations on their time in front of different committees and different Zooms. We're gathered electronically today to invite public comment on proposed legislation. We have 4 public hearings this afternoon. It should provoke a lot of interesting discussion. Just a reminder, everything is being broadcast on Zoom. So if your mic is unmuted, everything you say will be heard. And everything you do, if your camera's on, will be seen. I just want to ask people, including members, that make sure the name on your box when you are testifying or participating as a committee member reflects who you are. We don't need Dad's laptop or Mary Jones or iPhone 6. At this point, I will ask the committee members to introduce themselves. And again, I'm going to call on them in the order that they appear in my participant list. Representative Laura Libby.
Good afternoon. Thank you, Mr. Chair. I'm Laura Libby. I live in Auburn and I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Poirier.
Thank you, Mr. Chair. Jennifer Poirier, and I represent District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Sheehan.
Thanks, Mr. Chair, and good afternoon, everyone. My name is Erin Sheehan, and I represent House District 12. That's downtown Biddeford.
Thank you. Representative Babbage.
Thank you, Mr. Chairman. My name is Christopher Babbage. I represent House District 8. I have the privilege to represent the town of Kennebunk.
Thank you, Representative. Representative Reckett.
Thank you, Mr. Chair. I'm Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Representative Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you. Representative Downs.
Thank you, Mr. Chair. Good afternoon. I'm Kathy Downs. I represent District 130, which is Bucksport and Orrington.
Thank you. Representative Hagan.
Thank you, Mr. Chair. I am David Hagan. I represent House District 101, which includes Hamden and Newburgh.
Thank you, Representative. Senator Sanborn.
Thank you, Mr. Chair. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And last but certainly not least, Representative Moriarty.
Thank you, Mr. Chair. Welcome everybody to the afternoon session. I'm Steve Moriarty, representing Cumberland and part of Gray in House District 45.
And again, my name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. A few reminders as we start this afternoon's meeting. Again, we're using an electronic platform. I cannot guarantee many things in life. I can guarantee that something will go wrong at some point electronically as we navigate through the afternoon. We are going to be conducting 4 public hearings, and for each bill, I will introduce the bill. I will then call on the sponsor and co-sponsors to speak first. When they are called upon, they will be promoted from attendee to a participant. They will then return to attendee status after they are finished speaking and being questioned by the committee. I will then turn to other legislators who might be interested in testifying. Then I will hear from people for the bill, against the bill, or neither for nor against the bill. And each person will be available for questioning by the committee members. Reminder, this is being broadcast on YouTube and can be heard, and everything is saved for posterity. In terms of timing, the sponsor of the bill has no time limitation on presenting the bill and their testimony. However, all persons speaking after that have 3 minutes to speak. I will let you know that will start when you begin to speak, and you may hear a beep at the end of 3 minutes, and then I will gently remind you to try to wrap things up as quickly as possible. And I failed to do this morning. I should have introduced our outstanding committee clerk, Supi Panett. She may show up there and give a little wave. She's apparently in Greece, outside of some temple. And our analyst, Peggy Reich. They are the people that actually make these things happen. So the first bill we have before us this afternoon is LD 310, an act to establish equitable education requirements for judges. And I am pleased to recognize the former House Chair of the Judiciary Committee and now Senator Donna Bailey. Welcome.
Thank you, Mr. Chair, and welcome everyone. Representative Harnett and esteemed members of the Judiciary Committee. My name is Senator Donna Bailey. I represent Senate District 31, which includes the communities of Saco, Old Orchard Beach, Hollis, Leamington, and part of Buxton. I'm here to introduce LD 310, which is an act to establish equitable education requirements for judges. You may have noticed that this was submitted as a concept draft. It is my understanding that Judge Crockett, who will be testifying after me, does have some language for the committee's consideration. The concept behind this bill was to bring the CLE, the continuing legal education requirements for probate court judges, in line with the requirements for district and superior court judges, both in the requirements and also in terms of recognition that those CLEs the mandatory CLEs that they would do as a judge would be credited towards their CLE requirements as an attorney. As members of the committee know, probate court judges are also, or can be, practicing attorneys as well as being part-time probate court judges. So I am going to yield the majority of my time to Judge Crockett, who is going to give a little more detail. They tried to accomplish this by rule change. So if that's one of your questions, why didn't we just do this by rule? But apparently it does require a statutory change because it will be requiring the probate court judges to attend CLE the same as the district and superior court judges. So we do need to put something in statute in order to do that. So I am happy to answer any questions, but I would again defer most of those to Judge Crockett.
Thank you, Senator Bailey. Are there any questions from committee members for the good senator? Seeing none, thank you very much for introducing the bill. And before I call on Judge Crockett, I will point out that because and I've been in this position before, he's really the one presenting the bill, he will not be subject to the 3-minute time limitation before he is in a position to answer questions from the committee. So with that, I would call on Judge Jared Crockett. Is Judge Crockett with us? I see him muted and without a camera on.
Okay, am I visible?
You are visible, yes, and you are loud and clear, and we welcome you to the Judiciary Committee and welcome your introduction of LD 310. Thank you, sir.
Thank you. Again, my name is Jared Crockett. I'm a resident of Bethel. I have the honor of serving as the probate judge for Oxford County. Today, I'm obviously coming forward to support LD 310, an act to establish an equitable education requirement for judges. First, I'd like to thank Senator Bailey for sponsoring the bill, along with Senator Keim and Representative Millett as co-sponsors. Also, I have to put a special thanks to Peggy Ranch, who provided the technical drafting of the amendment, although there was a minor change that I added. So if there's any credit to be given, give it to Peggy. If there's any fault, I happily shoulder it. And I also want to mention to Soupy, I understand I'm running a tab for treats that I have to bring back to the committee. So I want to make sure that's clear. The goal of LD 310, to get more to the heart of the matter, is to treat probate judges similarly to district and superior court judges with regard to continuing legal education requirements. Currently under Maine statute, probate judges are not required to fulfill continuing education requirements in a similar manner as district and superior court judges. Part of this is a result of the fact the probate courts were created in Maine's Constitution in Article 6. So the probate courts are courts with equitable power, exercising jurisdiction over certain types of cases, but are funded by the county governments, not the state, which has a consequence. The last portion also means the probate courts do not operate under the supervision of the judicial branch. Now, that being said, before anybody gets too worried, the decisions of probate courts are appealable to the law court, as any judge's decisions are in the state. And the 16 probate judges in the state are also subject to the judicial canons, as well as oversight by the Judicial Responsibility and Disability Committee, the respective county commissioners of their counties, and voters every 4 years. So there are layers of oversight to provide protection from a potentially rogue probate judge. So even though that doesn't have oversight from the judicial branch, there are still protections in place. Also, while I'm testifying, I want to offer my apologies to the committee. I'm actually on vacation, so I'm not in my normal office doing this. So my technology may be spotty, so forgive me in advance. So currently, probate judges are required to satisfy the same requirements as all other attorneys under Maine Bar Rule 5, which is, except for legislators and ironically judicial law clerks, they're exempt as well. But the requirements of Maine Bar Rule 5 specifically remove state court judges. And so it doesn't touch the county judges, just state court judges. And as some of you know, some of the probate court judges are actually full-time, and by statute, we actually are in continuous session because we're on call. Even on vacation, I have to deal with certain matters of the court. But that's just part of the full-time language in the Bar Rule 5, but the state court portion is what the key issue is. Now, we're able to satisfy these CLE requirements through any number of courses. A probate judge could take a CLE in maritime law, immigration law, any sort of subject that isn't even pertinent to the probate court themselves. So, or its areas of jurisdiction. So what LD 310 would result in would be probate court judges being exempted from Maine Bar Rule 5, just as the other district and superior courts, but we would be required to take the same continuing education requirements as the state court judges. Now, this may seem like a small step, but it's actually a large leap in some of the reforms that this committee has been seeking over the years. It works towards that concept of uniformity in all the courts, because with the education of the probate judges, you will end up having courts that are more similarly run. And that's one of the goals. It also would make potential transition to the state court system more, a little more gradual and with far less resistance. So it also is novel in the sense that the judicial branch has never been able to exercise control of the probate courts. And this would be the first small step the judicial branch would be able to have some input onto the training required by probate judges. So it's actually a very dramatic shift from the current status of the law. During past legislative sessions spanning decades, this committee has been asked to alter the manner in which probate courts have operated or are comprised. This bill represents a step the majority of the probate court judges, members of the assembly, agreed was appropriate. This is a big shift in time. Now, we initially sought to amend the rule through the law court, which has oversight of the rules, and the Supreme Judicial Court can amend them. But that's not possible in this case. While they can exempt us, they cannot require us to take the training that other courts do. In the past, the court has been reluctant to get too involved with the probate courts. When I was on this committee, that was always a unique situation. But there has been a lot of effort, and I know members of this committee have been part of this over the last few years, to see some sort of updating of the probate court, because it is a little bit of an outlier. However, this is a step, and it's a significant step. So if it's something this committee would like to entertain, the Probate Judges Assembly would like to be a part of a solution as opposed to being an obstacle to some of the reforms that could possibly happen. So I'm summarizing because I understand this committee is obviously behind today, and I've been in your shoes before, and so I don't want to prolong the process. In summary, this bill is amended as a step to the direction in the direction sought by the previous judiciary committees, and likely bears very small expense The result would be more uniformity, standardization, and a degree of input from the judicial branch, which does not currently exist. The probate courts are receptive to the imposition of this new requirement in hopes of making all the courts of Maine better for the good people who live here. Thank you for your time and consideration, and I'll answer any questions or make myself available. I'm not sure if Judge Mitchell, who is the president of our assembly, will be speaking today, but I offer whatever help I can.
Thank you very much, Judge Crockett. Thank you for taking time out of your vacation to testify in front of the committee. We appreciate your participation. Are there questions from the committee for Judge Crockett? Representative Moriarty.
Mr. Chair, Judge Crockett, very, very good to see you again.
Pleasure's all mine.
We served together in one memorable session. Just a quick question, which reflects my own lack of knowledge, I guess, is whether are there CLE programs designed just for judges, or are you proposing to attend the same kind of CLE offerings that the bar in general attends?
No, judges have their own studies. In fact, some probate judges, there's a judicial college that puts on these seminars around the country, dealing with rules of evidence, how to handle trials. There's a lot of that. And right now, the probate judges that attend those suffice for our CLE credits. We can take those classes now at our own expense, or in some cases, our counties pay for them, and they count for our CLE requirements. But if a probate judge doesn't want to, they could take whatever, and I'm sure that we've all had those times where we had to make up a CLE in a hurry and we took whatever was available.
Mm-hmm.
And sometimes they're completely unrelated to our practice, but they were quick. Well, that's still a possibility. But what we want to see is the probate judges become a more professional group. I'm not saying that there's anything lacking now. I'm just saying raising the bar, implementing more standardization, having the judicial branch have some say and some ability to direct and control. It's not necessarily a bad thing for the eventual transition, which you were on the committee last year, and you know about the 1967 amendment to the Constitution that to the state constitution allows for the courts to eventually be the segue to be rolled up into the judicial branch, which we've been unable to do for 200 years. But we're not even making progress. Every time there's a step, it gets wiped out because for one reason or another, unfunded mandate language or something, it's just not able. This is the cheapest way that we can accomplish something, but you're also giving some of the judges, the probate judges, recognition of saying, okay, you're a judge, we're going to treat you, we're going to exempt you from CLEs like legislators were, like other judges are, but there's also a sense of responsibility that goes along with that, because now you're going to have a new type of class you are going to be required to take in place of those. We can technically kind of do that now, but not every county is required to. And the fear is those counties that aren't required to are not going to. So we want to have some standardization, some uniformity. So that's the goal. And if this, I don't want to seem like this is a life or death issue. If the committee doesn't care and says this is not a necessary issue, I understand that. The legislature has a lot of other issues that are coming up this year, but we want to be proactive. We want to be helpful in this process. We know there's going to be a commission coming up or some attempt to do a study group again. We want to see progress. We don't want to stand in the way. So yeah. I know it's a long answer. Sorry.
Well, I commend you for your being proactive. I think you're on the right track. Thanks very much. And good to see you.
Yeah.
Thank you, Representative. Next representative I see, member of the committee, is Representative Reckett.
Hi, Judge Crockett. I have just one clarification. Currently, the probate judges are paying for their own training, or the county is paying for it, or whichever. Somebody's paying for it.
In some cases, the counties do. In some cases, if one of the judges just wants to take a normal CLE the bar offers, we can pay out of pocket. In some counties, they'll reimburse. So it's county by county.
Okay, so the reason I asked that, because it seems to me then that if we're eliminating that necessity, and thereby saving either the judges or the county or somebody money, it seems to me that mandating to do this other training is not really an unfunded mandate in the grand sense of the word, because you're absolutely substituting one set of training requirements for another. Would that be accurate in your view?
It's my hope that you are accurate. I am not sure there won't be those who would take the contrary position, because if a fiscal note were going to be generated, right? If the state is required to pay and absorb us into theirs, then yes, it'd be a fiscal note. If it's just a requirement, and if the counties say, well, we're already paying, some of the counties are already paying for this expense, so it's not really any additional cost, right?
Mm-hmm.
Our hope is that it will pass on those grounds. I guess someone could make the creative argument that it is an unfunded mandate, but I'm trying to help to get some reform at the lowest price. So I wish I had a great answer for it, and hopefully when the fiscal analysis is done, that we manage to bypass that. So
thank you.
Thank you, Representative Breckett. Representative Hagan.
Thank you, Mr. Chair. And at the risk of unimpressing everybody, I really don't know anything about this. I'm a teacher. Every 5 years, I have to have 90 hours of training to keep my accreditation. Is there a requirement for hours or credits that you'd have to, that we would be approving, or a minimum amount?
what our proposal is whatever the judicial branch requires of the district and superior courts, we're basically subjecting ourselves to that, which is a dangerous premise, because right now we can do our CLEs as attorneys and get our credits that way and satisfy the same requirements as all other attorneys. So by us subjecting ourselves to what the same requirements of district superior court judges have, we're actually sort of opening up a gateway. We could really not like the result in this, depending on what the judicial branch comes down with. But it's a self-imposed improvement we're willing to subject ourselves to. But again, that's why if the committee elects not to go in this direction, it's not going to hurt us at all. So,
all right, thank you.
Thank you, Representative Hagan. Are there any other questions from members of the committee? Seeing none, Judge Crockett, I want to thank you for, again, taking time out of your vacation to testify today and providing us with this helpful information. Now go back to whatever it is you were doing on vacation. Thank you.
Sounds good. Thank you for having me.
And I noted after our introductions, I believe we were joined by Senator Keim. If Senator Keim is still here, if she would like to introduce herself. Perhaps it was a fleeting moment. Are there any other persons in the electronic meeting that would like to testify in favor of LD 310? Seeing none, I will ask, are there any persons in the electronic meeting that would like to testify in opposition to LD 310? Seeing none, I will ask if there are any persons testifying neither for nor against LD 310, and I do have one person on that list, Julia Finn. Welcome, Ms. Finn.
Hello, good afternoon. And I hope to be adding to my my bank of time this afternoon.
You're at 2 minutes and 7 seconds. So
I think you all know who I am, Representative Harnett, members of the committee. I just put in some quick testimony, neither for nor against this morning. I honestly don't know what the position of the judicial branch will be at this point. The Supreme Judicial Court would very much like to discuss this proposal, and they have not yet had an opportunity to do that. You know, I very much appreciate the efforts of Judge Crockett and Senator Bailey and Peggy, I think, who did get me a draft yesterday afternoon. However, the court just has not had a chance to really review it in depth in time to provide meaningful comments or assistance to the committee, which we would very much like to do. So I'm, I guess, asking for a little bit of indulgence and hoping that I can submit some testimony at a later date or at the work session, because we would very much like to be involved in helping you with this bill. I just can't do that right now.
Well, thank you, Ms. Finn. And absolutely, we welcome the testimony of the judicial branch, so we will make that accommodation. Do you have any idea when the powers that be might be able to meet to discuss this issue? And I only ask that because we'll be scheduling a work session.
I imagine that we could certainly get to something next week at a work session if you schedule one.
Okay.
Thank you very much for accommodating my request.
You're very welcome. Any questions for Ms. Finn? Seeing none, this does not add to your time bank because you did not provide testimony. So don't think that you've racked up some more time today. But thank you for being here, and we look forward to your testimony or input when we're at the work session. Are there any other persons in the electronic meeting that would like to be heard on LD 310? I would ask the committee clerk if she is hearing from anyone.
Yes, actually, I see Leo Delicata is looking to be promoted. Would you like me to do that?
Absolutely. Is he neither for nor, well, I guess he will tell us where he's.
I'm losing it. Where did he go? No, I stand corrected. He has disappeared from my attendee list.
Okay.
Oh, there he is. There he is.
Mr. Delicata.
Representative Harnett and members of the committee, my name is Leo Delicata, and I am an attorney with Legal Services for the Elderly. I did not provide any testimony on this bill because it was a concept draft and we really had no idea what it was about. But having heard the discussion and having heard the testimony, both from the sponsor and from Judge Crockett, I want to very strongly support this effort. I think that it is a very forward-thinking step taken by the probate judges. I think that Judge Crockett has been extremely helpful in the past in terms of thinking and trying to take steps forward to do what the Futures Commission with Harriet Henry did many years ago in wanting to eventually unify the probate and the judicial branch judges. And I think this is an extremely important and generous step forward. So I couldn't be more happy and I couldn't be more supportive of this. Thank you.
Thank you very much, Mr. Delicata. Nice to see you again.
Good to see you too.
Are there questions from committee members for Mr. Delicata? Seeing none, I thank you very much for your testimony, and the committee appreciates you taking the time to offer it today. Are there any other members in the meeting, individuals in the meeting that would like to be heard? Seeing none, I will now close the public hearing on LD 310, and we move on to our next bill. The next matter that we are considering is LD 345, an act updating certain probate filing and certification fees to reflect current costs. And that bill is being presented by a committee member, Representative Lois Reckitt. Representative Reckitt, welcome.
The miracle is my electronics resuscitated themselves, not the computer, but everything else in midstream today.
Don't jinx yourself, please.
Yeah, I shouldn't, particularly on a day when I'm having my second vaccination. So I'm going to disappear at some point mid-afternoon here, and you'll have to forgive me, but I shall be immune at the end, or 2 weeks from now. Good afternoon, Representative Hartnett and fellow members of the Judiciary Committee. As most of you know, my name is Lois Galgay-Reckitt, and I represent House District 31, which is part of South Portland. I'm here before you this afternoon to introduce LD 345, an act updating certain probate filing and certification fees to reflect current costs. This bill would make updates to certain probate filing and certification fees. I submitted this bill at the request of a Cumberland County Commissioner and actually on behalf of the County Commissioners Association. And I believe the requestee is here with us today to explain why these updates are needed. I'm not sure it's actually Commissioner Gordon who's going to speak after me. I believe it's Kathleen Ayers from the Kennebec County Probate Court. And it was from her that I discovered that these fees have not been updated since 2005, which is really a long time. If you're looking at the bill, it has the schedule of what would be, it's obviously on a graduated scale depending upon the size of the estate that's being probated. And I'll leave it there and ask you to be liberal with Ms. Ayers, who has way more substance than I do on this issue. Thank you very much.
Thank you very much, Representative Reckitt. Are there any questions from members of the committee for Representative Reckitt? Representative Poirier.
Thank you, Mr. Chair. And Representative, is this the same list that went out to from all of the commissioners from the probate?
I believe so, although I didn't send it to me. So how about that?
Okay.
So I
just
have a
asked
list,
because
yeah.
I actually submitted a bill with the same fees, so I'm very supportive of your bill. It was brought to me through the Somerset County, and I was told that these fees have not been updated for 15 years.
Yeah.
So it's very important.
Yeah, I agree.
Attend to this. So thank you.
I suspect they're exactly the same as the ones you have in your hand.
Okay.
Thank you, Representative Poirier. Are there other committee members with questions for Representative Reckitt? Seeing none, thank you very much for introducing this piece of legislation, and good luck with your the rest of your afternoon.
Yes, but, of course, I've now disclosed my age range anyway by telling you I'm off today in the 1A category of vaccinations. But
well, your secret is safe with us and the YouTube universe, so there's
That's right.
Nothing to be concerned about. I only have one person on my list of people testifying on this bill. It is listed as neither for nor against, but I have a feeling it might be in support of. And I would like to call on Kathleen Ayers.
Yes, can you hear me well?
I hear you very well.
Okay. Yeah, I am definitely in support of this. The fees welcome Honorable Representative Harnett and honorable members of the judiciary. I'm very glad to be with you today and always. My name is Kathleen Ayers for the people on the internet, and I am the Register of Probate from Kennebec, and I'm also the president of the Maine Association of Registers of Probate. I want to thank Representative Reckitt for sponsoring the bill, and I want to also thank Representative Poirier for being willing to help us as well. The Fees Committee of the MARP has reviewed our current fees and is asking for a moderate increase. The duties and responsibilities of the probate court have expanded, and expenses and costs have all grown, making the portion of the revenues that goes back to the county to reduce the property taxes smaller and smaller. Fees have not been adjusted since 2005, the same year the tax cap passed, which we are still under. And counties do not go above the tax cap without a major issue. Also, county budgets, you know, are the bus for the funding is driven by the JUD, by the jail. The jail funding issues in the last few years have always, we have always had to give some of our budget towards the problems that have happened with the jails. The opioid crisis, the pandemic, the economic downturn, there's always cases of indigent litigants who will require services paid for under statutory guidelines. Costs for court-appointed attorneys, guardians ad litem, waived filing fees, service costs, as well as transcripts, some specialized medical experts and interpreters, all paid for by the counties. Since 2005, the legislature has added child support to our minor guardianship duties, increased responsibilities, and I guess I should have put in here, of the new uniform probate code, have increased the number of required hearings in guardianship conservatorship cases. They have required tracking and yearly reports on every case, which is a new concept, really, because in the old days when Jim Mitchell was our judge, he would always tell people, you have guardianship of this adult or child, and unless you have a problem, then you come back to the probate court, but no longer. We are tracking everything. So this also does not include the increased processes bestowed on us on the probate courts by the Supreme Court rules. You know, all expenses have increased in areas from the cost of stamps from 37 cents to 51 cents, and the court-appointed attorneys, which are now in the range of $60 to $70 an hour. As always, I will provide information for the works. Feel free to ask me for questions. I did include some spreadsheets of my own budget, which really show what we all know. Our personnel is our most important piece and part of our budget. The second largest is always the legal services, and it's a valuable resource. And I also, if you have any questions about these, the fees themselves or what they're about, I would love to answer them. The most important fee I think on here is a subsequent formal proceeding, which we're only asking $50 for that. And those are contested matters or problems with guardianships and conservatorships that have to go to hearing, have to have judge approval. And for $25, it was a bargain. And I think that's the most important thing that needs to go up. And they've recommended 50, and I would even perhaps go farther than that. But I really appreciate your patience and your time. And like I said, I'd be glad to answer any questions, and I will bring any information I can gather for you to the work session.
Thank you very much, Ms. Ayers. It's nice to see you again. Are there questions from committee members for Ms. Ayers? Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Ms. Ayers. My question is, and you may have said this and I could have missed it in looking at all the fees, but what if this went through as proposed? Or do you have any numbers as for what this would do to your budget, which I can see the numbers here as they currently stand? Is there any information?
I had my spreadsheet guru, which is my friends from Waldo County. They have a smaller county, so they went through their budget and their last year's budget and increased the fees to what they would be. And she said in Waldo County, it would mean a 45% increase in the revenue that goes to the county.
Okay, thank you.
Yep.
Thank you, Representative Libby. Are there any additional questions from other committee members for Ms. Ayers? Seeing none, I want to thank you for your time today and for your presentation, Ms. Ayers, and we look forward to working with you at the work session, which will be coming up shortly.
Great. You all have a fabulous day.
Thank you very much. Those are the only persons that I had signed up to testify on the list that was provided to me before we started this afternoon's session. I will ask the committee clerk if anybody has joined us that she is aware of that is interested in testifying.
I do not see anybody else, Mr. Chair.
Thank you very much. With that, I will now close the public hearing on LD 345, and we will move on to our third bill of the afternoon, which is, let me just get this up straight, which is LD 331. No, I'm sorry, it's LD 366. No, it is, sorry about that. It is LD 366, an act regarding emergency guardianship. And our sponsor is Representative Jay McCrate.
Thank you, Representative Harnett. It's nice to see everybody in Hollywood Squares and people I've never met, which is because we're not there in the building. So nice to meet you virtually. Shall I go ahead, Representative?
Yes, yes, please. Welcome to the Judiciary Committee.
Thank you. Representative Harnett, esteemed members of the Judiciary Committee, I'm Jay McCrate, representing House District 51, Harpswell, West Bath, and Northeast Brunswick. I'm here today to present LD 366, as mentioned, an act regarding emergency guardianship. The bill before you proposes a follow-up step to help address a serious problem we began work on during the last legislative session. In the 129th, the Judiciary Committee heard and unanimously passed LD 1229, a resolve to establish the committee to study and develop recommendations to address guardianship challenges that delay patient discharges from hospitals. Quite a mouthful. Though the study did not come off the study table, the work still happened, thanks to the dedication and commitment of our long-term care ombudsman, representatives of the Hospital Association of Individual Hospitals, DHHS, Disability Rights Maine, Legal Services for the Elderly, the probate court system, and others. Senator Bailey and I were both invited to participate as well. I want to back up a little bit and describe the problem. This is about adults who are stuck in hospitals. Even though medically ready for discharge, these are individuals who cannot be discharged due to guardianship challenges. They can be stuck for months or longer. We're talking specifically about cases where there are challenges and barriers that prevent satisfactory resolution of guardianship. This is a problem that has been intractable, even though there have been efforts over several years to resolve the problem. The committee established by LD 1229 met regularly over the months since, working together to tackle this tough problem. Those specific solutions, such as a path to apply for main care when that's a barrier, and specific steps to improve communication among all those involved, were tackled. It's clear from feedback among committee members that the problem remains largely unresolved. Adults are still stuck. I want to stress that these efforts were not wasted. It's just that we need to do more. Certainly, no individual is the same. No situation is the same. No one solution will fix it all. Of course, the need for more capacity for the appropriate level of care is clear, but what I propose to you is an important step we can take right now as we work on other longer-term solutions. When we do have an appropriate placement, or what we often call a bed, we need to be able to act as, and if the barrier is unresolved guardianship, the proposed change will help. Being stuck in the hospital is not good for anyone, and it needs to be clearly identified as creating harm. I'm proposing that we establish in statute that the delay of discharge of an adult patient who is medically ready for discharge, but who has guardianship challenges delaying that discharge, creates in itself a situation of substantial harm. By doing so, we establish that this situation meets an important criteria for appointment of an emergency guardian. The probate court code would then recognize that the situation described here constitutes substantial harm. This language would provide clarity for probate judges that these cases must be scheduled promptly on the court docket. All other legal aspects of appointing an emergency guardian for a hospitalized patient remain unchanged. Thank you for your attention, and I'll do my best to answer any questions.
Thank you very much, Representative McCreight, and thank you for bringing this back after we saw it in another iteration in the 129th. Are there questions from committee members for the bill sponsor, Representative McCreight? Representative Moriarty. Representative Moriarty, you're on mute.
Whoops.
Did we lose Representative Moriarty? While we try to recover the good representative, I will recognize my Senate Chair, Senator Ann Carney.
Thank you very much, Mr. Chairman. Briefly introduce myself. I'm Senator Ann Carney. I represent Senate District 29. And I did have a question for the bill sponsor. Representative McCreight, could you give us a real life example of how this problem plays out?
There are people following me who I know are planning to give you specific examples. If that's okay with you, we could have them do that. But just in general, I'm aware of people stuck in this situation over a year. And it's a situation where there are lots of reasons why guardianship has not been able to be established. And as I said, some have, the work group that met resolved some of those, but at the last meeting, there was not an official poll, but a discussion of, has this made a significant difference? And the answer was no. In certain areas, it's made it a little smoother, but we still have people stuck. It could be a situation where the family is not in any position to offer guardianship, or not available, not able. So it becomes an issue for the probate court to deal with. But again, those coming after I know they have specific examples to share.
Thank you.
Thank you, Senator Carney. And it appears that Representative Moriarty has returned.
Moriarty. Thank you, Mr. Chair. You know, you predicted that something would go wrong, and I wanted to make sure that your prediction was not unfounded. So I deliberately jinxed myself here.
Well, you're assuming I didn't kick you out of the meeting, but
yeah, it's a big assumption. I think my question is probably the same as Senator Carney's, and it's just that I was not part of the process from last year or the 129th, but I'm unclear from this brief excerpt from the probate code as to what sort of patient we are talking about. So if someone else is better suited to answer that question, that's fine, but that's what's unclear to me at this point.
Thank you. Yeah, I think that you'll have some better help on that. But in the work group that was meeting, we did talk about the specific situations, and it's it's a range of issues. It's someone who, for a variety of reasons, needs guardianship. And as I mentioned, it might be to be able to get their insurance coverage straightened out. And that was an easier thing to resolve. But what we talked about in the 129th when this bill came forward was that this has been an issue ongoing. And even though the groups have talked to each other, we weren't solving the problem. So let's get everybody around the table. And when it started, we were actually around the table in real life. And then it became by Zoom. And different things were tried, different forms were developed, and it still continues to be a problem.
Thank you. Are there questions from other members of the committee for Representative McCreight? Seeing none, I want to thank you very much for presenting this bill, and we look forward to working on it together with you moving forward. Are there any co-sponsors of the bill that are interested in testifying? Seeing none, are there any members of the legislature who are interested in testifying? Seeing none, I will move on to those who have signed up to testify in favor of the bill, starting with Christopher Wellens of Maine Health. And just so people know when they're going to be called, it will be Mr. Wellens, then Jeff Austin, and then Lisa Harvey McPherson testifying in favor, and then we will turn to those who are opposed. So if Mr. Wellens could be made a panelist, that would be wonderful.
I think I'm all ready to go. Can folks hear me okay?
Yes, we can.
Great. Senator Carney, Representative Harnett, and distinguished members of the committee. I'm Dr. Chris Wellens, Senior Medical Director of Utilization Management at Maine Medical Center and an internal medicine physician with Maine Medical Partners, Cape Elizabeth. I'm here to testify in strong support of LD 366. Currently, Maine Medical Center has 16 patients that have been cleared for discharge, but due to a lack of guardian and/or a lack of MaineCare long-term care coverage, are unable to be discharged to the next appropriate level of care. These patients have a length of stay ranging from 20 to 257 days for a total length of stay of 1,563 days. 8 of these patients will require state guardianship, and their stays range from 20 to 150 days for a total length of stay of 680 days. It takes on average 3 to 4 months until a petition for non-emergency guardianship can be granted by the probate court for a patient who's deemed to lack capacity. Ultimately, this means that a patient cannot be discharged from the hospital for 5 to 6 months or longer until guardianship is granted, and then MaineCare long-term care coverage is in place, and finally, an accepting long-term care bed is identified. To keep patients who no longer need acute care in the acute care setting is not patient-centered care. Acute care hospitals are not designed, equipped, or staffed to best deal with the needs of patients who require a long-term care setting. Being in an ill-equipped milieu is extremely stressful for the patients and the staff who are trying to care for them, and it is not uncommon for us to see patients regress both physically and psychologically. I'd like to share one patient's story with you, and I know her story well because I was her primary care provider for over 15 years. After a medical episode, my patient, who had multiple chronic conditions, was hospitalized, and her care team expressed concern that she lacked decision-making capacity. She agreed that things were not going well at home and expressed a willingness to go to an assisted living facility if she could bring her small dog. Despite having a living family, due to certain circumstances, none were willing to assume guardianship. Over the course of 70 days, her care team worked tirelessly to arrange a guardianship study and to secure the necessary information to complete a MaineCare long-term care application. At the same time, my patient's health rapidly declined, and I firmly believe that it was as a result of being stuck in an inappropriate care environment for a prolonged period of time. The care environment took her away from her beloved dog and was not suited for a patient who was used to being ambulatory. She spent more and more time in bed and developed painful medical complications as a result. After 70 days in the hospital, my patient's health declined to such a point that she was discharged to a hospice house. Days later, she passed away. Her life was unnecessarily shortened by this system failure. I have personally participated in the work group approved by this committee last session to study the issue of guardianship, and I appreciate the commitment of the members of the work group. But progress has not been made. We have patients languishing in our hospitals that are not being cared for in the appropriate setting, like my patient I just described. I urge this committee to set a standard that some probate courts use, but not all, and clarify that a patient in a hospital whose discharge is delayed until the appointment of a guardian constitutes substantial harm so that we can avoid more tragic stories similar to that of my patients. Thank you, and I'd be happy to answer any questions that you may have.
Thank you very much, Dr. Ellis, and thank you for presenting your testimony to the committee this afternoon and for all your work in advance of this bill being introduced. Are there members of the committee with questions for Dr. Wellens? The first hand I see is Representative Laura Libby.
Thank you, Mr. Chair, and thank you, Dr. Wellens. I'm actually not sure if Dr. Wellens is the appropriate person to answer this question, and I'm happy to delay it if there's someone more appropriate. My question is, if you could speak to the reason that that not having the appointment of the guardian done before discharge, why that would delay discharge?
Sure. So there are two reasons. One, patients who lack capacity cannot apply for long-term care coverage, which they require to be placed in a long-term care facility. So until there's a guardian, that care cannot be applied for. And the other is that facilities, for the most part, will not accept a patient for long-term placement if they lack a guardian, as well as lacking a payment source.
Thank you very much.
Thank you, Representative Libby. Representative Moriarty.
Mr. Chair, Dr. Wellens, I need some guidance in terms of understanding which patient the situation applies to. Is it the situation that a patient comes in and is hospitalized for some reason, and that during the course of hospitalization for treatment, that person's competency is challenged or problems become evident?
Yes, I think it's a little bit, it goes both ways. There are certainly people, who are marginally functioning in the community,
Yes.
who probably lack capacity, become ill. And it's fairly obvious early on that the capacity is going to be a discharge issue. There are other people who, as a result of an acute illness, say a brain injury or something like that, clearly had capacity before coming in, but will not have it moving forward.
Okay, all right. If I could ask a follow-up then, what rights does such a patient have to determine his or her own discharge, and what obligations do you, as the hospital, in turn have?
So I'm clearly a physician and not an attorney, but
Right.
I can explain. If a patient wishes to leave the hospital and the hospital feels that they lack capacity to make that decision, the hospital will keep the patient here until such a determination can be more formally made.
And you can do that legally
That is my understanding.
against a person's will.
Yes.
Okay, I'll pause there. Thank you.
Thank you, Representative Hagan.
Thank you, Mr. Chair. And I apologize that I missed your last answer, writing down my question, and you might have answered it already. Are there risks involved in assigning an emergency guardian? Someone who may take advantage of the patient?
I guess I'm not sure how to answer that question. I think from my perspective, the benefits to the patient outweigh the risks. The risks are being in a care setting where they can be harmed, as I have illustrated. I suppose a temporary guardian could do something that was not in the interest of a patient, theoretically.
Thank you.
Thank you, Representative. Representative Libby.
Thank you. So this is a follow-up to my previous question as I've thought about it. So can I just clarify, if a patient was admitted to the hospital, say they had been living on their own and during their stay they were found to be it was a question if they had capacity to make their own decisions, but they already had main care or some other form of insurance, then this would not apply to them. Is that correct? This would only apply if they didn't already have some sort of insurance and way to be admitted to the long-term care facility. In that case, could they be discharged and then this continued to be followed up in the long-term care facility?
So the main care coverage and main care long-term care coverage are actually separate entities. So, you know, many people in the community have main care, but those folks with main care still need to specifically apply for the main care long-term care coverage to be able to go to a facility for long-term care.
Okay, so if they were coming from home versus a long-term care facility, that's the issue, that they wouldn't have already had that.
That's correct. If they're coming from a long-term care facility, then more than likely they already have that. They either have their own finances or they have long-term care coverage.
Thank you for clarifying.
Thank you, Representative Libby. Representative Babbage.
Thank you, Mr. Chair. Excuse me. Dr. Wellens, could you clarify for me? I mean, I understand the inappropriateness, to say the least, of having a person languish for a long time in an acute care setting, with all those resources available but not necessary, and taking a bed and all that. But can you help me to understand? You also mentioned that it would be better for the patient to be in a long-term care facility. Are you talking medically? It would be better for the patient. I mean, I am aware of people that have gone in for the usual type of thing, like a fall, and then with a prolonged hospital stay, they may have developed bed sores, they may have developed MRSA, those kinds of things. But I wanted you to specify if the medical well-being of the patient is better served by going elsewhere. Not just the mental, but the medical.
Right. Yeah. So, I mean, I think in considering this population of patients, we're sort of talking about folks who we feel that their acute care needs have been met. So from that perspective, I would say, I mean, I'm not sure that it's medically better for them. I mean, I guess in the case of my particular patient, who stayed in bed too long and developed painful complications of that, it would have been better for that person to be in a setting where she was able to wander around and have her clothes on and perhaps have her dog staying with her. So yes, clearly there are psychiatric advantages, and I think that there are medical advantages too, even though the level of care is what would be considered to be, lower.
Thank you.
Thank you, Representative Babbage. Are there any additional questions for Dr. Wellens? Seeing none, I thank you very much for your time and testimony today, Doctor.
Thank you.
The next person on my list testifying in favor of this bill is Jeff Austin of the Maine Hospital Association.
Good afternoon, Senator Carney, Representative Hartnett, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association to testify in support of this bill. We very much appreciate that Representative McCrate filed it on our behalf. I have submitted written testimony to you, and I hope you've received it. This is the toughest issue hospitals face, period. And it's really not even close. I've been lobbying for the Hospital Association for 10 years, and it has been a persistent issue for those 10 years. Patients stuck in hospitals. They're medically cleared to go, but they can't leave. I also want to thank some of the organizations that probably don't agree with us on this legislation, but who agree with us that they want what's in the best interest of the patient. Organizations like Disability Rights and even DHHS. The proposal we're making is actually rather modest, but is necessary. Our understanding is the current probate courts approach this question differently. The law has a standard of, does the individual face substantial harm? Some courts view this situation being a patient stuck in a hospital, as satisfying that standard. Others do not. When the courts take your words, which is what they're interpreting, and they view them differently, the same circumstances, the same fact pattern, differently, I think it is a ripe opportunity for you to step in and clarify what you meant when you said in the statute substantial harm. This is especially true when what we're talking about is counterintuitive. It does not strike one immediately that a person in a hospital is in a setting of harm. In many ways, it's the safest place we have, 24-hour professionally monitored care. But as you heard from Dr. Wellens, and you'll hear from others, extended stays in a non-residential institutional setting like a hospital does impair the patient. You have in the bill a snippet of the statute. I've provided at the end of my testimony the full statute so you can see it. I'm sure your analyst, Peggy, would get it to you as well. But in a simplified version, the emergency guardianship is a three-part test. And in a simplified way, it's, does the patient merit guardianship? Is there anyone else who can help? And does the situation merit guardianship? It's important to us that you know what we're not changing. We are not changing the analysis of the patient. If you qualify for guardianship today individually, the lacking capacity type test, we're not changing that. We're not making it any easier to determine that a person lacks capacity, nor are we making it any harder. We're not addressing that part of the test. The part of the test that we are asking you to clarify is the situational part of the test. Is the person facing harm? And again, it is counterintuitive to think that a person in a hospital faces harm, unlike a person living alone in a rural area who cannot care for themselves. But when you accept the reality of what staying in a hospital means for 3 months, 5 months, longer than that, I think you can understand. Simply personalize it. Imagine it was your parent. Can they leave today? No. Can they leave tomorrow? No. Next week? Next month? No. This really doesn't impact you because you could step in and be the guardian and the court would appoint it fairly quickly. But what about those Mainers who don't have someone like you to step in? So most of the time, we're talking about the guardian as being DHHS. They have a service, it's the Adult Protective Services. They do a whole guardianship analysis on their own. They exercise their own independent judgment. We are not changing that. They will still continue to exercise their own judgment as to whether or not they want APS to secure guardianship. The issue is when they agree with us that a guardian is merited, and when they agree that it would be good to move the patient now rather than later, are we getting different opinions from different courts across the state? You may hear about this not addressing the underlying issues, bed availability, other challenges. That's true. The issue of patients being stuck in the hospital is multivariable. There are probably 100 people in hospitals today. I talked to my hospital this morning. I live in Brunswick. I'm a resident of Brunswick. 5 patients stuck who need guardians. But just because it doesn't resolve all issues, bariatric patients, 600 pounds, needing specialized facilities, sexually violent patients who are abusive to staff. This doesn't tackle every problem. No bill will. I think we have 5 bills this session on this topic. Nothing, please don't accept that as an objection to doing something in those situations where guardianship is the issue. we know this is difficult. Guardianship can be, but please remember that the courts are obligated to make the guardianship appointment as narrow as possible to only effectuate the purpose for which guardianship is being sought. The purpose for which guardianship is being sought in this case is the safe transfer of a patient from one facility to another. It is not for access for all time to the guardianship rights over this individual. We simply want to get this individual the right care in the right place at the right time, which is what we all want. With your indulgence, I'd like to be able to try to answer some of your questions that you asked the previous Dr. Wellens, but obviously that's up to you, Chairman Harnett.
Why don't, if there are some that you think you could address right now before I turn it over to the committee, why don't you answer?
I have four written down. The Medicaid eligibility question, the involuntary commitment question, Representative Hagan's question about harm, and Representative Babbage's question about sort of harm, hospital-acquired conditions. As to eligibility, I believe DHHS will testify accurately that even without guardianship, sometimes Medicaid long-term care eligibility can be secured. The big issue here is securing bank records from third parties that hold them. You can't just walk into a bank and say, give me Mrs. Austin's bank records. Sometimes there is a workaround that DHHS can accomplish without guardianship, but sometimes there is not. Oftentimes an out-of-state bank will not honor and will quash a DHHS issued subpoena for bank records until guardianship is in place. So sometimes there's a workaround, Representative Libby, sometimes there's not. Representative Moriarty went down the path of sort of blue paper and involuntary commitment and holding people against their will. My understanding on this fact pattern is that's typically not the issue. These are not individuals expressing a desire to leave, such that you need to invoke, a specific desire to leave. They all want to leave and go to another place, but they're not trying to elope and walk out the door. In those circumstances, this is the snowbank fact pattern where someone could walk out and die in a snowbank. It is not in their interest to let them go. That is not generally the fact pattern here. They're pretty unable to do that in most of these circumstances. And so it can be a factor, but it's pretty unusual for sort of blue paper involuntary commitment situation to emerge. Representative Hagan asked a good question about could the guardian cause harm? You can express what you want to the probate courts. We want a very limited guardianship appointment for the very limited purpose of a successful transfer from one facility to another. We don't want open-ended guardianship to exercise all sorts of rights on behalf of the patient. The probate courts, we have not heard that that's a problem that needs addressing. Probate courts are obligated to issue limited guardianship, to narrowly tailor the guardianship powers. The problem we've heard is that understandably, again, different courts view the situation of being in a hospital differently. And the other point, Representative Hagan, is that typically, again, we're dealing with DHHS, APS professionals here. They're not just somebody walking in off the street. Quite honestly, the problem is the opposite. There are some family members out there, they're lurking around, they won't accept guardianship, and the fear is they're spending down the individual's assets and they don't want anybody getting access to these bank records. That's a whole nother thing that Adult Protective Services works on. And to Representative Babbage's question about sort of medical hospital-acquired conditions, bed sores, infections, and the like, obviously that's a concern, but that's really not what we're driving at. We're driving at the 6-month emotional, mental well-being of someone who is stuck in a non-residential institutional setting that does not provide someone the life they deserve. So we're simply trying to expedite an outcome that I think most of us would agree is in the best interest of the patient. Sorry I took so long, but I wanted to try to address those questions.
Thank you, Mr. Alston. Questions from the committee, Representative Evangelos.
Thank you, Mr. Chair, and nice to see you again, Mr. Austin.
You as well.
Thank you. Three really quick questions. Have these extended stays resulted in the onset of depression among some of the residents?
Yeah, I would leave that to the clinicians like Dr. Wellens to give you some profiles. But as a layperson, what we've heard is, yeah, you decompensate, you get depressed. Why can't I leave? I want to, why am I here? Why am I still here? I'm not sick. So it is depression or depression-like symptoms. Yes, sir.
Thank you. Are any of these cases resulting in these unfortunate circumstances aren't about money, but I'm going to ask a money question. Are they creating charity care cost pressures in any of these cases for your institutions?
Yeah. Yes. Typically, an inpatient, you get a per discharge rate. So we're going to get paid what we get paid if they stay 3 days or 30 days. There are limited circumstances where we can apply if they are already Medicaid approved patients. We can apply for a little stipend in some circumstances. I think the bigger issue for us is not the lost revenue from having someone 6 months, although there is lost revenue. And this is what my CEO in my town told me today, it's the aggravation in the emergency room for all the families that need to get in. I mean, that bed in 5 months should turn over every 6-7 days. You should have 20 or 30 patients access the services they need in that hospital. If you're a half-empty hospital, it's probably not a concern, right? You've got other beds. But if you're full, which many hospitals currently are, if you're full, people wait. Other people in your community, other constituents are sitting in the emergency room for extended periods of time, or have to go to other facilities for care, not in their immediate, not in their town. So yeah, there is a financial hit to us. The real hit though, and there's a hit to the community sitting in the emergency room. The big depression and hit is among staff. They're used to taking care of people and helping people, and they're seeing the opposite happen. They've fixed the broken arm or they've cured the infection. Now the patient is getting depressed and there's nothing they can do. They can't make that hospital a residential setting. Happy birthday. Merry Christmas in the hospital. It stinks.
Yeah. And real quickly, and anyone can weigh in on this, but are these temporary and emergency guardians, do they provide 24-hour housing and supervision?
The guardian does not, but the guardian can stand in the place of the patient. And that's often what the receiving facility, let's just say it's a nursing home, in order to lay out the care plan on the acceptance of this patient, they need someone to communicate with. So if you've ever placed a loved one in a nursing home, you walk them through what the care plan is going to be for your loved one. Well, for folks that don't have a loved one, they're alone, someone needs to walk through that care plan. And again, the professionals at DHHS, Adult Protective Services, serve in that role and serve it well. We just would rather they serve it now rather than 6 months later.
Thank you very much.
Thank you.
Thank you, Representative Evangelos. Representative Moriarty.
Thank you, Mr. Chair. Mr. Austin, what I'm hearing is that the situation involves a person who may have been functioning very poorly on the outside, who didn't have a guardian at the time, may have sprained an ankle, came in for acute treatment, and then from an objective point of view was ready to be discharged. But it became apparent to clinicians and staff members that that person couldn't, in fact, survive on the outside. Under the current system, since you, the hospital, have the right to keep that person for as long as you deem appropriate, what is it that brings an end to the lengthy hospitalization right now?
Well, it depends on the patient's circumstance, but the patients we're talking about today is generally ultimately securing guardianship through the non-emergency guardianship process. That is the resolution. And then once that guardian is in place, we're able to call around to facilities and say, will you take Representative Moriarty now? Until that time, the receiving facility is like, I can't hold a bed open until you secure guardianship. Don't call me now. Wait until you're able to facilitate the transfer, meaning wait until you have a guardian in place, then call me and we'll tell you whether we have a bed available. So we can't really even initiate conversations with long-term care facilities, because as soon as we tell them, yeah, they're great, they're docile, they're easy to manage, not an issue, not particularly medically complex, but lack capacity, you can handle them, but we need to get a guardian in place. They go, well, okay, call me in 4 months.
Well, a quick follow-up then. If you become the de facto place of residence and there's sort of no end in sight, at least in the short run, can you, the hospital, file a petition on the patient's behalf with the DHHS?
You mean with the court? Can we file
with the court?
a
petition? All I have is 3 lines of statute here, so I'm a little unclear as to what the bigger picture is.
I don't know the legal answer to that. I think most of our facilities view that as a conflict of interest and do not believe they can act as the guardian for the patient under their care. For example, what if something went wrong at the hospital? We can't, let's say we made a mistake in the course of holding them. We can't be the legal representative of a patient we're caring for. I think that's a conflict of interest, or it probably should be if it's not.
Well, I take your point, but think of Dr. Whelan's patient who was falling apart before his eyes.
It's the wisdom of the state establishing something called the Adult Protective Services. You have an objective third party whose mission it is to look out for the interests of incapacitated individuals. That's the wisdom of that system.
Well, yeah, I know, but who triggers that?
Well, how does that work? Yeah, we contact DHHS. There is something called a guardianship study. There is a whole bureaucracy behind when will DHHS Adult Protective Services seek guardianship. And that is a long conversation, an investigation. They don't simply take our word for it. Hey, Representative Moriarty needs a guardian, give them one. And they say yes. No, they exercise their professional judgment in determining whether or not they think APS should step in. There are situations where we disagree, but we're really only this bill doesn't change that. There may be situations where a doctor says, we think the patient lacks decisional capacity. The state disagrees. This wouldn't change that. They don't have to pursue guardianship. It's when they agree and we get to a court and the court's like, no, they're in the hospital, they're fine. Well, you can see why they say that. Of course they're fine, they're in the hospital. Now, when you consider that it's going to take 6 months, I think you can understand why they won't be fine. And it makes sense to move more expeditiously in the interest of the patient.
Thank you.
I believe DHHS is submitting testimony. I don't know if they're speaking, but they can speak to the APS process more intelligently than I can.
Okay, thanks.
Thank you, Representative. Representative Libby, I saw your hand up and then I saw it go away. Are you?
I'm not sure how it magically went away, but thank you, Mr. Chair, and thank you for being here today, Mr. Austin. My question pertains to something that you actually alluded to, and I wonder if you could expound on that a little bit. In every hospital in which I've ever worked, our ICU admissions would always be held up and limited due to patients that were no longer appropriate for ICU, but were ready for step-down beds. And that would include patients coming from outside hospitals that needed emergency care. So can you speak to that up the chain effect when a patient is in a space that is no longer medically appropriate to them, and how that comes into effect with this bill?
Yeah, I appreciate the question. I mean, the healthcare system is a system. It's sometimes dysfunctional and frustrating, but it is a system. And you can't let people in the front door if an equivalent number of people are not leaving out the back door. And a single occupancy for 6 months ties up that bed, and even more importantly, the human resources, nursing staff, that are needed for other patients. And so, again, when you're in a realm of excess capacity, you've got beds that are empty and nurses twiddling their thumbs, not an issue. But that's not really reality. We're typically pretty well stretched to our capacity. And so you wait, you sit and you wait. And those patients can suffer either a delay or a transfer. Sorry, you can't come into Midcoast and Brunswick, but we can send you off to Farmington. That's a real inconvenience on the family. So there are those downstream impacts for patients who are waiting for services. And you heard from Maine Med. I mean, Maine Med is the big tertiary center. There are some services that are only offered in some of the big hospitals like Maine Med, Central Maine Med, Eastern Maine. Really precious resources for the state. So if they're held up, you can really have some problems because of the nature of what those facilities do.
Thank you.
Thank you, Representative. Before moving on to our next witness, any other questions from committee members?
Thank you.
Thank you very much, Mr. Austin. Good to see you.
You as well.
And I will now turn to Lisa Harvey McPherson of Northern Light Health. Ms. McPherson, you're muted and your camera is off. You're in as a panelist. You just muted your.
Great. Sorry about that. Hopefully, okay, great. I am in and I thank you very much. Senator Carney and Representative Harnett, my name is Lisa Harvey McPherson, and I'm here to speak in favor of this bill on behalf of Northern Light Health. I want to pick up on the theme that Representative Libby asked about, and that's actually how I start my testimony. This really is about doing the right thing for the individuals who are living in hospitals for extended periods that do not need to be there. But the bigger picture on any given day, pre-COVID and certainly post-COVID, your larger medical centers, Eastern Maine Medical Center, Maine Med, and others are generally full. Our emergency rooms are busy. We have patients in rural hospitals with gravely ill conditions who need to get into the medical centers. The rural hospitals also are challenged by these patients who are unable to be discharged due to guardianship. And on any given day, we have about 42 patients living in hospitals who shouldn't be there. The larger volume, not necessarily always the larger volume, but on any given day, we have 5 at Eastern Maine Medical Center and 1 or 2 at other hospitals. The system gets stuck and it's not serving anyone who needs to be in an acute care bed to serve the medical condition well. As Representative McCrate and others mentioned, we have been working with interested parties since 1999. We met in 1999 and then we met virtually again last fall. I believe that we have accomplished what we can accomplish. We all agree on what the challenge is. We agree that we've improved communication. And we agree that there is risk to patients when they're living in hospitals for extended periods of time. We've accomplished what we can accomplish. And this bill provides us with a tool in the toolkit for patients in need of guardianship to get discharged. And in my experience, having worked on this for many years, the patients in need of guardianship, out of all the difficult to place patients, if we solve the guardianship issue, then they can get placed. We're not transforming our long-term care system. We're not creating new behavioral health beds. By and large, when these patients have a guardian, we can discharge them. To help the work group, Northern Light Health did an analysis of guardianship patients. And from May of 2020 to September of 2020, we had 22 patients living in our hospitals for 4 to 6 months, all needing a guardianship for placement. I'm going to give you 2 examples, and Representative McCrate is right in her comment that we did a debrief. Where are we now in 2020 after all of this work? Where are we now? And we really haven't accomplished what we need to accomplish to serve these patients well. So I'm going to give you an example, pre-work group and post-work group. So the first patient is a patient admitted to one of our hospitals in August of 2018. The patient had heart issues, kidney disease, and lacked capacity to make decisions. And so we identified that this individual needed a guardian for placement.
Ms. Harvey McPherson, I'm sorry, I've not been diligent in my job of keeping time, so I'm not going to cut you off at 3 minutes, but I would ask if you could wrap up.
So this patient was admitted in August of 2018. Northern Light Legal became involved in January of 2019. We could not get this patient on the probate court docket until June of 2019. Almost a year to get on the probate court docket. And that's all he needed. A guardian was appointed, and we had a residential care facility that accepted him within days of that appointment. He spent the last 10 months of his life living in a hospital, all but 1 week at a residential care facility, where he died shortly after admission. In 2020, we had a patient who was admitted in May. Now, this is a difficult to place patient. She had behavioral health challenges. And we referred this patient to an adult protective, and they declined to do the study. And Northern Light Health Legal and I actually met with adult protective, and in September, they did agree to do the guardianship study. But this patient didn't get on the probate court docket until November. And this patient was not discharged until January of 2021 during a pandemic, admitted in May of 2020 during the pandemic. And in this last situation, what it points out is what Jeff was talking about. When the guardian is appointed, then we can facilitate discharge, because the facility receiving that patient needs to know that there's a guardian and a decision maker. And this patient had a lot of decisions that needed to be made. So what this bill does is simply allow us to have an expedited process when a patient is living in the hospital for the appointment of an emergency guardian. No other aspect of the guardianship process is changed, but this will have significant impact in that patient being able to leave the hospital. And with that, I welcome any questions that you have. I believe Representative Harnett, you muted. Okay, yeah.
I said, thank you very much for your testimony. Now I will ask if there are committee members who have questions for Ms. Harvey McPherson. And seeing none, I will again thank you very much for providing testimony and information to the committee today. The next person I have testifying in support is Dan Moran, and I just need to let people know, given the amount of people we have testifying and another hearing we have, I'm going to be a little tougher with the 3-minute clock. So with that, I welcome Mr. Moran.
Hi, thank you, Representative Harnett. My name is Dan Moran. I'm the Director of Communications and Government Affairs for the Maine Medical Association. My camera's not working, so I apologize. So you see a picture of the front of our building in Manchester right down the road from you, or where you would be normally. The Maine Medical Association is the state's largest professional physician organization, representing more than 4,300 physicians, residents, and medical students in Maine, whose mission is to support Maine's physicians, advance the quality of medicine in Maine, and promote the health of Maine residents. We're here in support, and my testimony has another bill on there. That's the hazards of the second paragraph of doing multiple pieces of testimony at once. But this is for 366, as it says in the reason line. As you heard from Lisa Harvey McPherson, there's never been a better time to pass the bill, as the public's more aware of the limitations of hospital resources because of the pandemic. And the next paragraph in my testimony pretty much goes over exactly what you heard from Dr. Wellens, Jeff, and Lisa about the instances where patients are left in hospitals. Our hospital-based physicians have indicated that this is an important bill that they'd like us to support. The paragraph about emergency physician members wanting to support it, we did hear from them, but I'll need more information from them in the hospitals on that. You might just want to redline that paragraph. I don't want to muck up the bill with talking about emergency patients that are stuck and they come in for whatever reason through EMS and it's deemed that they need guardians. But if this mucks up the bill or puts the discussion sideways, just cross that out and I'll try and gather more information about that. The last paragraph, it's a time-consuming process. This is what we see is simply a tweak to law. Determining a discharge-ready patient that is stuck in the hospital is a situation that warrants emergency status. Doesn't change the legal status of the person or the analytical aspect of whether they need a guardian or their condition merits a guardian. It just speeds up an important and necessary process from our understanding. Be happy to take any questions. We thank Representative McCrate for introducing the bill. Good to see you again, Senator Carney. And my father-in-law, former Senator Carl Turner, says hi to Representative Moriarty, who is his state representative.
Thank you very much, Mr. Moran. Are there questions from the committee for Mr. Moran? Seeing none, I thank you again, sir, and appreciate your providing information to the committee today. I'm sorry, Representative Libby.
Apologies, and I'm not sure that Mr. Moran is the appropriate person to ask, but thank you, Mr. Chair. My question is there any change to the actual process itself of guardianship other than an accelerated timeline under this change to statute?
From what I'm not a lawyer, but from what I'm more of a comms guy and a PR guy and a government affairs guy, but from what I understand, this speeds up the process. It doesn't change the process. It just makes it an emergency situation. Jeff can correct me or Lisa or somebody else that's going to testify.
Thank you.
Thank you, Representative Libby. Are there other questions for Mr. Moran? Seeing none, that completes the list I have of people who want to testify in favor, but I have been told that Kathy Ayers would like to testify on the bill. I just don't know if you are in favor, against, or neither for nor against.
I'm going to say neither for nor against and just have information.
Okay, then I will get to you when we get to that portion. Thank you. I will now turn to those listed. Well, I'll ask if there are any other members that the committee clerk is aware of, any other folks on the meeting that the committee clerk is aware of that want to testify in favor of the bill.
No, I do not have anybody else in favor of the bill.
Thank you. I will now move to those testifying against the bill, and again, let them know that I will be keeping a clock with, but I do want to treat everyone fairly. The first person I have is Erin Salvo from Maine DHHS OADS. Welcome, Ms. Salvo.
Good afternoon. I'm hoping you can hear me okay.
Hear you loud and clear. Thanks.
Senator Carney, Representative Harnett, and members of the committee. I'm Erin Salvo, Associate Director of Adult Protective Services within the Office of Aging and Disability Services. I'm here today to speak in opposition to LD 366, and I'd like to offer the following information for your consideration. The department recognizes that barriers to discharge from a hospital after an individual is medically cleared create challenges for patients and hospitals. It is often suggested that a patient's lack of a guardian is the reason why a patient cannot be discharged, and hospital personnel regularly contact APS to seek a public guardianship appointment to make decisions on placement. However, in many situations, there are significant barriers to discharge that cannot be resolved by appointing a guardian. It's also been asserted that a patient's main care application cannot be initiated until a guardianship is established, which is not accurate. Probate courts throughout the state have historically held differing views on whether an individual's presence in a hospital constitutes substantial harm for purposes of establishing the need for an emergency guardianship, and many judges have held that that factor alone does not meet the standard. Currently, APS does consider whether to file emergency guardianship petitions when an incapacitated individual is in the hospital. However, recognizing the court's position, hospitalization alone does not result in the filing of an emergency petition within the public guardianship program. Circumstances that may rise to the level of an emergency petition include when the client needs a specific level of care that truly requires guardianship, such as a locked dementia unit, when immediate medical decisions during hospitalization must be made, like authorizing surgery, or when a caregiver or surrogate decision maker involved with the client has been substantiated by APS for abuse, neglect, or exploitation and needs to be removed from that decision-making role immediately. In response to LD 1229, during the 129th session, the department participated in meetings led by the Long-Term Care Ombudsman Program. The department shared information with that group that demonstrates that even when public guardianship has been established, patients with complex needs may remain hospitalized beyond the period of medical necessity, sometimes for significant periods of time until the appropriate type of placement becomes available or is developed. As written, this bill would dilute the meaning of substantial harm in emergency guardianship cases. At the same time, establishing that delay in discharge is due to the lack of appointment of a guardian is not the clear-cut analysis envisioned in this bill, given the many barriers to discharge that frequently exist in these complex cases. The wording in this bill would also leave unanswered whether a patient or patient surrogate decision maker disagreeing with a proposed discharge plan would constitute a delay in discharge and permit use of emergency guardianship to attempt to force someone to accept a discharge plan where they rationally resist or refuse. From the department's perspective, this would be an inappropriate overreach and potentially a regular occurrence permitted within the bill's wording. The probate courts currently have authority to use their judgment to identify which circumstances amount to substantial harm. APS makes case-by-case determinations on emergency and standard guardianship petitions, recognizing the department's role as a guardian of last resort and recognizing the value in minimizing delays in discharge as much as possible. Overall, adding this bill language will create confusion, and far more concerning, it will likely result in unnecessary emergency guardianships, a legal tool that is designed to be used sparingly to preserve individuals' due process rights. Thank you for your time and attention. I'd be happy to answer any questions you have and make myself available for the work session. I tried to trim my testimony a bit, so you should have all the full written version for your consideration as well.
Thank you very much, Ms. Salvo. Are there questions from the committee? Seeing none, I want to thank you for your testimony. We look forward to working with you during the work session.
Thank
as
you.
we move this bill, work this bill. Thank you. The next person that I have testifying in opposition to LD 366 is Leo Delicata from Legal Services for the Elderly. Welcome back, Mr. Delicata.
Thank you, Representative Harnett, Senator Carney, and members of the Judiciary Committee. I have submitted some testimony. I will tell you that I agree with everything that Aaron Salvo just testified to. Let me read a bit of my testimony, and if anyone would like me to speak more, I would welcome questions afterwards. And I will attend the work session. There are several reasons why we speak in opposition to this proposal. First, making this change is a policy choice, signaling a more liberal legislative interpretation of the meaning of substantial harm and encouraging the use of emergency guardianships. Neither of these results will benefit Maine people. Second, we believe a more appropriate legal remedy already exists in our probate code in the other protective arrangement sections of that code. Now, that code was put in force in 2019, so people are unfamiliar with it, and we spoke about it in our group, and some of the hospitals have had some success in using that provision in getting help from probate courts. Third, while it may appear to be expedient, the suggestion that this proposal forwards does not promote the guiding principles that support the public policy behind our probate code. And then I list what that public policy is. Enlarging the concept of substantial harm to specifically include the population described in this bill would remove discretion from a probate judge to interpret that term when deciding whether to make an appointment of an emergency guardian. Removing professional judgment from a judge for any reason is a decision that should give everybody pause. It's a drastic action that indicates that our system of justice is failing and legislative intervention is necessary. We do not think that the evidence before you makes that case. Of course, redefining the emergency guardianship language as proposed would make it much easier for a hospital trying to discharge a particular patient, but the probate code is not designed to make the appointment of emergency guardian the first choice for any petitioner. In fact, because an emergency guardianship may potentially remove all or some of a person's adult legal rights with a bare minimum of due process, it's a remedy of last resort that is only meant to be imposed when nothing else is appropriate. A petition for the appointment of an emergency guardian should be a rare legal proceeding because it values a person's safety above everything else. It cuts short a normal guardianship process and allows oral notice, and in some cases, no notice of the hearing at all. In those later cases, the appointment may be ordered without a hearing based on an affidavit by the petitioner that the respondent will be substantially harmed before a hearing on the appointment can be held. Although temporary, the appointment may last for 60 days, but may also be renewed. An occasion where rights may be lost with little or no opportunity to be heard before the petition is granted and the order is written is not one encouraged by the probate court and only allowed where harm to a person is occurring or imminent. So my time is up, but I do have another remark about why the definition should not be changed. And if anyone will like to ask me what that is, I'd be more than happy to answer the question. Thank you.
Well played, Mr. Delicata. Are there any questions for Mr. Delicata? I have first Representative Hagan.
Thank you very much. I would be very interested in you telling all.
Well, changing the definitions of, thank you, Representative Hagan. Changing the definition of substantial harm has consequences that go far beyond resolving hospital transfer problems. It would be a policy choice that would invite the public and judges to rethink what the word emergency means. This is about an emergency. It would open the door for other analogous situations to qualify for emergency guardianships. It would not be surprising to learn, for example, that someone might argue that appointment as an emergency guardian is an appropriate way to expeditiously move an adult of any age away from one living situation to another that would not be substantially harmful. We recommend keeping this door closed. The next part of my testimony, and we can do this in work session, is to really talk about the other protective proceedings option in the probate code. It is a new option. You do not have to file a guardianship petition. You don't have to file a conservatorship petition. You can file this other special new thing, new since 2019, another protective proceeding, and it allows the court.
Mr. Delicata, let's discuss that in detail at the work session. I still have a series of other representatives that want to question you. And the next is Representative Libby.
I am happy to go, but I believe that Representative Moriarty was actually the first, so.
Why don't you just go? Sometimes it's hard
to
take.
So I have a question and a follow-up question. My question is in regards to testimony on the second page, and you referenced a bare minimum of due process and an occasion when rights may be lost with little or no opportunity to be heard before petition is granted. So same question that I asked previously, is there a change in the process itself other than simply a change in the time frame that you can outline? And then in that same vein, in the normal process, when that is followed, which as we've heard can take from days to months, how often does a guardianship not occur once initiated?
I don't know. I don't know what the statistic is about that. I do know that Ms. Ayers attended all the meetings that we had. And one of the concerns was actually getting on the court docket. We have 16 different dockets in 16 different counties. Everybody's different, but Kathy Ayers has been chairing the registers group. They're an association. It may even be an incorporated association, and has great, can suggest things to the group that the group generally will accept. And one of the things that we heard was, if you let us know that this particular action that you are asking us to take in the probate court involves a hospital, and it involves somebody who has been in the hospital for a very long time or a long time, we will make sure that that case goes to the top of the docket. So, you know, That's not a formal thing. That's not a formal agreement, but at least there's that kind of good faith on the part of the registers. And we had a couple of registers that actually attended these meetings. Kathy, I think, attended all of them, who are interested in solving this problem. So it is a problem of access. It is a problem of some judges deciding that something is substantially harmful and something is not. And honestly, if you give them the benefit of the doubt, they're looking at patients with different conditions. You know, I heard testimony from Dr. Bellin this afternoon, for instance, that described people who were concerned about their pet or were making statements about wanting to go to other places. You know, to me, that represents someone that has some level of capacity. And the numbers of people that have developed these problems this afternoon, numbers in the hospitals, are new to me. When we started these meetings, the number that the hospitals were telling us were stuck in their hospitals were anywhere from 26 to 30 people a year.
Can you answer one more question? And that is down in number 2, alternative existing probate code remedy. So can you talk a little bit about the time frame of that? What would a change like that mean to the timeline?
You know, honestly, the time frames depend upon the individual probate courts, because again, it's a question of getting on the docket. And in order to get on the docket, you have to have a petition prepared. You have to have an assessment from a physician or a primary care source, which if you're in a hospital, that should not be a problem. And then you are ready to go. You can file the petition.
So if a petition is filed and it's labeled as an emergency petition versus just a standard petition, that does move you up the line.
Sure. It's from a different section of the code. It's a special section of the code under guardianship, under conservatorship, and it moves you to the top of the docket. And that's why that seems to be the option of first choice here, because, you know, somebody's been in a hospital for a very long time and they finally realize that somebody's been in the hospital a long time and they've got to do something about it.
Thank you very much.
You know, I'm sorry, but I've been dealing with this for a very long time. And
I appreciate that. I have as well, though, from a different perspective. I thank you for your answers.
Thank you, Representative Libby. Representative Moriarty.
Thank you, Mr. Chair. Mr. Delicata, I think Representative Libby and I are sort of honing in on the same issues. You mentioned in passing the loss of liberty and lack of due process. And what's missing for me is any due process whatsoever on the part of a hospital, which feels that it cannot safely discharge a patient for various reasons, and as a matter of default, has the authority to keep that patient without an end in sight. So what's wrong with requesting an emergency appointment?
What's wrong with it is
why do you oppose it?
There are two answers to that. Number one, policy-wise, it's not a good idea to encourage emergency guardianships because they can be imposed very quickly by people who are not people from sources that are not hospitals that need to either get control over somebody or get something done quickly. So as a public policy, it's wrong because it should be rarely used. And it should not be something that we should allow in our society unless there is a true emergency. Now, emergency has never been defined in the probate code. You can look it up in Black's Law Dictionary, and if you do, you're going to see wording that everybody here is going to agree with is an emergency. You know, it involves immediacy. It involves physical harm to person or property. It involves that kind of stuff that we can all agree on is an emergency. Somebody in a hospital is a different situation. And, you know, it may very well be an emergency, but it has to do with factors that are really up to the judge to decide. So from a policy perspective, it's a bad idea. From an individual perspective, if that's the way to get somebody out of a hospital, you're saying, well, you know, we're talking about a small number of people. Why shouldn't we open the door here? You put it in statute, and the judge is going to look at that and say, oh, so you mean somebody in a hospital, well, that's an emergency. Well, how about this other case, which is sort of like that? Why isn't that an emergency? Okay, well, that'll be an emergency too. Policy-wise, and that's what you do. You make policy. It's not a good idea.
Okay, thank you.
Thank you, Representative Moriarty. Senator Keim.
I don't have a question for Mr. Delicata. I actually just just wanted to make a note for the work session that the hospitals would obviously have been part of a long discussion and have heard this fix in probate language, and would just like to have their response, a written response from them, why this isn't working for them, as you know, as handily as Mr. Delicata seems to think it should. I just like that information before the work session. Thank you.
We will request that. Thank you. Any other questions for Mr. Delicata? Thank you, Mr. Delicata.
Thank you very much for giving me the time. I really appreciate it.
The person who was just added to testify in opposition, Lauren Willie. I hope I pronounced that correctly.
You did pronounce that correctly. Thank you. Can everyone hear me okay?
Yes.
Okay, great. Good afternoon, members of the Judiciary Committee. My name is Lauren Willie. I'm a managing attorney with Disability Rights Maine, and I'm here to testify in opposition to LD 366. I did submit written testimony, but I wanted to appear here today to just highlight a few points that I think are worth highlighting. First, I want to just restate that this proposed legislation is really well-intentioned. We fully support the goal that people should not be unnecessarily institutionalized, that people that should not be in hospitals should be able to leave hospitals, and that barriers to leaving should be addressed. However, we believe that this bill will really not address the issue in any meaningful way. And what's more, we think it will erode civil rights protections for anyone who's at risk of coming under guardianship in this process. At DRM, we work frequently with clients who are quote unquote stuck in hospitals, who've been cleared for discharge and are not able to do so. Almost invariably, the obstacle preventing just discharge is not a lack of a guardian, it's a lack of a service provider who's willing or able to serve the client. You heard testimony earlier that a part of this problem is sometimes a provider who refuses to accept a client who doesn't have a guardian. Making it easier to appoint a guardian is not the best way to address that issue. That's potentially a discriminatory practice that might be dealt better through other means. I just wanted to touch briefly on emergency guardianship because it's a really special type of proceeding, and it's meant to be reserved for the narrowest of circumstances. With emergency guardianship, there is no opportunity for the court to obtain the opinion of the person coming under guardianship. There's no opportunity to appoint an attorney in the matter. There's no opportunity to even notify the person that a guardian is being requested until after the appointment's made. Expanding the circumstances under which that might happen, regardless of the underlying reason, which is what this bill does, that's not a way to fix this problem. It can be incredibly difficult to get out from under guardianship once it has been granted. I work with many clients who, even without anyone opposing a guardianship termination, we face difficulties in getting it approved. Anyone that's been following the Britney Spears story knows that even someone with great resources can face insurmountable hurdles to getting out from under substitute decision makers. The existing law is appropriate to address emergency guardianship. Right now, you can ask to become an emergency guardianship to prevent substantial harm to health, safety, or welfare. Courts can and do grant requests for emergency guardianship when they deem that this criteria is met, including instances where people are sort of stuck in hospitals. This still doesn't give guidance on how to recognize emergencies. It takes away the discretion from the courts to do so. I hear my time is up, so I'm happy to take any questions and make myself available for the work session.
Thank you, Ms. Willie, and we certainly hope to see you at the work session. But even before that, I will check to see if there are any questions from members of the committee about the testimony that you just provided. Any questions for Ms. Willie? Seeing none, I want to thank you very much on behalf of the committee, and we look forward to working the bill together with all interested parties.
Thank you very much.
Are there any other persons on the electronic meeting that wish to testify in opposition to the bill? Has anyone notified you, committee clerk?
I believe that is it.
Thank you. Then I will turn to our last person who wants to provide information, and this is in the category of neither for nor against, and I would call upon Kathy Ayers.
Thank you, Representative Harnett and honorable members of the judiciary. I just want to talk a little bit about process because I don't think that that has been answered correctly or really at this point, and I want to talk about that. The emergency guardianship is not a standalone proceeding. Okay, so you have a guardianship petition with all the physician's report, the plan, the situation that is filed. There's emergency affidavit, a motion for an emergency. That is an ex parte emergency, no notice to the person, and it is sometimes granted and sometimes not, depending, but it is not a standalone piece. And it is, I question personally whether this change in the law would be constitutional, just from looking at it. But then after they have 48 hours to tell the person that they are under guardianship. If they object, they get an attorney. Whether they object or not, there's another hearing in 14 days. Okay, so and also the ex parte guardianships are ASAP. That's why we said, call us and let us know. Don't put it in the mail. Don't electronic file it and think we might see it because we have lots of other things in there and it might not get looked at that day. And that's why we said, call us, let us know, because if we don't have a judge available in our county, we have to find one in a neighboring county to look at this. So the other thing is that when we do the visitor's report, if we find out that it's an objection, that is what is a year out. That is what's a year out. Because we have many legal proceedings in between when somebody objects to being placed in a nursing home, a locked facility, leaving their home. That is the reason. It's not an emergency guardianship all by itself, and it's done. Now, some of the issues that I found and said was the emergency affidavits aren't being filled out properly to say, I don't want to, the situation is very limited because a judge can do a limitation. This is just for the purpose of Medicare, finding out whether they're main care eligible. This is just for the person, for the purpose of moving them to a nursing home. However, nursing homes don't want, they want a guardian. They want a full guardian. They don't want an emergency guardian. I think that's kind of, there's federal regulations about that. There's got to be somebody legally responsible. So those are just a few of the things that I wanted to clarify after I heard the testimony.
Thank you very much, Ms. Ayers. Are there any questions from the committee for Ms. Ayers? Seeing none and knowing that unless I hear otherwise, there are no other persons interested in testifying on LD 366. I will now close the public hearing. Thank the committee members and more importantly, thanking all of those who participated in the public hearing for the valuable information that you provided. Thank you.
Excuse me, Mr. Chair.
Yes, sir.
This may be totally inappropriate, and please tell me so if it is. We have a bill which consists of basically 1.5 lines of new language to be inserted into a fairly complex statute, which was just enacted 2 years ago. I am astounded that this issue hasn't been worked out by the stakeholders, the parties. And I'm not optimistic about a work session unless we take a whole day to steep ourselves into this entire process that is contained elsewhere in the probate code. I haven't printed all of the emails that came in this morning. I'm not sure if the Probate Law Advisory Commission has taken a position on this, and I just haven't read it yet. But wow, this is, I've been turned and twisted around so many times the past hour and a half, I don't know which way is up anymore.
I thank you for raising that concern. I can't answer that question right now. I must tell you, I've received over 150 emails since we started our hearings at 10 o'clock this morning. I have not had the chance to look at them. I've been admonished for not looking at some of them. I will talk with Senator Carney and we will decide the best way to move forward. But I thank you for raising that. We will now turn to our last bill of the day, which is LD 331, an act to protect student privacy, presented again by Representative Jay McCrate, who signed up for the entire afternoon, I guess. But welcome back to the Judiciary Committee, and I will remind all folks testifying other than the representative introducing the bill that I will be stricter with the 3-minute limit. You will see me hold up the phone with about 15 seconds to go, and then you will hear the dulcet tones telling you that your time is up. So with that, I would introduce Representative McCrate. Welcome.
Thank you. And I feel like I should thank you for your attention in advance as well as at the end. So I will do that. Senator Carney, Representative Harnett, esteemed members of the Judiciary Committee. Again, I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick. And I'm here today to present LD 331, an act to protect student privacy. The bill before you proposes changes needed to protect student privacy. It would establish that surveillance recordings made on school grounds or in school-related vehicles, as well as any live or recorded classes taught by public school staff in which students can be seen or heard, are not to be considered public records under the Freedom of Access Act. I have to say, I really thought unprecedented was going to be chosen the word of the year because we all have said it so often. And though it wasn't chosen, it's still a word that describes our lives now. So many things have happened that none of us would have predicted, I certainly didn't, and that we've never experienced before. Remote learning through Zoom and other platforms is one of those. I've worked in public schools for 20 years and know that systems to protect student privacy are critically important. These include protection of records, of course, and of requiring permission for public use of any pictures or videos taken. But we're way past photographs and videos now. Technology has allowed us to continue teaching and learning, but it has also created new challenges for maintaining the privacy of students. Establishing that any live or recorded classes are protected wasn't considered before this unprecedented time, but we do need to consider it now. It's also a sign of the times that we've needed to add surveillance equipment on school grounds and in school vehicles. We need to address protection of student privacy here as well. This technology is intended to increase safety, but to allow these visual or audio recordings to be publicly available means they could potentially be used to intrude on the privacy and the safety of those same students. I ask you to support this proposal so that we can address these new challenges to the protection of student privacy. And again, thanks for your attention. And I'll do my best to answer any questions.
Thank you very much, Representative McCrate. I will now turn to the committee to see if there are any questions for the representative on her LD number 331. Representative Hagan.
Thank you very much, Mr. Chair. I have a question. I'm not sure who to direct it to. When reading this bill, with police access to this kind of thing, does this restrict law enforcement?
Thank you, Representative. I asked the same question because there are times when it's unsafe, when something happens, that the police need to be involved, and it does not.
Do you have an additional question, Representative Hagan, or was that it?
No, I was just concerned that law enforcement would not be able to access things to properly do their jobs. And if this bill has no effect on that, then that satisfies me. Thank you.
Thank you, Representative. Next, I have Representative Moriarty, followed by Representative Poirier.
Thank you, Mr. Chair. Representative McCrate, one of the written comments that we have in opposition to the bill refers to the creeping erosion of the Freedom of Access Act. So my question is, where do we stand right now? Is it clear that these recordings are within the scope of the act? Or is this simply sort of a cutting edge issue that hasn't really taken a direction yet?
I think someone following me will answer that better. Once again, I have to say, I don't have all the answers, but I see this, having been in public schools, as I said, as an addition beyond what we already are trying to do around protecting student privacy. So I would defer if you'll allow me to do that.
Of course.
Representative Poirier, followed by Senator Keim.
Thank you, Mr. Chair. And Representative, my question actually stems because I serve on a school board in District 54. And our district actually has policies against releasing video and information regarding students for privacy purposes. So I'm wondering, are there specific examples or are there major issues going on with this sort of thing throughout our state that would cause this bill to have to be made into law? Or do you think this is something that could be resolved through school boards?
Well, actually, the request for the bill comes from school boards. So I think hopefully that answers your question, that perhaps some systems feel like they have what they need in place. But I think push comes to shove, it would be good to have a consistent policy.
Thank you.
Thank you, Representative Poirier. Senator Keim.
Thank you, Mr. Chair. Good to see you again, Representative McCrate.
You too.
My couple of questions. One is, would you see this bill as also applying to parents so that parents couldn't get recordings of a if the children are doing online school and it's being recorded anyway? Are you thinking parents wouldn't have access to that?
I'm not. I'm thinking that it couldn't be used publicly. But that's a different situation than a parent. And I worked in all levels of public school. And at every level, I felt strongly that parents were welcome guests, visitors. Sometimes would spend every lunchtime in the school in some cases, but welcome in classes. So it's not, and my daughter is a middle school special ed teacher. And so I've asked her about this bill. And from your experience as a teacher, I was a social worker, so slightly different experience. Do you have any concerns about this bill? She said she felt like it would provide some safety, that parents are welcome, they're in the room, they're walking by, they're participating with homework, but it not to be released publicly. That's how I would view it.
And my other question for this would be that, I mean, we're doing school now, obviously, so differently, but anyone can record. I can be recording what's going on right now. Anyone can record. So how do you see that? I mean, a student can record, and do you see this bill capturing just that, the participants themselves recording and then sharing? Do you see this bill capturing that scenario?
Well, I think, to me, the recording isn't the problem. It's what you do with the recording. You know, for example, if we take a screenshot right now and post it and say, I was in Judiciary Committee, that's very different than saying something nasty about someone who was here, or turning what someone said, using a snippet in an inappropriate way. That's how I would view it.
Okay,
it's protecting that student's person from being misused.
Thank you.
Thank you, Senator Keim. Are there other questions from committee members for Representative McCrate? Representative Babbage?
I couldn't let you get away, Jay. Thank you, Mr. Chair. Representative McCrate, thank you for bringing another great bill for us to discuss at length.
Welcome.
You know, having spent many years in the classroom, I've been concerned about this issue, and I appreciate you bringing it forward. As usual, I'm always looking also for ways in which we have unintended consequence, but you know, I've often thought sometimes things, in order to project something that somebody may be proud of, sometimes takes videos of a group and without permission disseminates that. And I think that does need to be reined in. I wondered about a situation in which a parent has a child that incurs a traumatic experience or something. Would they still be able to go to the school and request, if there is security video, that they might view privately without dissemination? I mean, is that how we would rectify this? Because it's public dissemination that we are trying to prevent here. Is that correct?
Right. I would understand it the way you've described it, that schools have a responsibility for protection of students. And certainly there have been times when people haven't felt there's been sufficient protection. We always need to make sure that we're protecting students from, I mean, I see this, I dealt with bullying all the time as a school social worker. Kids who, for a variety of reasons, were not kind to each other and went beyond kind into brutal. And it's the school's responsibility to intervene. I don't see that changing at all. I think it's the same idea. It's just that there are it's a different world than it has been. And yes, as a teacher, I know you've lived it. It's an honor that we have when we work with students in schools, but it's our responsibility to protect them. And that's what, to me, this is about. Things have changed.
I appreciate that. Thank you very much.
Thank you, Representative Babich. Are there other committee members who have questions for Representative McCrate? Seeing none, thank you very much, Representative. It's good to see you, and please feel free to stay with us for the complete length of this discussion. I've looked through the list of panelists and attendees, and I am not seeing any legislators who were co-sponsors or just here to testify on the bill. So I'm going to move along to those testifying in favor of the bill. And I'm going to give you the three that I have listed so you know when you're going to go. And again, I will start my 3-minute clock, and with 15 seconds left, I'll hold it up and then you'll hear the tone. It will be Andrew Mason from the Maine Education Association, followed by Samantha Warren from the University of Maine System, and then Victoria Wallach from the Maine School Management Association. So I would turn it over to Mr. Mason.
Hello, everybody. I apologize for not staring at you. I'm using dual monitors, and the monitor that I can actually read on is not the same one as my laptop. But Senator Carney, Representative Harnett, and other esteemed members of the Committee on Judiciary, my name is Andrew Mason. I'm a resident of Topsham, and I am here on behalf of the Maine Education Association to testify in support of LD 331, an act to protect student privacy. This pandemic has upended the educational system and what has been considered the traditional way of providing education. Educators have stepped up to teach students remotely and finding students in a variety of settings at home, with friends or relatives, in public places, and all of those in varying configurations. Because of this, school districts and educators are delivering and storing more data involving students and families, as well as public employees providing services and instruction on personal devices that could be subject to the definition of public records. This new reality needs to be reflected in the public access laws, shielding data that was never imagined to exist or need protecting prior to the pandemic. Further demonstrating the need for additional protections, there are limitations to what FERPA protects in the realm of security and law enforcement. Many school districts employ security staff to monitor safety and security in and around schools. Some schools employ off-duty police officers as school security officers, while others designate a particular school official to be responsible. Under FERPA, investigative reports and other records created and maintained by law enforcement units are not considered education records subject to FERPA. Accordingly, schools may disclose information from law enforcement records to anyone, including outside law enforcement authorities, without parental consent. Schools are increasingly using security cameras as a tool to monitor and improve student safety. Images of students captured on security videotapes that are maintained by the school's law enforcement unit are not considered education records under FERPA. Only if a school has direct control over a school resource officer's maintenance and use of education records will they be considered a school official and subject to FERPA. The MEA supports LD 331, and we appreciate the sponsor for bringing the bill forward to address this privacy concern. Another bill is forthcoming this session from Representative Jan Dodge from Belfast, a retired teacher, to address privacy and security concerns of educators engaged in remote learning. We look forward to working with the committee and the legislature and make sure educators are protected as best we can when they are engaged in remote learning activities. I believe that this bill, LD 331, will provide uniform protection of educational and school surveillance information that should be shielded from public access. Thank you for your time, and I'm happy to answer any questions.
Thank you very much, Mr. Mason. I think you timed that before you gave it. Very much appreciated. Are there questions for Mr. Mason from members of the committee? The first is from Representative Moriarty.
Thank you, Mr. Chair. Hello, Andrew. It's been a while since we've last seen each other.
Yes, good to see you.
You too. You too.
I'm glad you're still fighting a good fight.
In the absence of the protection that this bill would provide, where do you stand right now? Do you make this information available? Has anyone not yet asked? so that rubber hasn't really hit the road? What's the current status of the law?
My understanding, again, I'm representing the educator side of this. My belief is this was brought forward by the school boards. So it's the public agency that is responsible for storing and releasing the information. And the trick becomes that many educators, from the MEA's perspective, many educators are using personal devices to provide instruction, which could be requested under a Public Access Act. We've seen, as I noted in there, that FERPA doesn't necessarily cover law enforcement units that may be working there unless they're deemed school officials, which some districts may not do. The other concern would be there was a prior discussion among the committee asking questions of the sponsor about, well, what if it's recorded by somebody watching and doing inappropriate things with that. And that's going to be true. And there may be other bills that will address that. But for the purpose of a hypothetical would be a news report comes out or rumors come out into the public suggesting that a teacher said something on a remote class that was inappropriate. The news, there's nothing that would prevent a news agency or the newspaper from going to school district and requesting those as public records, copies of the instruction, so that they can have to disseminate that to them. So it's just something that hasn't been imagined until now, and it hasn't been such an issue that it's required some sort of legal addressing.
So as Representative Poirier suggested, as a member of the school board, the boards are simply dealing with these issues as they arise, and presumably they're making their own decisions independently.
Yes, consistency is important. So, why would a news agency be able to get records that parents under FERPA wouldn't necessarily approve of, because there's some law in the FERPA case law that suggests that crowd shots, like at a football game, that's not going to be a protected document. So depending again on the definition, if you're on a bus, it's possible that could be considered the same as a football field stand. And again, it's trying to limit the public access to it to people that have no legitimate interest. It's also these bad actors. We don't need our public school children having their faces disseminated without apparent approval, which would be under FERPA, or protection, which would be provided under the statute.
Thank you.
Thank you, Representative Moriarty. Are there other questions from committee members for Mr. Mason? Seeing none, almost. Representative Poirier.
Sorry about that. Thank you, Mr. Chair. Mr. Mason, when you're talking about it being brought forth by school boards, have the school boards met together, like superintendents and such, and discuss best practices? Because I know, like my school board, we have a very good policy about things like that, and John Moody's very good as far as sharing best practices, as was Brent Colbury, our previous superintendent. And I know both of them would be very happy to share policies that are working. And I just don't understand why other superintendents wouldn't be trying to gather the policies that are working to see how to resolve it before it even came to this point, if they were having issue with that.
Sure. And my response would be that a policy is good, a law is better. So if if the school board has a policy saying we're not going to release that information, and a news agency wants to fight that in court and say, hey, they're providing this instruction as they would in a classroom, and we have a legitimate right under the statute to that. That's going to trump the policy. So enshrining it or giving it more protection in the law is a stronger protection than just having a policy that can be overridden.
Okay, thank you.
And Representative Poirier, we will be hearing from the Maine School Management Association, so they may address some of your concerns in their testimony.
Thank you.
I did see Representative Hagan's hand went up and then it disappeared. Did you still
Yes,
have a
thank you,
question?
Mr. Chair. I think Mr. Mason answered my question. I know that I'm a teacher and in our district, and I just assumed in all districts, I haven't looked through this bill as carefully as I plan to. You can't give information out. But then again, this is a policy unless the parent signs off on it. And is that an RSU 22 thing, or is there any statute in that area? Do any of you know?
FERPA would be the one that generally protects student information and disclosure, but in this new reality, we're trying to get ahead of the curve in terms of offering these protections when it's possible that there's novel legal arguments that could suggest that a public classroom that anybody can presumably walk into with permission is the same as a teacher delivering it in her or his residence, and all the students are on the screen and can be seen in their various locations.
Thank you. You did answer my question. I appreciate it.
Sure.
Thank you. Representative Poirier, your hand is still up. Did you have an additional question? Okay, thank you. I'll give a little time. If there are other questions for Mr. Mason, and seeing none, I want to thank you for taking the time to share your thoughts with us this afternoon and sharing your testimony with us. And
sure, thank you.
May ask you back when we have a work session if that's something you would be interested
Certainly.
in doing. I will next turn to Samantha Warren from the University of Maine System. Good afternoon, Ms. Warren, and welcome to the Judiciary Committee.
Good afternoon. It's good to be here. Thank you. I wish my counterpart from Maine School Management could go next. I think it would provide maybe a greater continuum. So I'm going to go in a somewhat different direction, but good afternoon, Senator Carney, Representative Harnett, and distinguished members of the committee. I am Sam Warren. I'm Director of Government and Community Relations for the University of Maine System. And I'm here today in an unusual position. Usually I am asking for the university to be relieved of being included in legislation. Today I am actually here, maybe for the first time, asking for clarification that we be added into legislation. As the bill is written, it seems to pertain specifically to elementary and secondary schools and not post-secondary institutions like ours. As you heard from my colleague from the MEA, while FERPA, or the Family Educational Rights and Privacy Act, protects personally identifiable information of students at any institution that receives U.S. Department of Ed funding, which would include our universities, we believe it would be beneficial to explicitly exempt live or recorded courses, which is the focus of my testimony, or recordings from campus grounds in which our students can be seen or heard from FOA as well. Even before the pandemic, more than 1/5 of the credit hours undertaken within our system were delivered using some distance modality. And of course, the percentage of online courses has grown through the pandemic, but will continue to grow in the future as we strive to meet learners where they are. And you've recently heard from the Dean of our law school, Dean Softly, about how Maine Law is, for example, doing much more coursework online into the future. Our faculty determine whether those courses are recorded, how long those recordings are to be saved, and which students can access them. Our instructional designers estimate we currently have tens of thousands of hours of class recordings hosted in protected media galleries managed by our faculty. If these recordings were somehow determined to be public records subject to FOA, we would need to develop a universal retention policy that could be burdensome to faculty and staff and would also be incredibly costly in terms of storage capacity to maintain them in perpetuity. Instead, if this bill were expanded to include the university and enacted, it would both preempt the unreasonable expectation that we somehow alter recordings to remove personally identifiable information such as muting student voices or blurring their faces. And it would also preclude challenges from being asserted against our system when we deny a request due to FERPA protections. I see my time is running up. The last thing I would speak to is my colleague from the MEA mentioned consistency, and that's important here as well. I would remind you that thousands of Maine high school students every year participate in early college classes through the University of Maine system, either online or on campus. And so there really is no distinction in terms of the university and K-12 public schools in terms of protections for students. Happy to answer any of your questions and appreciate your consideration of our request.
Thank you very much, Ms. Warren. Appreciate you taking the time to provide testimony today, and just realized that I had myself muted so you couldn't hear the ringing of the phone. But I will now open it up for questions from committee members. Are there any committee members who have a question for Ms. Warren? Seeing none, thank you again for taking the time to be with us today. And I see you have the flag in dispute in the back hanging up on your wall right now.
It is not a statement on behalf of the university.
I imagine that, but thank you very much for taking the time to be with us. I will now turn it over to Victoria Wallach from the Maine School Management Association. And I note that the next three people we're going to hear from are members of the Right to Know Advisory Committee. So bringing with them a wealth of knowledge. Ms. Wallach, welcome.
Thank you. Senator Carney, Representative Hartnett, and members of the Judiciary Committee. I am Victoria Wallach, Communications and Government Relations Director for Maine School Management Association, testifying on behalf of the legislative committees of the Maine School Boards Association and the Maine School Superintendents Association. I want to thank Representative McCrate for sponsoring this bill. It is near and dear to our hearts, and it has become more so as we've all talked about, now that we're in Zoom land in public education. Our association supported a version of this bill in 2019. It proposed making videos and audio recordings made by security or surveillance cameras on school grounds or in school vehicles exempt from the Freedom of Access law. This amended version adds videos of online classes where students can be identified because of the times we're in right now. We first became concerned about student privacy and school videos when it came to our attention that the Commonwealth Court of Pennsylvania in 2018 allowed a bus surveillance video to be released under the state's right to know law. The court upheld a lower court ruling saying the video did not fall under the Federal Family Education Rights and Privacy Act, FERPA, in protecting standards because it was not a student's academic record. And that was the key finding. And our concern was that as this made its way through, this could become a standard. The video had been requested by a local newspaper because it contained footage of a disciplinary action by a teacher against a student, and other students were clearly identifiable. Given how ubiquitous videotaping has become on buses and in school hallways, the court's decision raised concern that anyone could request school videos under the Freedom of Access law. We can say with certainty that school officials and parents don't want videos of their children being given to strangers. The bill, as I said, took on more urgency this past year when schools turned to Zoom. Google Meet and other platforms to teach classes remotely. Since lessons can be recorded, we are concerned about student privacy if images of students shown or screened on videos are not protected. The use of these technologies is not going to go away. If it's going to do anything, as we've all learned, it's going to expand. They have proven to be invaluable teaching and learning tools and a way to share knowledge. I'm going to wrap out right now. Videos could still be reviewed, and this will answer some questions. Videos could still be reviewed by appropriate parties in an investigation, including the police, or as a result of a parent complaint with a request made to the superintendent or their designee. It certainly could include both sides in a dispute. So if one parent versus another disputed what was happening, attorneys could have access to it. And as I mentioned, yes, police would be involved. But these videos would not be openly available to the general public. We believe this bill protects children and urge you to recommend its passage. And I'll be happy to take any questions.
Thank you very much, Ms. Wallach. Are there questions from the committee? I see one from Senator Lisa Keim.
Thank you, Mr. Chair. Thank you for being here, Ms. Wallach. The question I had, you mentioned the Massachusetts case where the bus recording was released. What negative effect did that have?
I don't know, but I can foresee the negative effects it would have here. If, for example, a person saw the student, if one example we used before was if someone were in a custody battle or there was a protection order and all of a sudden the child's face became public. And we don't know what's in the minds of some people when they're watching kids. I don't mean to be scary, but it is scary. And so that's what we believed. And we don't think it was ever intended that these things, we're in a new era. The protections under FERPA are no longer adequate, but the intent of FERPA is clear. And FERPA is designed to protect students and their records. And in this case, the video is the record. But we're living in a new world right now. I hope that answers the question.
Thank you.
Yep.
Thank you, Senator Keim. Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Ms. Wallach. Just for purposes of clarification, can you tell me, do you know any more specifics regarding the 2018 case? And was that the case that involved the principal's wife that was charged with accosting a student?
I don't believe so, but what I'll do is get you more information for the work session. I have the court documents, so I can provide those.
Thank you. I would appreciate that.
Yes, you're welcome.
Thank you, Representative Libby. Are there additional questions for Ms. Wallach? Seeing none, thank you very much. It was good to see you again today. We will continue to work with you through the work session, and we very much appreciate your taking the time to provide testimony and information today. Thank you.
Thank you.
I am going to check with my committee clerk, but looking through the panelists and the attendees, I am not seeing anybody else who has indicated that they are testifying in support of this bill, LD 331. Am I missing anything?
Why not?
Thank you. I will now turn to, we have two persons who have registered to testify in opposition to LD 331, and they will be taken in this order. The first is Amy Beveridge on behalf of the Maine Association of Broadcasters, and Judith Meyer on behalf of, well, no, she's a publisher, but says she's here on behalf of Camden, but I know that's not the case. But I'll start with Ms. Beveridge.
Thank you, Representative Harnett. Thank you, Senator Carney. As Representative Harnett said, my name is Amy Beveridge. I am representing the Maine Association of Broadcasters. I am the news director of WMTW, and I serve on the Right to Know Advisory Committee. And I'm here to testify against LD 331. I have submitted my comments in the printed record, and I do have some links there if you do want to look at them later on. A special needs child is dragged by the shirt through the hallway of his elementary school. A bus driver drinks a beer wrapped in a paper bag while she's picking up kids. Another is seen swerving and crashing on the side of the road. These are all true events that have happened in other states in recent years, and all were caught on surveillance cameras owned by the school or bus system. All these stories have been broadcast on local and national television. These are events where children were put in danger by the adults who were entrusted by their communities to protect them. If LD 331 were to become law, the negative impact on the public interest would be severe, permitting events like these to be swept under the rug without giving anybody from the public an opportunity to evaluate them and shape their community's responses to them. The key problem with this bill is that, as written, it goes so far in an apparent attempt to protect the privacy of children that it would also have the effect of protecting those adults who act in ways that could put school children in harm's way. These adults are paid with taxpayer funds, and the taxpayers have the right to understand the full scope of an incident where a public employee is alleged to have betrayed the trust put in them by our citizenry. This includes having access to surveillance video of events occurring as part of school, which can be essential to the public's evaluation of such allegations. Of course, we can understand the impulse to take steps to protect the privacy of children, but wholesale withholding of these videos, especially where the content of the video has nothing to do with education, but rather with the betrayal of public trust, is exceedingly overboard and inconsistent with the spirit of public access to government records. Indeed, just as portions of records can be redacted to accommodate personal privacy or other exemptions while ensuring the public remains sufficiently informed about the actions of government, surveillance video can be redacted using commonly available and affordable software. Even simple and easy to use editing software would allow a bus, school operator, or city to blur children's faces or even entire portions of video where appropriate, while leaving enough of a surveillance video for the public to understand the circumstances. Several software suites are available to schools at discounted rates that make them highly affordable. Many schools may already have these software tools available, particularly those with video production classes. The cost of such tools is minimal in comparison with the cost of keeping the public in the dark.
Ms. Beveridge, I see you only have a couple sentences left, so if you could wrap up, we're out of time.
All of the above examples included blurred images of the child or children involved, while properly notifying the public of what their town employees were doing on the job. Let us not protect bad actors in the name of children's privacy when there are easy ways to protect the identity of a child through simple redactions, as with so many other categories of government records.
Thank you very much, Ms. Beveridge. We appreciate you taking the time to provide testimony today, and thank you for providing the links to the incidents that you described in your testimony. I would like to say I know which order the hands went up. I know somebody will correct me if I am wrong, but I am going to go with, Representative Hagan. Representative Hagan.
Okay, thank you very much, Mr. Chair. I was the second hand. I'd be glad to defer if you'd like.
No, it's okay. It's okay. Senator Keim always gets her questions in. It's not a problem.
All right. I think I know the answer, but I just want to make sure that I'm clear. The examples that you're giving are law enforcement issues, which law enforcement would be able to get the video coverage of drunk bus drivers or whatnot. Is this more of an issue that broadcasters would like to be able to also show stories and things like that? And
correct. These examples were broadcast on television. The actual surveillance video themselves were broadcast on television. So those television stations had to request that video separately from the police department.
All right. And
Leslie
can I follow up?
Gave it to them.
So is
Yes,
your
yes.
wish, okay, is your wish to, in opposition of this bill, to make sure that broadcasters across the state of Maine will be able to have access to criminal acts that have happened in classrooms or buses or wherever school children were available?
I believe it should be even before any criminal charges are pressed. If there is a question of something happening, the media should be able to access video to view it ourselves and let the public decide what they see.
Thank you very much.
Thank you, Representative Hagan. Senator Keim. You're muted, Senator Keim.
Thank you, Mr. Chair. Nice to see you again, Ms. Beveridge. I appreciate the press being here and offering the perspective that you do, because it is important that we keep access and accountability, because that's what we need. So what I'm questioning is, we heard testimony that FERPA was developed before this day and age, and that it now doesn't cover enough protections for students. I'm just wondering if you, and I know you serve in the Right to Know Advisory Committee, so I'm sort of asking because I assume maybe this has already been discussed, and is there what your response would be to that?
Are you asking specifically about recording classes in online learning?
Yeah, online learning, or really just kind of what we've heard. Yes, I mean, because specifically we heard the university say, oh, that would be so much if, we would have to hand over all of our classes. My response would be, well, I don't think anybody's going to be asking for all your classes. There's only going to be a request if there's some issue that is being investigated, right? In general, we just don't want to watch all those classes. Even the students that are enrolled half the time don't. But no, just your response to that.
Well, I mean, I could say I certainly could see examples of good news to share where we might show a online class, where I mean, for example, one of our own meteorologists was speaking to a class of first graders that happened to involve my daughter. And we had a picture of her class that we shared online, and he was just talking about how they do the weather. So, it's not just when there are bad people doing bad things. However, the school rules already keep children who have had, their parents say they don't want them on television, that they already have those rules. We respect those, certainly, absolutely. I would say if there's something after the fact, the same technology applies where children's faces can be blurred. I'm not prepared to enter an opinion specifically about online classes. I'm here talking really about surveillance video, but those are my initial thoughts in that category.
Thank you.
Are there additional committee members that have questions for Ms. Beveridge? Seeing none, thank you very much for being here today. Chris, is that your hand?
Well, actually, I was going for the raise hand, but yes, please. May I have a question for Ms. Beveridge? Thank you.
Yes, you may.
Thank you, Mr. Chair. Ms. Beveridge, thank you for testifying. And, full disclosure, 40 years in the classroom. I love the school setting. I appreciate the desire for privacy of children. But I've always championed the press and investigative journalism and all of that. Earlier on, there was a comment by someone testifying about a legitimate interest. in seeking public records. Can you help with that? Is there a need for a legitimate interest, or can you define that for us if you think so?
Are you saying what would the legitimate interest be? I mean, to
Well,
me,
I guess what I'm worried about, I served on Right to Know as well, and I appreciate you spending the time necessary to go through these important issues. But well, I'm not sure where I want to go. I lost my train of thought with what I wanted to say. It's just that oftentimes the privacy versus public access debate is a difficult one. And certainly on Right to Know, we are concerned about people weaponizing information. And so I think that's where the legitimate interest, I'm not interested in data mining companies and satisfying their needs or whatever, but also there could be some with only wanting to look for the sensational and so forth. Is there a way that you would be amenable to moving forward with greater protections, but still protecting the right of free press?
I think the legitimate interest here is that you're talking about employees who are paid by the taxpayers, and the taxpayers have a right to know what happens inside the school buildings they pay for and inside the school buses that they pay for.
Okay, I'll take that. Thanks so much. I appreciate it.
Thank you very much, Representative Babbage. Are there other questions from the committee for Ms. Beveridge? Seeing none, thank you very much again for being here, and I'm sure we will see you as we work this bill through work session. Thank you. The committee appreciates your time and participation. The next person that we have to speak on this bill is the last person I have, although I will open the door when she is done and answered questions from the committee. But I would like to welcome Judy Meyer.
Thank you very much, Senator Carney, Representative Harnett, and members of Judiciary. My name's Judy Meyer, and although I am a member of Right to Know, I'm also a newspaper editor, and I'm representing the Maine Press Association, which is an organization of 43 daily and weekly newspapers in Maine, in opposition to this bill. We recognize that protecting the well-being of children on school buses and school grounds is essential, but as journalists, we believe we can safeguard students without eroding Maine's Freedom of Access Act and the public's right to inspect public records. This bill before you is very similar to LD 639, which was proposed in 2019, that would have shielded video and audio recordings made by security cameras. That bill was the subject of two separate workshops, the first in 2019 and the second in February of 2020. In July of 2020, which was not that long ago, Judiciary reported this ought not to pass. The current proposal goes further than LD 639. It calls for a change in status for all live and recorded classes. We oppose both concepts, and I would like to make 2 points. The first is that citizens must maintain the basic right to inspect publicly funded filming of themselves in a public venue, whether that be a bus, a library, a hallway, or a classroom. Surveillance video serves as a record of how children were treated and sometimes mistreated in the care of adults. And they serve as a record to protect the public interest in protecting our children. By shielding students, we also shield abusers, which does not protect children. Last month in Florida, a county deputy slammed a 16-year-old girl to the ground so hard he knocked her out. In December of 2019, an officer in North Carolina was fired after slamming an 11-year-old into the ground. A month before that, a police officer threw a 15-year-old girl to the ground in Florida. So providing access to police departments is well and good, but when it involves police officers, I'm not sure that goes that far. And not to just pick on police officers, but in November of 2020, a substitute teacher in Florida took a teen to the ground in the hallway. The boy had been asking to use the bathroom and had been ignored. And so he left to go to the bathroom, and the teacher followed him out of the classroom and into the hallway and attacked him. All of those were recorded. All of those were made public. This is about protecting the safety and well-being of a child. The technology, as Amy mentioned, is available to redact identifying information so that we see the video of the action, but not the child. It's easily available, easily implemented. So we're arguing that these surveillance records be maintained as public records. My second point is this bill would make secret all live and recorded classes in which children could be seen or heard. And I appreciate under pandemic conditions, that's increasingly difficult. But also under pandemic conditions, students have heard presentations from astronauts, from politicians talking about climate change, from artists and authors. I spoke to Lewiston High School students earlier this week about journalism. I think the public has, and parents in particular, have a right to know what lessons are being delivered in their classroom. And in-classroom learning is something the media has traditionally been invited to cover that would, under this proposal, end. There are so many great things happening in our schools. And not only is it media's role to report on that, but it's important for our communities to know and understand what students are learning, how they're learning it, and who they are learning it from. The much better solution, and the one used now, is for schools to ask parents to sign media permission slips for their children to be photographed and recorded. If there's no permission slip, the child's identity is shielded. That's happening now and can be accomplished on digital platforms very easily. And that can also be done through direction of the DOE instead of language written into law. The basic tenet holding us from any creeping erosion of Maine's Freedom of Access Act is to maintain the public's right to see, to read, and understand public records, including recordings. That tenet protects all of us, including children. Thank you, and I am happy to answer any questions you may have.
Thank you, Ms. Meyer. Appreciate you taking the time to present information today, and it's nice to see you again.
Nice to see you too.
I don't want to be wrong again. Senator Keim.
You're wrong. I was second.
But I think people are playing with their devices. Representative Evangelos and then Senator Keim.
Thank you, Mr. Chair. And same place, new year, Ms. Meyer. Nice to see you. Just refreshing my memory from where we were 2 years ago and last year. This was the long discussion and debate that you helped us with the Press Association President, J.W. Oliver. Am I remembering this right?
Yes.
Okay, thank you. When I read these news stories or other, media stories in Maine that, sometimes revolve around youngsters, it always seems to me that the press has taken a responsible position to protect the identity of the student. Am I correct in that?
You are correct. Yes.
So given that we're living in this electronic Zoom world, I'm concerned that secrecy seems to be sweeping the nation in a variety of our institutions, law enforcement, jails, and the like, all the way across the gamut of public institutions. And this is coming at the same time that there's this public outcry for transparency, the demands for transparency in the public interest. And I'm deeply concerned about all of the exceptions that have been written into our right to know law here in Maine. I mean, it appears to me like it's Swiss cheese at this point. Would you react to that, please?
I am likewise concerned that we are piling on exceptions to FOA out of fear of what might happen. And there is so much technology available to us right now. It's not like every recording ever made has to be redacted upon creation. School administrators have every opportunity to look at a recording and make sure that children's identity, children who have nothing to do with what the request is about, that their identity is shielded, much like paper records and other digital records are redacted and blurred. This would be no different in that regard. But our argument is that fundamentally they should remain public and be edited accordingly to protect children's identity on a case-by-case basis.
Thank you for that. I know that the Criminal Justice Committee and the Judiciary Committee are both involved in taking up a lot of issues around secrecy and the public's right to know. And you'll certainly be joining us for the spirited discussion in the work session.
I certainly will.
Look forward to seeing you then. Thank you very much. And thanks for your work.
Thank you.
Thank you, Representative Evangelos. Senator Keim.
Thank you, Mr. Chair. Nice to see you, Ms. Meyer. Thank you for the work you do, and just so appreciate you being here and working through this bill with us again. Your viewpoint is so helpful. I was wondering if you would respond to the concern brought to us by the University of Maine that if this bill doesn't pass, that somehow that then means that they, if I understood correctly, that they have to keep in perpetuity all of their classrooms recordings because they could at some point be forward.
I don't see why they would have to. They, the archivist could put together a schedule of retention, just like there's retention schedules for local, municipal, county, and state records. These schedules serve the purpose of letting agencies and schools, frankly, get rid of records when they're no longer needed. And the University of Maine system could do that very thing.
Is there something in statute already that would regulate how long they have to keep a record?
It's not in statute as far as I know. It's on the retention schedules.
So it's just a policy that each organization would make for itself then, is your understanding?
No, it's actually the state archivist sets the schedule, and then towns, counties, and the state must abide by the schedules. So they set how long correspondence has to be kept, for instance, or how long personnel records or accident records, that sort of thing.
So then this law, for your understanding, whether or not this passed, they would have the same requirement to keep this information separate from this law. Like at this point, they're still going to be required to keep information based on the schedule the archivist has set up for them. And if this law passes, then somehow I guess they're thinking that they would be able to get rid of it. Is that the difference that you're seeing here?
I wouldn't see a difference. I would think the archivist schedule would apply no matter what. I think I appreciate the fact that there's just so many more recordings being made every minute of every day. So there is a storage issue, but there will be no requirement for them to keep these digital records for all time.
Right. And that was kind of what I was getting at too, is that I also understand that now we're creating so many more records, and I don't want, I know that's problematic. So I think that it's something worthy for us to consider, but thank you for that. I appreciate it.
I do acknowledge the concern, but they could go to the archivist and make the pitch that they only need to be kept for the current school year, which would resolve a lot of storage issues. Could be that short.
Right. Okay. Good. And maybe as a note for the work session, we should have some sort of discussion around what the archivist's role is in all of this. I think that would be helpful. Thank you.
You're welcome.
Thank you, Senator Keim. Representative Hagan.
Thank you again, Mr. Chair. And thank you, Ms. Meyer. I'm going to throw you not a softball, a Nerf ball, the easiest, simplest question in the history of the world.
Oh, good.
629, was that the number?
639.
639. Thank you very much. I'm done.
Thank you, Representative Hagan. Are there other committee members with questions for Ms. Meyer?
Yes, Mr. Chair. Let me.
You're all set.
I don't understand why. Okay, let's. Thank you very much, Mr. Chairman. Yes, Judy, I can't let you get away. Good to see you again, Ms. Meyer. And I mean, the idea of public records and public access is that a reason need not be required in order to have that information. Isn't that right?
That's right.
So when we're talking about video in a public building that involves minors, is there a threshold at which that you would be comfortable setting in order for information to be shared?
It's certainly worth discussing. I don't know what that threshold might be, but I'll give you a good example of how video actually helped in the pandemic. I had a mom from the Augusta area reach out and say she was disapproving of the teacher's lessons on MLK and Black Lives Matter, and she thought that we ought to do a story to prove to the world that this teacher was too biased in her lessons to her children, to her students. I looked at some of the video that the teacher had, posted herself, but some other video that the mom had provided to me. I didn't ask the school for it. And there was no story there. That teacher was absolutely on point, as neutral as she could possibly be. And, without that video, the mom could have made a very strong case that the teacher was behaving inappropriately in the classroom, when in fact, she was not. So I don't know what threshold would protect that instance, because we can't predict why we might want to see the video.
Thank you for the example. Appreciate it.
Thank you, Representative Babbage. Are there additional questions for Ms. Meyer? Ms. Meyer, I have one, and I will admit that it's not totally related to the LD in front of us, but can you tell me what happened to Mark Trail? and when he is coming back?
I'm awfully sorry, but he has gone off into the sunset.
Okay. Thank you.
You're welcome.
With that, thank you very much for being here, providing information and answering that question for me. Those are all of the persons that I have been notified wanted to speak to this bill. I would ask the committee clerk to just confirm that there is nobody else that we need to hear from.
You are correct, Mr. Chair.
Thank you. And with that, Representative Hagan.
I apologize for this late minute thing, and thank you, Mr. Chair. So I just want to make sure I got it right, that if I have a feel-good story at school with my 8th grade social studies class, this bill eliminates the ability of broadcasters to come in and do a feel-good story on the news, on the nightly news. Am I on?
You're on. I'm not. Who are you posing the question to? Are you posing the question to Ms. Meyer?
Yes, to Ms. Meyer. Yeah, I thought I interpreted earlier, and I just want to make sure before we go away that you were saying that, let's say I do a really cool thing where I have Representative Babbage as a guest speaker on politics, arguing with Representative Poirier, and it's kind of a neat little thing, and they want to interview the kids and stuff. That would be illegal.
That's my understanding, all live and recorded classes.
Okay, thank you.
I would not do that, Representative Hagan.
Thank you, Representative Hagan and Representative Babbage. Seeing no other hands and realizing that this has been an incredibly long day, and I thank the committee members for their attention and for everybody who participated throughout this process. I will now close the public hearing on LD 331, an act to protect student privacy. Thank you for all who participated. I would entertain a motion to adjourn. Oh, this is an easy one, folks. Somebody put your hand up.
So moved.
Representative Libby, Representative Poirier, the entire committee. This meeting is adjourned. I will see everybody tomorrow morning. Thank you.